This meeting is now resumed. Members, please rise if you're able to join me in observing a moment of silence in memory of Mar Gillespie. Thank you. Members, we will now review and confirm the order paper. Once the order paper has been approved by council, any change will need a 2/3 vote. The city clerk has posted today's order paper online with agenda item RM 30.7, review of the order paper. There are 51 items left on the agenda, including 29 member motions. Council has timed item CC 30.5, headed Proposal Bylaw Amendment to provide access to social infrastructure as the first item of business this morning. I will now take the release of holds. The clerk will open the speakers list in CMP, and you can place your name on the list if you have an item to release. Are there any further changes to today's order paper, such as request to time items? So if there's any quick releases, if you can please put your name on the list, please. Councillor Perks.
Yes, Speaker, I'm just pulling the item number up. It's the planning item related to employment lands.
PH 21.1.
I'd like to hold that.
Oh, I'm sorry. I checked with 6 other councillors. I didn't know Councillor Pasternak had an issue. Okay.
Okay. Councillor Myers.
Hi, can you hear me?
Yes, I can hear you.
I'd like to release SD 21.1, which was a deferred item, and move that's been pre-circulated, please.
That you move? I didn't hear you. You move what?
The amendments that have been pre-circulated.
Oh, okay. So let's put the amendment on the screen then. This is SC 21.1, a deferred item for 900 Middlefield Road, official plan amendment. Okay. There's 2 amendments. One is on the screen. Okay, and the second one?
There's another one that should be there as well.
Yeah, we're just putting the other one up. Okay, the second one is on the screen as well?
Yes.
Okay, so you'd like to release the item with the 2 amendments, correct? Okay, so we'll put the first amendment up there, 1A, on favor, show of hands, carried. 1B. There it is on the screen, on favor. Okay, thank you.
And then I also have one more.
Pardon?
I have one more, PH. Oh no, that's being held by Council first. Okay, that's fine. Thank you.
Okay. Councillor Morley.
Thanks, Madam Speaker. Good morning, everyone. I can release IE 21.2. I do just have a motion that isn't confidential, so I wanted to draw that to my colleagues' attention, and maybe I can give it a moment for them to review and release at the next opportunity. But it has been advance circulated, and I've worked with staff on the motion.
So on IE 21.2, can you just...
It's recommended strategies to address prematurely failing water meter transmission units.
Okay, so you have an amendment?
Yes, but it's confidential, so it's attached. It's been advance circulated. I just wanted to advise my colleagues in case anyone
Okay,
wants to go.
so there has been a confidential item that was previously circulated. So Councillor Morley would like to move that. Okay, on favor? Oh, hold on. Councillor Holiday.
So, Speaker, if I may suggest we hold it till the next interval so we can digest what the motion is.
Okay, thank you.
Happy to do that. Thanks, Madam
Okay.
Speaker. I'll encourage my colleagues to take a peek.
Okay, thank you. All right. Okay, Councillor Fletcher.
Sorry. It is NC 16.1, appointment of public member, Toronto Hydro Board. I'd just like to refer that back to the corporate nominating, please. Thank you.
So you're releasing NC?
No, I'm referring it back to.
Oh, you're referring it back, okay.
Thank you.
The motion is on the screen. Councillor Fletcher's referring it back. On favor? Carried. Thank you. Councillor Ainsley.
Thank you, Madam Speaker. I need a bit of clarity from clerks first. On DM 30.1, I was informed by staff yesterday that the motion I moved, the recommendation from the original report had to be deleted and something was being sent to clerks. And I just wanted to see if I could take care of it now.
I'm sorry, I didn't hear the item number.
DM 30.1, Scarborough Bluffs West Project Environmental Assessment Agreement. There was a recommendation in the report and we're ready? Okay.
Okay. Okay, so we'll display that on the screen. There it is. By Councillor Ainsley. On favor? Carried. And then on the amendment. There's the amendment on the screen.
Just the actual recommendation.
On favor? Carried.
Thank you.
Item is amended. On favor? Carried. Thank you. Councillor Bravo.
Thank you, Speaker. I'd like to release TE 22.3 72 Perth Avenue zoning bylaw amendment application decision report approval, and it is with a motion. It's to move the staff recommendations. This came without recommendations with an amendment that has been proposed by staff. If we could share that, please.
You can put the amendment on the screen. That's T 22.3. There it is on the screen. It's here without a recommendation, so that's the amendment. On favor? Carried. Thank you. Okay, all those in favor of adopting the order paper as amended? Carried. Members, I have reviewed some urgent motions without notice to be added to the agenda if we have 18 members. Do we have 18 members? Councillor Burnside? Thank you. We just need 18 members to introduce members' motions. If you don't mind taking your seat. Okay. Who's first? Councillor Ainsley.
I'm sorry, I'm sitting down.
Okay, it's you have a member's motion you want to introduce. We'll put it on the screen.
Thank you, Madam Chair. I'd like to introduce the reason for urgent members' motion without notice. The correction is urgent to enable Toronto Water to proceed with a contract to support critical building automation system maintenance at Ashbridges Bay Treatment Plant to ensure there's no disruption to city-mandated water services.
Okay, on favor? Carried. Councillor Moyes.
Thank you, Madam Speaker. This urgent motion is for the Allen Gardens Palm House to allow Friends of Allen Gardens to help manage the Palm House.
Okay, on favor? Carried. Councillor Moyes, you have another.
Do I?
Yeah.
Yes.
Committee of Adjustment.
Yes, Section 37 funds needs to be released to complete Committee of Adjustments hearing by June 11th.
On favor? Carried. Councillor Chernes Lynn.
Sorry.
Councillor, can you please stand?
Thank you. This is an urgent motion to go to TLAB. It's a timing issue, and it is the city solicitor requires instructions to obtain party status.
On favor? Carried. Deputy Mayor Malik.
Thank you very much. I have a motion to authorize the release of Section 42 for improvements to the Ryerson Community School playground. And the urgency for this motion is that it requires the funds to be released to coordinate with the contractor's scope of work.
Thank you. On favor? We have another one for you.
And I have this urgent motion, the purchase order amendment on a contract for the construction services of the new streetcar tracks on Adelaide. And I'm bringing this forward on the request of staff so that it can align with the construction work currently taking place.
On favor? Carried. Mayor Chow.
The motion regarding streetcars being stuck on King Church construction. It's urgent because people are taking a long time to get anywhere. Construction is on right.
Okay, thank you. On favor? Carried. Councillor Fletcher, you have two.
Yes, thank you very much, Speaker. I have two urgent ones. One is about tariffs, the other is a TLAB. First one is a request for city solicitor to attend the TLAB.
Okay, on favor? Carried. Second one.
Is a impact of tariffs on the film industry. City.
On favor? Carried. That it? That's it? Okay. Oh, there's another one for Councillor Fletcher. Oh, you put the wrong one. Okay, it's okay. Thank you. Is that it? That's it. Okay. Members, we will now consider item CC 30.5. So if members have questions, if they can please put their name on the screen. Councillor Pasternak, question.
Yeah, thank you, Madam Speaker, through you to staff. So when we gave city staff, I guess the city manager and chief solicitor direction, we asked that a constitutional legal expert opinion on charter rights and a charter filter be part of this process. Was that done?
Through you, Madam Speaker, City Council has that as an attachment to my report, confidential attachment.
And in your opinion, the bylaws before us are charter compliant?
If Council wishes for me to go into detail about that, I would recommend going in camera. What I can say is with the instructions we have done our very best to come back with a bylaw that could be defended, yes.
Okay, do the bylaws ban protests?
The proposed bylaw would not be a complete ban on protest activity. No, it would not.
Do they ban free speech?
It would also not create a complete ban on free speech. It would create a limit.
And do the...
So a ban, the courts look at a ban and a limit differently, yes.
Okay, does it stop labor union picketing?
No.
Okay. These bylaws in general, or more specifically, are to protect the rights of people wanting to access vulnerable institutions, places of worship, daycares, other cultural institutions. Do you think this does that?
The goal of the bylaw is evident in its title. Actually, it's a safe access bylaw.
Okay. And can we agree that actually bubble zones or variations of have been in Canada for years and years in abortion clinics, hospitals, and more municipalities are adopting them?
With respect to years and years, the abortion clinic bubble zones are the clearest example of a long-standing access zone. There also was an access zone law put in place during the pandemic to protect access to vaccination at healthcare facilities where there were demonstrations, anti-vaccination demonstrations, and several municipalities have created bubble zone bylaws in the last couple of years.
So I've looked at a number of court cases, and some of these, particularly around abortion clinics, have been challenged in court. But every court case I look at, they uphold the legality of those bubble zones. Is that correct? And the furthest it ever got was the BC Court of Appeal, where they upheld the legality of bubble zones. Can we?
Yeah, there's not a lot of case law on bubble zones. However, the BC Court of Appeal did uphold the abortion access law in BC.
So has the Supreme Court of Canada ever ruled that bubble zones are unconstitutional?
The Supreme Court of Canada has never ruled on bubble zones.
To the specifics of the item before us, Section D allows peaceful gatherings, protests, or demonstrations within the bubble zone, exclusive of some conditions previously. Do you think that creates any kind of confusion when it comes to enforcement on the ground? And if we remove it, does it have a ripple effect?
If it is removed, I would argue that that is implicit. However, it has been placed there intentionally, precisely because the purpose of the bylaw is to protect safe access to vulnerable social institutions. So it is quite narrow, not intended to prohibit all conduct in the zone.
I'd like to use my last minute to show a very short video and then ask two questions regarding it, if that can be done.
Yes, that's fine.
We can hold my time until the video's up. What you're looking at, what you'll be seeing in a minute, is protesters trying to storm the doors of a synagogue on July 31st, 2024, when 1,500 people were trying to assemble peacefully. And then I have two questions for the city solicitor. Oh, here we go. So this is at Pride of Israel. Councillor Cheng, Mayor Chow, and I were inside along with 15 other people. Very short video. This is the doorway of the synagogue where protesters were trying to get in and wrestling with police. So I have two questions. I guess let's let it run. Of course, I wouldn't call this peaceful assembly, but let's let it run its course. So two questions for the city solicitor. One is, there's 1,500 people inside. Do they have charter rights to peaceful gathering?
Sure, everyone has that charter right. It's protected for all people, yes.
Thanks. My second question is, if bubble zone bylaws were in place, would this mayhem and chaos and threat be mitigated?
It's difficult for me to say without having been there to appreciate the full context, and I hesitate to comment, to put myself in the shoes of an enforcement officer, for example. But I would say that a bubble zone could create a deterrent to certain activity that might violate the bubble zone rules itself.
Thank you. That was your last question. Mr. Moy's questions.
Thank you, Madam Speaker, and through you. Last year, Toronto Police spent an additional $20 million more than the budget they were allocated to assist and to deal with some of the protests that happened across the city. In your opinion, have they done their jobs in doing that?
Speaker, that's not a fair question for us to answer. The police have consistently reported through the Toronto Police Services Board their actions.
Sorry, that question should be asked to the police, not to the city manager.
Well,
Yeah, so go ahead, continue.
have they been given the resources that they need to do their jobs? Is that also a question for you, for the police?
Speaker, no, again, the resourcing of the police services, and how they would allocate that would be again through the Police Services Board.
Okay. My final question is that the report that staff prepared states that the federal government is actually looking into bringing a bill forth in relation to access to places of worship, schools, and community centers. If the federal government's actually doing that work, why do we need to do it here at the city level and not wait for that report or that bill to be presented and that it impacts the entire country rather than this piecemeal approach we seem to be taking here in the city?
So, Speaker, my answer to that would be that's now in the hands of council. If they choose to wish to see what other orders of government are going to come forward with in policy, that's a decision that this body would make. Our direction from staff was to bring this forward. Actually, we're a couple of months outside of the time frame that was originally given to us. But again, council would have that ability today to say we want to wait on a policy front.
Okay, those are my questions. Thank you.
Thank you. Councillor Myers.
Thank you, Speaker, through you. So I have a question regarding the case law result that was relied on, particularly the abortion clinics in British Columbia. So I'm reading from one of the cases, R.V. Lewis, and just to read a section, it says, notwithstanding the injunction obtained by Every Woman's Health Center, large-scale protests continued until July 1989. In all, there were 26 blockades outside the clinic. Until 1990, there was protest activity on 30%, 40% of the days. There were numerous instances of locks being glued and wired shut, use of hardwire, and use of locks and chains, all of which made entry to the clinic difficult. Is it fair to say that there had been numerous instances of injunctions granted by courts based on evidence before this law was debated at the BC Court of Appeal?
There were injunctions granted for bubble zone perimeters for abortion clinics prior to the challenge to the British Columbia Court of Appeal.
And in order to get those injunctions, evidence was presented, such as evidence that I just have read, about the type of protests the abortion clinics were undergoing, correct? And the safety that their members were feeling. They were being followed for their cars, they were being videotaped, they were being harassed at their home, correct?
Speaking in general, again, not having an exhaustive memory of all of those cases and injunctions, obviously the litigants would have provided evidence of the harm and the need for the injunction as part of the injunction proceedings.
So under the bylaw that we're debating today, what evidence is required to be presented before an applicant can make an application for a home?
Madam Speaker, we're having difficulty hearing the councillor. We didn't hear that question.
Yeah, can you repeat that question? It's hard when you're virtual. We don't hear you.
Sorry, is this better?
Yeah, it's a little better.
So I just wanted to know what evidence is being presented in order to get a bubble zone application through by an applicant.
The applicant would be required, if under the bylaw that has been proposed, to submit an attestation.
So there is no evidence required to be submitted, correct? Simply an attestation.
The individual could only be the owner or operator of a social, the vulnerable social infrastructure, and would be required to indicate a number of things. There are criteria, one being that there has been demonstration activity in the last, I believe, 90 days. Is that correct? 90 days? And,
sorry, just to be clear, I just want to get the point across. They wouldn't be required to submit, for example, video evidence, evidence of calls to police, or maybe evidence of damage to property.
no, this is quite different from an injunction. The other questions were about the injunction proceedings, which were court proceedings, which do require the production of evidence.
Correct. Okay, so no evidence is being required in order to get the attestation through and to get the bubble zone implemented, correct?
No, not in the way a court requires evidence, no.
So I guess my question is, how is this going to survive a constitutional review? If in the cases that we're relying in, there had been a long history of evidence being gathered and shown that these protesters were going above and beyond mere protest in terms of how they were attacking the institution itself and the people that worked at the institution.
Madam Speaker, just to be clear, should the city find itself in court defending a bylaw, evidence would be produced. But beyond that, I would recommend that should Council wish a more detailed response, that Council go into closed session.
Thank you. Well, one final question. What training or background does the general manager of transportation have in ascertaining the validity of an attestation?
The attestation is an administrative process.
Okay,
Thank you. Councillor Bradford, questions?
Thanks, Madam Speaker. Through you, and this is, I think, to our city solicitor and city manager. The report gives 3 examples of municipal bylaws that would prohibit certain protests, bubble zone bylaws. I'm just wondering, what is the size or the distance of those bubble zones that you reviewed? It's a straightforward question.
They vary. In general, to 50 meters to 100 meters, somewhere in that range is what other municipalities have produced.
So there's a precedent for 50 meters. There's a precedent for 100 meters. Is there a precedent for 20 meters?
Yes, the precedent's out of British Columbia, and it has to do with safe access to schools.
In Toronto, we've seen a lot of protests. Some of them have been violent. There's been a lot of intimidation. There's been a lot of harassment. We've seen hate crimes and hate incidents go through the roof, triple-digit increases over the past 24 months. Municipalities like Vaughan and Brampton moved on bubble zone legislation much sooner, much faster than the City of Toronto as we try and get it across the finish line today. And municipalities like Vaughan and Brampton seen more protests or less protests than the City of Toronto?
I don't have that data as speaker in terms of the volume of it. We've produced the information that we have from Toronto Police Service, but I haven't looked at the volume of protests that have happened in other jurisdictions.
Okay, I'm surprised nobody here has looked at that as part of the report. I want to ask about the abortion clinic bubble zones. When was that legislation passed by the Ontario government?
2017.
Okay. And what is this extent in terms of size of the bubble zones around abortion clinics, protecting women's access to reproductive health? It's a range, I think.
So it's 150 meters to the clinics, and then there's another access zone for access areas around the clinicians' homes.
Okay. What is that?
I believe it's 100 meters. I'll double check.
Okay, we got to know this stuff. Transportation services, Barbara Gray, questions for you. How wide is Shepherd Avenue on average? Maybe that's unfair. Like, I have it as 36 meters.
If you've looked that up recently, Councillor, then I believe
I Googled it. I got
36 meters.
Let's, what about Warden? I have Warden in excess of 30 meters. Warden jogs a bit more. It's not as consistent as Shepherd, but 30 meters on Warden. Would you sort of agree with that?
Speaker, yeah, I would agree with that. That's probably about right.
Okay, so would you agree then that some of our streets here in the city of Toronto actually have a right-of-way width that is in fact wider than 20 meters?
The right-of-way widths, certainly. The right-of-way
They
widths
vary.
even in an individual quarter, even in an individual block.
Some
but
are north
certainly.
of 20 meters.
Correct.
Okay, so the proposal in front of us today of 20 meters wouldn't even put these protests on the other side of the street in a case like Shepherd. It puts you on the island in the middle.
Speaker, according to what the councillor has defined in terms of widths and dimensions, I would agree.
Okay. I'm going to kind of start to wrap up here. The proposed approach requires applicants to experience an incident in the last 90 days before they're eligible to request an access area. Is that correct?
Yes, it is.
Okay. The report also says, quote, to promote proactive and voluntary compliance. Would you describe waiting for an incident to happen and then acting as proactive, or is that reactionary?
So providing evidence in the last 90 days is a reaction to what is occurring, not, and that is why, but that's the feedback we received through the consultation process, is that proactivity was not generally what we heard from the folks that participated in the public consultations.
Okay. I see my time's wrapping up here, but I found it a bit curious that the impacts on faith-based communities like the Muslim community, like the Jewish community, are not mentioned in the equity impact statement on the report. So does the City of Toronto consider the Jewish community to be an equity deserving group?
That was your last question.
So through the Speaker, the equity deserving impact statement is intended to provide information that is enabling staff to determine potential impacts on groups such as Indigenous, Black, and equity deserving groups. Those groups have been identified through the Data for Equity strategy as being those that are most likely to have disproportional unrepresentation in society based on several factors, and that is what has been used in this instance.
Okay. Councillor Bradford, that was your last question.
Madam Speaker.
Yeah.
Madam Speaker, I can correct our response on the abortion clinic bubbles now. We've just
Okay, go
confirmed
ahead.
the bubble around the clinics is 50 meters and around the service providers' homes is 150 meters.
Okay, thank you. Councillor Bravo, questions.
Thank you, Speaker, and I'll note the extra minute that you provided. I hope you'll be equally available to everyone today.
Well, that was because...
first of all, I want
Councillor
to...
Bravo,
please,
Councillor
I want
Bravo,
to,
hold on. Councillor Bravo, that was
can you
because...
hold my time?
Sorry, that was because staff was taking their time answering the question.
I understand.
So thank you.
An extra
Okay,
minute.
go ahead.
Thank
Go
you.
ahead.
So, first of all, I want to ask the city manager, were you directed to come up with, to first of all study whether this was a useful thing to do? Were you ever directed to do an analysis of why this is needed? Or were you in fact directed to report back here with a bylaw?
The direction was to bring back a bylaw. Further clarification was provided in the December council meeting to that recommendation to involve a public consultation process.
Right. And the direction that you were provided was to bring back a bylaw that would not violate the charter, correct?
Correct, and in addition, provide some analysis of it from a charter perspective.
Okay, so we don't have any kind of answer around whether there's a sufficiency here. There's no test that says that in answer to my administrative inquiry, I asked, how did you analyze whether existing criminal code, municipal bylaws, and use of trespass notices is insufficient to achieve what we want? The answer says, here's the criminal code, here's the bylaws, here's trespass notice, but there's no evidence that there was any assessment that these things are not enough to keep people safe, correct?
So that full assessment as you described it, not in there. Our public consultation, which is what drove us to what is before you today, indicated in the feedback that by and large there are not access issues across all of these institutions in the City of Toronto. However, a strong minority did give us specific examples of where access is a barrier. They have tried other solutions to reduce that access. They have been unsuccessful and feel that this might be a helpful tool along that way.
Well, however, we do not have the benefit, as we're discussing a bylaw, to limit the charter-protected right of freedom of expression and assembly. It is not accompanied by any substantiation from any evidence that is beyond what people said in a consultation. Isn't it correct also that the majority of people that responded to the consultation saw protest as a social good and a value in Canadian society that is protected constitutionally?
Absolutely, and that's not in conflict with what's before you, but absolutely, that was the feedback we received.
Okay, so the video that was displayed by my colleague, Councillor Pasternak, that was a situation that wasn't, there was no worship services. That was an event that had a political character where there was real estate discussions, and that some of the protesters were also of the same faith. Is that not correct?
Yeah.
Would that still
Point of order, Madam Speaker. That is
hold my time?
an incorrect description of what that event was.
Can you hold my time? Thanks.
No, she's misleading the council.
I held your
Councillor
time,
Perks.
Councillor Bravo.
Why don't you let the speaker rule?
I won't. I'll move on. You don't have to answer that. If the institution in question is being used for a political purpose or a purpose not affiliated with a religious use, would that be prevented? Is that preventable here?
So our bylaw is clear that it applies for the primary use of that institution. So a good example is a rental of a school facility, for instance, is not the primary use of a school. So that would be a situation where the bylaw does not apply.
Thanks. I'm going to ask the city solicitor. You've already answered that you believe that what is before us is defensible, but it is expected, as has been indicated by multiple letters. In fact, I would love if somebody told me how many organizations have written to the City of Toronto indicating that should this bylaw be adopted and be put into use, there will be a charter challenge. But what we have before us is already going to be challenged. If any additional changes to restrict further will be in violation of the charter. Is that not right?
Through you, Madam Speaker, it's difficult to predict the outcome of court proceedings. We have given our best advice here, and minimal impairment is important. Anything that expands the scope would reduce the ability to defend.
Yeah.
But frankly, I'm not prepared to say more than that. I won't say that anything expanding the scope would fail either. I can't say that.
Well, that would be speculative. However, what we have before us is a bylaw that is already going to be challenged, we know, and that on top of that, there is a discussion that's going to be here today about expanding the scope further to limit speech, which we can certainly expect will be challenged in court. Thank you.
Thank you. Yes, just one moment, Councillor Holyday. Point of privilege, Councillor Holyday.
Yes, Speaker, when the solicitor was providing a supplemental answer, there was a noise, and I didn't catch the second number, and I just wondered if the solicitor could repeat those two numbers. One was 50 meters, and the second one?
50 meters around the clinics and 150 around the service providers' homes.
Thank you. I appreciate that, Speaker.
Thank you. Councillor Fletcher, questions?
Oh, I'm sorry. That was on for a different, I may have questions in camera, Speaker.
Deputy Mayor Malik, questions?
Thank you very much. My first question is for Toronto Police Services. Are they present? Okay, thank you very much. In the report, staff cite the various criminal code descriptions of conduct that constitutes criminal offenses. What does this bylaw do that the criminal code doesn't?
So I would say that it approaches the space in between where items are not covered by the criminal code specifically, and provides another avenue for us to have conversation and enforcement to ensure people have access. So there are, the criminal code also, the standard is quite high, reasonable doubt in terms of getting a conviction. The same applies for a bylaw, but this just finds the space in between the bylaw, provincial offenses and the criminal code that allows us to engage in those conversations and that enforcement.
So without this, you would not have that?
I think it would just look different. In terms of the criminal code, a criminal offense is quite high and quite severe. When you compare that with a provincial offense or a bylaw, there's a bit of a scale there. So we wouldn't necessarily want to jump directly to a criminal offense depending on what the situation that unfolded before us. So it gives us options to escalate enforcement if we needed to.
When we previously debated this issue, it was quite clear from Toronto Police Services that the intent of what you just described was already in the power and scope of Toronto Police Services, supported by the criminal code. Is that correct?
Through you, Chair, yes, I think that there is some overlap with the criminal code, but again, if we're talking about enforcement and taking an enforcement approach to some of these things, we don't want to just jump to the highest level of enforcement. We want to be able to have a staged walk into enforcement. So that starts with conversations, that starts with education, then it can move to bylaw, it can move to a provincial offense, and then criminal code being the absolute top tier of enforcement.
Okay, thank you. My next question is for the city manager. How will the city be sharing that social infrastructure sites have access areas in place so that the public knows?
How will we? So if access has been in the past 90 days, have been an issue around access, and that attestation comes in, there will be signage placed at those facilities, and then the bylaw is enforced in those facilities. So we are not taking a everywhere approach. That's not the recommendation that's before you. This would be applied in specific circumstances where it's required.
My next set of questions is for municipal licensing and standards. Can you share the number of bylaw officers currently employed by the City of Toronto? Just the number.
It's approximately 300. There are 69 that deal with parks and open spaces.
And can you please share the range of issues that bylaw enforcement officers currently patrol for and investigate? We just had a very lengthy debate yesterday that shed some light on that, but I'd like to hear that from you.
Municipal licensing and standards bylaw enforcement officers enforce over 45 different bylaws, all of which are unique and diverse.
Okay. And what are the current timeframes for bylaw enforcement to investigate the bylaws currently on the books at the City of Toronto? I have a few ranges that you've heard a lot from us about, some of the most basic things like dogs off leash to much more important issues that are widespread across the city.
Our service standards, which are approved by council, range from 24 hours to 10 days and various ones in between. It's important to note that we are not immediate responders. We are not emergency responders. We are not approved or resourced to respond to a call that comes in at 3 o'clock to be there at 3:15, as an example.
Okay, so how would bylaw officers be expected to respond to calls for enforcement?
So this is something that we are working on. These bylaw enforcement officers could either be in transportation services or in municipal licensing and standards. That is a body of work that we need to do to understand how we would be responding. We would be, again, it would be an education first, and based on the size of the protest, we would definitely call in our colleagues in Toronto Police Services. If 2 bylaw officers went into a crowd of 300 or 100, they would not be effective. It's important that we partner with the police for
public safety and safety of our officers.
Thank you.
Thank you. Councillor Fletcher. Just one sec. Okay, sorry, I couldn't get the
That's all right.
screen
Thank you.
working here. Okay.
Thank you. I apologize. I didn't realize we had Toronto Police here because didn't have your white uniform on, so I got confused. But I did want to ask you a couple of questions, please. And obviously, you've had some conversations about this since the last meeting because I don't think either of you were here, but it was really clear that there have been only 2 charges laid under hate crimes, as I understand it. Were there more charges since that time when you were here, I think 2 meetings ago?
So you're asking me how many hate crime charges have been laid since somebody was here last?
Yes, whoever that was.
Oh, I wasn't prepared to answer a hate crime data question,
Oh,
but
okay.
I can certainly find out, and I'm undercover today.
Yeah, let me say you're definitely undercover. I thought you were city staff, so now I know who you are. Thank you. So obviously you've considered this, and I'm wondering, are there budget implications for the Toronto Police in the number of bubble zones that would potentially be created? And how have you had that conversation? At what level? Is that a board conversation? Is that a command conversation?
Yeah, through your chair, I think that you've hit the nail on the head. It is certainly a command board conversation, but it's also a conversation that has to be informed by data on what we're actually seeing as this bylaw is operationalized. So
Right.
it's hard to predict where that pressure would come from.
But you are considering it may have implications, correct?
Yes, of course.
And the same with bylaw enforcement for Mr. Grant. Are you considering that may have budget applications?
Speaker, should the council make a decision to move this bylaw forward, we would go into our operational planning stage and we would look at how we would actually do that enforcement.
Right.
And we'd be monitoring that as that moved forward. And if there was an impact on resources or budget, we would have to report back on that.
So you're not saying there's no impact. You're saying you have to look at that because there might be. Am I right?
You are correct.
Thank you. And then there used to be, to Mr. Conforti, when we were looking at different things, we used to get a sheet. And Councillor Thompson, we remember that, Councillor Carroll, of all the decisions we might make. We got a yellow paper, because we don't do paper, but on it were all the financial considerations for decision making. And I don't think that we have that in front of us right now, do we?
To the speaker, so in terms of staff reports, we'll identify in the financial impact section. I believe the sheet you're referring to might be as it relates to notice of motions, if I'm correct,
No.
and that is still produced.
No, everything.
Something separate?
Sorry, you
not
weren't in that
familiar.
role, so you don't have that, and it's not the same thing. Thank you. I'm just wondering, and I don't know who can answer this, but my recollection is that there was one abortion clinic in the city of Toronto, Dr. Morgenthaler. Is that correct? One abortion clinic, maybe 2 or 3. Who wants to answer that? Number of abortion clinics, possibly 3. Oh, 2, yes, 2, one on Parliament and one on Harvard, correct? That had a bubble zone.
So I can confirm there are 7 prescribed abortion clinic locations in the province, and I believe there are...
Across the province, did you say?
Correct.
I'm talking about Toronto, where we have a bubble zone in
And I'm
our
just doing the
Toronto.
math.
Madam Speaker, we can clarify
There are-
how
Thank
many
you.
are in
That's
Toronto.
okay, I'm going into numbers
There
now.
are 5.
We're
There are
doing
5 in
data.
Toronto.
Number of hospitals in the city of Toronto, I've counted about 10. Hospital Row, Scarborough 2, Etobicoke 2, North York 1. Is that 10 or 12 hospitals in general? I'm going to go 10 or 12. Would you agree that it's not 50 or 60, correct? Number of schools in the city of Toronto. I think there's probably about 600 schools in the city of Toronto. Number of churches,
Speaker,
synagogues, mosques in the city of Toronto. Yes? Oh, you might know that.
yes, Speaker. So we did an analysis through open data, and there's in total across the 3 prescribed social infrastructures that are being proposed, approximately 3,000 locations in total across places of worship, schools, and childcare centers.
3,000. So I actually am going to want to talk about money and resources and people. So I think we may have to go in camera on this item to dig into that a tiny bit more. 3,000 versus probably 25 that we currently have, and how that would work. So I don't know, Madam Solicitor, if that's something that we can do, but I'm asking, Speaker, I'm asking that we go in camera on this issue.
That was your last question,
Madam
but
Speaker, those do sound
just
like
I
public
don't
questions.
know if that question needs to be going camera. Okay, just one sec, Councillor Fletcher. Yeah, the clerk will speak to you, okay, Councillor Fletcher? Councillor Perks.
Thank you. My first question is to the city solicitor. So you've provided councillors with an in-camera report on the reasoning and the charter issues. Would it harm the city's ability to defend a bylaw in any way if we made that public?
So I've thought about this, and in my view, if council adopts the proposed bylaw in its current form, I would not be concerned about risks in any litigation should my advice become public.
Okay. And if we're asked to defend a bylaw, you're going to have to provide your reasoning anyway, right? And that's
Yes,
on public.
absolutely.
Yeah.
Absolutely.
Okay, thank you. To the Toronto Police Service, we debated this issue in December, and there was a representative from the Toronto Police Service here, and he was asked questions about, protest and how you manage it, and how a bylaw would interact with it. And at the time, the Toronto Police Service said to us that a bylaw would not change how police handle demonstrations. Is that still true?
So I would answer that a bylaw wouldn't change our operational approach to protest.
Okay, thank you. The same staff superintendent, long night last night, said that the police already enforce de facto bubble zones. And he gave an example of the Highway 401 overpass. He also talked about some work you guys did at university. Essentially, what he told us is that if you perceive a threat to public safety, your officers already go in and create cordons and control where people go to. Is that still true?
Thank you. So I don't work on our operational side of the house that the chief superintendent worked on. I work on the investigative side. So I'll leave the operational components a little bit to what he's already discussed. What I will say, though, is that as we approach any kind of policing function, public safety is always something that is top of mind, and we do have the ability to engage in activities to support public safety. But however, having legislation in place around specific issues is always helpful as we approach a public safety issue, even if there are avenues that we can employ that don't have a piece of legislation specifically attached to them. But those are more challenging things to have to enforce. So it's always better to have something written down by a legislative body that gives us guidance.
So what we were told in December is that under existing law, under existing legislation, and by the way, we don't pass legislation here. Under existing legislation, the Toronto Police Service already has the power to implement, and I'm quoting here, de facto bubble zones. Was that advice we got from the Toronto Police Service correct?
I would say that if the chief superintendent had provided that information to you, then you have to take the chief superintendent at his word.
Thank you. Mr. Grant, you're having a busy meeting. Your officers are provincial offences officers. Do they have the right to demand that someone identify themselves? Do they have the right to detain somebody? Do they have the right to remove them from a site?
The short answer is no. We can request identification. We do not have a We do not have the authority for them to meet that requirement.
Okay. And I'm not sure who I asked this next piece to. So in the event that someone applies to have a bubble zone and they make their attestation, and I guess it's Ms. the Director of Transportation Services who reviews it, and we decide, no, that's not sufficient. Is there an appeal? Do we get taken to court? What happens then?
Speaker, there's no appeal process, but I want to be clear that if there was a quote-unquote rejection of it, it would be purely administrative. An example I use is that it did not come from the owner-operator of the facility. It came from a user of the facility requesting the bubble zone. That's not what the bylaw states. That could be a situation. That is not a judgment call on the information provided. That is simply, it's non-compliant with what needs to be provided.
Okay.
It is an attestation-based approach.
Thank you. Councillor Chang, questions?
Thank you. Through the chair to Toronto Police, is uttering hate illegal?
I'm not aware of a charge of uttering hate.
So if people are uttering hate outside a daycare, let's say, and it may frighten the children, but the actual utterances of hate are not actually criminal. Is that correct?
So it really depends on what is said, how it is said, the context around what is said. So that's a very broad question, unfortunately.
Like there's no threat. I hate you because you are X, Y, or Z. You shouldn't.
Again, complicated, because even what you're saying there, depending on the context and what is specifically said, is important and has to be factored in as to whether or not it rises to the level of hate crime.
So is there legal forms of hatred in our city?
I'm sorry, are there legal forms of hatred?
Mm-hmm.
Yeah, that's a difficult question. Right. And I don't know that I really would be able to give it a good answer because, I mean, people have their own thoughts and feelings that could rise to the level of hate, and we're not the thought police.
We can't police hatred, right? Who would be enforcing the bubble zones?
So my understanding is that MLS and the City Transportation Services lead as the primary enforcement agency for this bylaw, and that the Toronto Police would be supporting it.
Okay, to Carlton, I'd like to ask, what will the consequences be? I heard there's an education approach being taken at first, but eventually would there be tickets, or would we ask the police to arrest?
We would start with education. Are you aware that you're not permitted to do this activity? Please adhere to the bylaw. If we needed to escalate enforcement, it would lead to tickets. If it came to arrest, that would be under the jurisdiction of the police, and they would use that as necessary.
There's a daycare here at City Hall, and if the daycare in City Hall applied to be a sensitive area, access area, what would that do to City Hall in terms of being a place of protest? What kind of impact could that have?
Perhaps the city manager or the city manager's office. It's probably more appropriate for them to answer that question than me.
So, Speaker, we're not getting into hypotheticals, and that's what it is. I can tell you, City Hall is not one of the institutions that is covered within this bylaw.
But even though there's a daycare in our building?
There is a daycare. Daycares are covered in it. We're not going to get into the theoretical of answering exactly how this would be enforced and what would happen here. But the bylaw is in place for that. City Hall, as an institution, is not.
And so just to clarify, this policy is tied to use of a space and not the space itself. Is that correct? So if an activity that is not, for example, worship related in a faith institution is happening, then that access area might not be enforceable?
As drafted, the proposed bylaw applies to the primary purpose of the institution. Yes, that's correct.
What are key differences in our proposed policy and those enacted in Brampton and Vaughan? What do we see as the big differences?
Yeah, so first of all, the recommended size of the access zone is different. It's 20 meters. In those, it's 100 meters. The city also has a request-based attestation process for establishing it, so it is not a uniform, universal application across all of the defined social infrastructure sites. And those are the key differences.
And what is the signage policy? So is there going to be signage for those places that have applied and been approved, or only in certain situations would a sign be erected?
Yeah, so the bylaw prescribes that the city will require the posting of a notice of an access zone by signage at the location. There are also other notice requirements in the bylaw, including on a city website, as well as prior notice by an enforcement officer before taking any enforcement action.
I have one last question. What precedents do we have?
That was your last question.
No, I have one more question.
Okay, go
please.
ahead.
Yes.
One
what
last.
incidents in the city have we seen where children have been subjected to people uttering hate or intimidation in accessing their place of daycare or schools?
Thank you.
So I can answer that the Toronto Police Service has laid a charge in relation to willful promotion of hatred against commentary that was made against children, but I don't believe that the context for that was at a school or a daycare.
Thank you. Councillor Burnside. Questions?
Yeah, thank you, Madam Speaker. Through you. So I'm just trying to understand currently, if I'm trying to take my child to school and someone's holding a protest at the entrance, and they won't let me through, is there any charge there? Or is there anything that the police can do?
There are potential charges of mischief or trespass to property if they're on property. So there are, the potential for some of those charges to be considered depending on the context.
So they currently exist. Okay. So I think this, through the speaker to staff, there's no power of arrest in a bylaw itself, is there? No. Okay, thank you.
No.
Okay, now back to the police. In terms of if someone were to disobey this proposed bylaw change, the power of arrest would be failure to disobey a lawful order. Is that correct? Or is there?
Yeah, so if there was a breach of the bylaw, then there are a number of avenues. One could be issuing a summons charging the person. But if you're talking about continued non-compliance,
I'm talking about power of arrest. Yeah.
The power of arrest for this really would stem from like an obstruct police. So if you're giving somebody a lawful order to engage in something or not to engage in something, so if it's interfering with our ability to affect public safety, then obstruct is a power that we have for an arrest and a charge.
Right, but that currently exists. Back to my original question.
Yes.
Correct?
Yes.
So this bylaw doesn't actually do anything in that regard. What this bylaw does is allows a ticket to be issued that differentiates.
So I would say that a bylaw, when you're talking to somebody about enforcing some piece of enforcement, a bylaw being included in that definition in my mind, having that basis and that foundation for why you're engaging with a certain person, asking for identification or asking them to do or not do something is foundationally a piece of building towards an obstruct.
Okay, so it makes the obstruct charge easier.
Well, it certainly provides a clear path for why we're asking somebody to do something, exactly.
But if someone's, so back to the speaker again, but if someone's obstructing the sidewalk, won't let someone through, you said there are potential charges there, you would have that conversation anyway. I'm trying to understand how this is really that different other than the ability to lay a charge, because you can have that conversation. Hey, you can't, you could face a mischief charge, which is actually quite a bit more potent than a bylaw offense.
Yeah, so I think to your question, it's just another tool in the toolkit. It's another conversation about limitation that's been put in place. It's been adopted by City Council as a bylaw. And if that were the case, then that is the basis for those conversations, as well as conversations around obstruct, mischief, or trespassing. It's just another tool in the toolkit that actually outlines what the expectation for protest activity is around those particular incidents.
Okay, thank you.
Thank you. Councillor Chernis Lynn, you're up.
Thank you, Speaker. So I just have some brief questions for staff. This is really to the city solicitor, I think. The 90-day proof of incident or victimization requirement, is that present in any similar legislation for access zone restrictions in Canada?
Not in the municipal bubble zone, but the Ontario abortion legislation does require an application.
Okay, but not in the municipal one. And an application, but do they actually have to show like that they've been victimized?
I'm not familiar with the application form itself.
Okay, thank you. The other examples of legislation around restriction of access legislation, bubble zone legislation, similar to what we're proposing today, did they create this similar 20-meter perimeter, or do they go further than that?
They have a 100-meter perimeter.
They have
the municipal ones do.
The municipal ones, yes. So is it fair to say then, in your experience and your jurisdictional scan that you guys did as part of this work, is it fair to say that the other municipal access zone legislation, bubble zone legislation, that they go much further than what's being proposed here today?
Yes, they do.
Okay, thank you. That's it for me.
Thank you. Councillor Holiday, questions?
Thank you, Speaker. To the solicitor, it says the purpose here is to reduce, prevent, and eliminate physical, psychological, and emotional barriers that may prevent persons from accessing such facilities. What are psychological and emotional barriers, and what things cause them to be in place?
It's difficult to be precise in the absence of a context and a particular situation, which we might be called upon to analyze on a case-by-case basis, but the idea is that barriers could be created by conduct discouraging access, and there is some language in there to describe the type of conduct.
I see, and so that's the link, is the conduct then creates a barrier, and purpose of this bylaw is to deal with that.
Yes, that's correct.
Okay, to Toronto Police. There was this bylaw focuses on schools, daycares, and places of worship. Is it a reasonable assertion that these are places that have a lot of children and seniors that attend? Reasonable person could.
I think the average person would agree with that.
Are children and seniors considered vulnerable individuals?
If you're asking a layman's definition, I would say that children and seniors could be considered vulnerable in certain respects, but I don't think that's for me to really answer.
In some shape or form, does policing around vulnerable individuals have special considerations?
Of course.
Okay. Earlier, Councillor Perks talked about de facto cordons that are created by the police. So I'm going to imagine, I don't know, that the police would put out caution tape, maybe put out barriers. Is that how it works? You'd have to deploy officers and resources to a location to create a cordon.
Yes, if we were going to create a cordon to limit access, we would have to deploy resources for that.
And that is resource intensive.
A cordon would be a resource intensive.
There were some other questions that talked about, impact on resources, the city's budget, work effort, that sort of thing. If a safe zone was created and people followed the rules, they created a 20-meter space, is it possible that actually could reduce the workload? Because people would see the rules and there wouldn't be a barrier to access any longer.
So I think that pulls a little bit of the thread that Councillor Burnside was pulling on there, and I think that a bylaw sets an expectation of what's reasonable behavior and what's not, and that's always a good starting point for us to have discussions with people.
So are there examples of situations where police set up zones or cordons, and part of the challenge of individuals at that location were pushing back on, not physically, but pushing back on, I want to enter that space, or your cordon's too big, or it's not, there's some confusion around that, because I don't think the police have a hard and fast rule about what a cordon is. It's ad hoc, right?
Well, again, I think we're talking about a term called cordon, a cordon, and what that actually is in practical sense. That we don't just go around setting up cordons. We might block a street because there's a car accident, and you might consider that a cordon. So it's really hard to kind of delineate what you're striving at.
So this bylaw deals with access to certain locations. When police get a call for service or are asked for help with respect to an evolving situation, is protecting access to the site at least sometimes part of the equation and part of the work that police has to do?
Yeah, depending on the situation, preventing or allowing access is part of that.
So, there are public order considerations, there are, all sorts of considerations, but allowing access is among the mix of things that you need to deal with.
Certainly.
This is the last question. It's a technical one. I didn't understand it from the rest of the answers, but Mr. Grant's bylaw officers have some limitations in stopping people and asking for it. It's a question for police. They have some limitations in how they interact with individuals. But could the police issue a ticket under this bylaw?
Yes, the police have the power to issue a ticket under this if this bylaw was adopted.
And beyond that, if someone resists providing information to facilitate a ticket, resists the direction of the officer, the police have other secondary rules that can help with that enforcement process. That's what you do.
Yes.
That was your last question.
Thanks,
Thank you. Councillor Carroll.
Thanks, Madam Speaker. I think most of my questions are for the Toronto Police Service. I want to follow on Councillor Chang's line of questioning, because I don't want there to be confusion. So many are watching today. The Toronto Police Service has been laying hate crime charges. We have been doing that, especially since October 7th, 2023. Am I right?
Yes, Councillor and Chair, the Police Service Board anyway, that's how I'll refer to you. We have been laying charges. It's a common misnomer for people to think we're laying hate crime charges. We're actually laying criminal code charges where we say that there's hate motivation and we attempt to prove hate motivation, and that provides for aggravating circumstances in sentencing.
Yes, and it's squaring that circle. That's why it's difficult because that's how they make these things possible to have a court outcome. You can't use something as subjective as just the word hate, and so it's very complex, isn't it? But we have been providing enhanced training both through the Hate Crimes Unit and Project Resolute to fortify our ability to enforce the criminal code. Have we not?
Yes, Chair, we have substantially increased our training around enforcing the criminal code in the hate crime context. We deliver training to all of our recruits. We participate in working groups, both provincially and nationally, to create training for investigators as well.
I've witnessed some of that, and it's been quite good.
Thank you.
We also know, we recently looked at our 2024 statistical report, but we also we know anecdotally that in these first few months of 2025, we are still laying those charges where the police service sees a need to lay those charges. We're still doing that at the 2024 rate or higher, even though the report of incidents is actually going down slightly in 2025. You're aware of those updated statistics?
Yes, Councillor, I am. And I would also say that the numbers may be down when we compare year over year, but when you go back 2 or 3 years, they're actually still, I believe, up.
Yes, and we continue our efforts and we continue our training because while stats are nice, we know that reports going down doesn't mean incidents has necessarily gone down. That may mean, you know, some potentially dangerous normalization and a lack of reporting. That's what we heard last week at the board.
Certainly, underreporting is significant in the hate crime reporting, and we do a lot of community engagement to try to encourage reporting and give information to communities.
Thank you. And then lastly, I wanted to talk about, because we're now looking at, you know, the one legal precedent we have here, which is the bubble zones created around abortion service providers. Has there needed to be collaboration between the police and MLS to enforce those zones? Have the police had a lot of involvement there, or has that been necessary?
So in my memory, we've not had any need to enforce or collaborate in that, but that's just anecdotally me here. I've not done any research to that. I think the closest comparator I could draw to collaboration with MLS is during the COVID regulation restrictions. We worked hand in hand very closely with MLS in creating enforcement teams for large gatherings and people hosting parties that was in violation of the current regulations at that time. So we're well exercised to do this.
Right, and while you may not have had many requests, if you had a request in enforcing the bylaw we're considering today, or indeed the precedent that we have, if you had a request as a police service, you'd respond. Keeping bylaw officers safe while they're doing their job is as important as keeping any Torontonian safe. Am I right about that?
Of course.
Okay, thank you. Those are my questions. Thanks, Madam Speaker.
Thank you. Councillor Thompson, question.
Yes, thank you very much, Speaker. My questions, at least the first couple, are for legal. Does the proposed bylaw restrict freedom of speech, or does it infringe upon protected rights that are guaranteed by the Charter?
It would create a limit on freedom of expression. However, the Charter freedoms are not absolute, and there is a test under Section 1 of the Charter that would be applied in any court proceedings to determine whether the limit was reasonable.
Okay. And does the proposed bylaw restrict the right to assemble?
Yes, however, our analysis focuses on the case law around freedom of expression.
So restrictions,
generally speaking, that's where the cases are.
So there are legal restrictions that are able to be put in place that protects the bylaw, the proposed bylaw that is being discussed at this point.
Yeah, the Charter itself permits what are referred to as reasonable limits in a free and democratic society, and there are some tests articulated by the courts to determine whether a limit is reasonable.
So does the proposed bylaw itself balance free speech and public safety?
We've provided a lot of advice in the process of coming up with a proposed bylaw, and we have identified arguments that could be made to...
I'm sorry, you have identified?
We've identified many arguments that could be made to argue that the tests under Section 1 are met. However, one can never predict with certainty the outcome of a court proceeding, and should Council wish to go into any more detail on this particular topic, I would recommend a closed session.
Fair enough. I'm not proposing that at this time, but so I guess my next question would be for Mr. Grant, I presumed. Does this proposed bylaw limit noise levels to prevent disruption of services, for example, activities that are taking place at a particular, let's say it's a church or a synagogue or other venues? Does the bylaw address the issue around noise?
This specific bylaw doesn't speak to noise. We have a noise bylaw that prohibits amplified sound. If there was an amplifier and a blowhorn or whatever those are called, a speaker, we could use, and if it exceeded those limits and exceeded the noise bylaw, we could use that authority But this particular bylaw does not speak to noise or people noise.
And the reason why is because you actually have the authority already, as you've just expressed, correct?
That's correct.
And I guess this one's for the police, I guess, or the city manager. We talk about the bubble zone, and I think Councillor Bradford asked a question about, and he gave the example to the general manager of transportation around the width of roadways and so on. I believe Warden and Shepherd was utilized. Let's assume for argument's sake that the distance of 20 meters is in the midpoint of Shepherd or Warden. We don't allow protests to take place in the middle of a street that has not been permitted to allow a protest. So what would the authority be in order to address this issue when in fact the 20 meters would be in the midpoint in a roadway? Who has the authority to either suggest to the protesters that they need to move because it's unsafe, or any other particular requirements that would be required?
So, Speaker, there are other circumstances, bylaws, and other reasonableness that would suggest that if it ends up being in a lane of traffic, that's not appropriate. What we tried to balance here is, though, the urban environment in Toronto, if it is much larger, could push this very much into private property or into neighborhoods. So it's a balancing piece around this. So yes, we understand not all roadways are 20 meters wide.
Right.
But the reasonableness piece would be that it may extend a little bit further. The goal of this and the thinking behind this is it's a small movement to allow the access to happen. It is not to take away the visual or audio pieces that may be occurring. And as I say, we would use all those reasonable pieces or tools we also have already in our powers to make sure that everyone's safe.
And the authority for that, would that be the police to remove the protesters to a safer area, or would it be MLS?
Again, it would be a combination. It may require the police. It could be our enforcement officers articulating that and people complying, which would be fine too.
Fair enough. Thank you, Speaker. Thank you.
Thank you. Councillor Crisanti.
So thank you, Speaker, and good morning, everyone. So just to confirm, not sure who to ask this question, the three institutions included in this proposed bylaw are places of worship, schools, and childcare. Is that correct, the way I described it?
Yes, that's correct.
Was any consideration given to other institutions that are widely used by families, community centers, libraries, other institutions, hospitals possibly? Any consideration given to those institutions?
Speaker, yes, there was consideration, and this was actually a major focus of the engagement that occurred. So two things are at play here. One is there was a desire to limit the access zones to places where it was a high concentration of, in this case, children and other persons like that. But the other piece was we listened to the community. There was not widespread support for all sorts of other institutions to be part of this. This seemed to tackle where there was the most consistency in their answers and engagement.
Okay. It says here that in 2024, there were 680 demonstrations. I think the highest number that we've had in many years. Did you assess where those demonstrations took place out of those close to 700 demonstrations, and include those institutions into the report?
Speaker, we did not assess exactly where those demonstrations were. Those statistics were provided by police, and we can follow up on that information if needed.
Okay, thank you. So this is an attestation-based approach from what I've heard this morning and read in the report. Can you explain that exactly? How does that work? How does the attestation-based report? You got to do something first before
Yeah,
you
so
could be
an
protected.
owner or occupant would submit a request to city staff, and they would be asked to attest three things: that there have been activities that are prohibited under the bylaw occurring within the last 90 days at their location, that they have reason to believe it will continue, and they'll submit that attestation as part of the process. Once all the criteria have been met, the access zone would be established for the site.
So you're saying then, if I understood this, that something needs to first happen or a threat of something happening before you could do what? Apply the bylaw?
Yes, so the access zone is reactive to specific events of issue that are causing or impeding access at the site, at the social infrastructure site.
And the recommendation here says 20 meters from the boundaries of that particular property or institution. Is that correct? That a protest could take place outside of that area, 20 meters.
That's correct. The restrictions contained in the prohibited actions in the bylaw would only exist for the 20 meters within that access area.
Okay.
There would be no restrictions contained in this bylaw applying beyond the 20 meters.
So I'm old school. 20 meters is roughly 60 feet, 62 feet, 63 feet maybe. That's maybe from here to the end of the council chamber, roughly. So families are having, weddings or events at a place of worship, or families are entering the place of worship, and the main entrance is roughly where the speaker is sitting. You felt that was adequate and safe?
The purpose of the bylaw is to protect safe access, and it was determined that 20 meters was an adequate distance to achieve that goal.
I guess it'll look good in a wedding album as well. In terms of enforcement, what I read was education and then enforcement. Can you take me through the steps of enforcement here? So there's a protest going on 60 feet away, and things aren't going that well and needs to be enforced. What happens?
I'll leave it to those whose staff will be engaged in enforcement to provide more detail, but the bylaw does require that enforcement staff notify those who are offending the bylaw provisions prior to any charge. And notification includes explaining how their conduct contravenes the bylaw.
Can I shoehorn in one more quick question? When we're having almost 700 demonstrations in 2024, do we need to pull resources to help Toronto Police to support Toronto Police and our enforcement officers?
That's your last question. Can the police answer that? Oh, okay, whoever wants to answer, please, staff. So the question.
Sorry, I was just engaged in another question.
The question was, when there's a major protest, are resources from other divisions brought in to enforce and to monitor the protesters? So we bringing in resources from other divisions?
Yes, we do often pivot resources throughout the service to respond to protests in a given area.
And Speaker, from a city perspective, we already engage in partnership with the police around some of these instances, and many times we are attending with the police and in support of those actions as well.
Thank you. Councillor Coe, questions?
Yes, thank you. Can Toronto Police Services lay hate crime charges?
So, Councillor, we don't lay hate crime charges. We lay criminal code charges that we believe are hate motivated and then apply for consideration for aggravating sentencing upon conviction.
So, in other words, if someone...
Sorry, just to clarify, there are also a couple of provisions within the criminal code for willful promotion of hatred. I think those are hate crime charges, but those are required AG consent for us to lay those charges.
Okay, so the Toronto Police do have the ability to lay hate crime charges?
Just that category of charges, those very narrow category.
How many charges have you laid recently of hate crime related?
How many hate related? Oh, I'll have to get back to you on that.
Okay, can you find?
I mean, I can point to our 2024 statistical report.
Could you?
Yep. Just give me 1 second here. So in 2024, 115 persons were arrested for criminal code charges that were hate motivated.
How many,
Councillor Perks, please stop interrupting.
how many of these charges resulted in convictions?
So of the charges that were laid in 2024, that'd be a challenging question to answer at this point because criminal code charges don't resolve fairly quickly. They sometimes resolve over the period of months and years. So we do, I do have other data that I'd have to look a little harder for to find out what that data might be, but I wouldn't be able to give it to you right now.
Now, when you lay these charges, for them to proceed to criminal court or whatever it is, you need the consent of the Attorney General of Ontario, do you not?
Only for a select three charges, sorry. Other criminal code offenses, we do not require AG consent.
But under those 4 areas, has the Attorney General of Ontario ever given consent to proceed with the prosecution of those hate crimes?
Yes.
And when was this?
So we have a number of willful promotion of hatred requests that we've put forward to the Attorney General, and they have consented to those charges.
When was that?
That's been occurring last year, this year, the year before. So that's something regular. There's just not a lot of those charges because they're very specific charges.
Yes, and then in terms of the number of demonstrations that have occurred in Toronto over the last 19 months or so, do you give us an approximate number of how many of these demonstrations the police had to attend to?
In terms of our attendance out of the total number of protests?
Yeah.
I'd have to go back to the data requests that went into our analytics and innovation unit, and I'd have to actually ask them that. So I'm not sure what the basis for this data was, if it was all protest activity that we know about, or protest activity that we actually attended. So I'd have to delineate that for them.
And I guess maybe senior staff may have an idea of what the cost of policing these protests have been over the last 19 months. Maybe, does the city manager have that?
Speaker, I don't have that full costing of policing. And the other piece in terms of any cost to the city, we're going to have to continue to monitor that. Given the initial engagement around this, it was not suggested that there would be large volumes of institutions attesting to this. So we'll have to continue to monitor that and report back to council on any budgetary pressures.
No, but not so much to the bylaw enforcement. I'm talking about the police overtime and extra resources used over the last 19 months to basically monitor and secure these areas where protests have taken place. What's been the impact on our budget?
Speaker, so that's reported through their variances. My understanding and looking at the public records is we're somewhere in the 20 million range, or a little more than $20 million. That's been a pressure that's been identified by the police. But that's my recollection from reading some of the public statements about their budget pressures.
Could you get that number for us to see what the cost has been about the police attending these protests?
Yeah, absolutely.
Thank you.
We'll go to the speakers. Councillor Pasternak, you're ready. You're first on the list to speak. Councillor Pasternak to speak.
Yes, thank you, Madam Speaker. I have 2 motions. One is giving councillors the option of extending the 20 meters in the bylaw to 50 meters or to 100 meters. If 100 meters fails, then we will vote on 50 meters. Those are my only motions. So I think in this discussion, it's concluded bubble zones do not ban protests. They do not ban peaceful assembly. They do not stop free speech. They do not stop legal picketing as part of a strikes. Bubble zones are not unconstitutional. For those who respect our charter, it only seems natural to support these measures. Bubble zones extend charter rights. They do not take any rights away. They protect people in prayer, people going to take their children to faith-based schools, people who attend vulnerable institutions. If the protesters are unhappy with the moves we're making in other municipalities across Ontario, they only have themselves to blame. They don't want to hear from anyone else. They want
Okay,
to shout.
Councillor Pasternak, please speak through the chair, please.
We have seen them on their marches, screaming, "Shut it down." They invade award ceremonies, storm shopping malls at Christmas time, disrupt travelers in Union Station and on CN tracks. They shut down speakers, synagogues, churches, and other places of worship. They are out to deprive others of their rights to go about their daily lives in peace, security, dignity. They block roads, they taunt police, and this is not what we describe in the Constitution as peaceful assembly. You know, if it wasn't for our faith groups, our great city would be in dire straits. They are the ones that host the Out of the Cold program, food banks, toy drives, counseling, and solace. They help with mental health challenges, those working with substance abuse and marriage challenges. By keeping the faith, they keep us whole. Ask not what our faith groups can do for our city, but ask what this council can do for our religious communities. These faith groups and other vulnerable institutions are not asking for the sun and the moon. They are asking simply that they have safety and security. They want to go about their daily lives with peace, security, and peace of mind. These protesters, to be just a few feet away from children, going to daycares and yelling at them about a world conflict zone 10,000 kilometers away, defies logic, but defines hate. I'm quite surprised at the letters I'm getting from labor unions about bubble zones. The NDP actually has a rich history in supporting bubble zones and supporting a safe work environment. In Nova Scotia in March 2020, it was NDP MLA Claudia Chender who tabled a safe access zone bill to protect those who work at and attend an abortion clinic. Starting in 2018, Manitoba NDP MLA Mahani Fontaine introduced bubble legislation on numerous occasions in protests to stop protests in schools, hospitals, clinics, personal care homes, and other sites. And in 2024, the NDP government of Manitoba introduced bubble zone legislation. Former federal NDP leader Jagmeet Singh said in 2021, quote, "I absolutely support creating a safe bubble. I absolutely believe there is no space for all protests that are threatening healthcare workers and patients. So no, I do not believe this is appropriate at all. It's wrong, and that is not the place to protest. I again reiterate, this should not happen." And as we know in other municipalities across the GTA, Patrick Brown, the former head of the Conservative Party of Ontario and current mayor of Brampton, supported and adopted bubble legislation for that city. And former Liberal cabinet minister Stephen Del Duca, the current mayor of Vaughan, also introduced bubble legislation in that city. Let us look back at this time that we were a council of high purpose, that we didn't give in to misinformation, conspiracy theories, and angry mobs, that we've seen the emails saying bubble zones take away the right to protest and ban free speech and the right to picket. This is nonsense. Bubble zone protect rights, as was the case used to protect women who sought medical care of an abortion clinic, those frontline hospital workers from harassment, and faith leaders in several municipalities, a growing number of municipalities. These laws won't solve all our problems or offer complete protection, but will send a strong message that this council supports religious communities and the rights we cherish. The right to peaceful assembly can be our highest ideal. Thank you very much.
Councillor Moyes?
Thank you, and through Madam Speaker, I do have a motion. If you want to put it on the screen, it's a deferral motion. The current government, Prime Minister Carney, during his recent campaign, stated that dealing with this issue is a priority to his government, and is something that he wants to address. In the report before us today, I think the city manager referenced that. It relates to access to places of worship, schools, and community centers. I think in the meantime, until that law comes into place, where it governs the entire country, not just the City of Toronto and other municipalities, I do believe that the police have the resources to actually keep our citizens safe. And it was alluded to in the question period that we've just had here in regards to mischief charges, trespass notices. It covers the criminal code when it comes to hate and other things. And even in regards to no signage on our bridges on the 401. So as I mentioned in my own questioning, Toronto Police actually spend an additional $20 million above their allocated resources budget to actually deal with protest and deal with people who deal with protests. And I must also say that 95% of people who actually protest in the City of Toronto is being peaceful. And that's important. And those that have not followed the laws of the land have actually been charged. So I want to continue thanking Toronto Police and city staff for all the work that they do, not only during the difficult times, but also during the good times as well. So I do hope that my council colleagues will consider this deferral until the federal government puts the proper laws in place that addresses this very significant issue.
Okay, members, so there's 2 minutes to speak on the deferral. 2 minutes. No, it's just on the deferral. Yeah, 2 minutes. No, it's just, yes. Okay, go ahead. Go ahead, Councillor Fletcher. Go ahead. Yeah. Okay. Okay, 2 minutes for question and 2 minutes on the deferral. So go ahead. Oh, sorry, Councillor Fletcher, there you go.
Okay, thank you, and thank you for that clarification, Speaker. Earlier I had asked Toronto Police about the budget, and you've indicated this should wait until we hear what's happening from the federal government. Councillor Moyes, would you think this would also give us a chance to understand any financial impacts after we heard that there's over 3,000 locations that could be considered for a bubble zone? We're just waiting for this mic now.
Sorry, can you repeat the question?
Let's just give her a chance. She's just figuring it out. It's about, there's going to be a lot of money there.
Hey, Councillor Moyes, are you going to answer?
Sorry.
My mic is on.
Now,
Your mic is on.
Speaker, I think his mic wasn't on. I think we just need to go again while we get this sorted out, if you don't mind, please.
Okay, go ahead. I turned your mic on, Councillor Moyes.
Thank you, Madam Speaker.
Okay, now I'll just ask that again in my 2 minutes.
Okay.
Whose mic is on or off?
Okay, my mic is on now. Go ahead.
His mic is on.
Okay.
Okay. Go ahead.
Yes.
So I think you mentioned, so there's 3,000 locations that the police would have to be responsible for in regards to schools and daycares and synagogues and mosques and all these things. It's quite extraordinary. I think, again, they spent $20 million last year above and beyond what is needed. Not to mention the resources, people power that goes into this. It's an impossible task. And I think, we're asking too much of our staff, police and MLS, to deal with this issue. I believe that the federal government has the resources whatever legislation they may bring forth eventually, hopefully that will accompany financial resources as well, which we need here.
So if the federal legislation said the same as this bylaw, there would be 3,000 locations. You're thinking that would give us a chance to say 3,000 locations, you've identified those, and now we need resources federally to our local police in order to be able to respond to many hundreds of requests for these bubble zones.
Exactly. I believe that. And again, I know MLS talked about education, which they're very good at, to educate the public as to what is and what is not. And I want to also mention, too, 95+% of the protests that are taking place in the city are peaceful protests. It's important to state that. And for the few that may be agitators, that may be troublemakers, Toronto Police has been present. Even in the video that Councillor Pasternak showed, Toronto Police was present. And they were there to actually engage those that were agitators.
Thank you. Thank you for that.
Two minutes. Clarification of the motion. And then we've got 2 minutes to talk on the deferral.
So, Councillor Moyes, the rationale of, sometimes there are overlapping jurisdictions, right? We sometimes have different areas where there's overlapping. Why can't we have that here?
Again, I believe that Toronto Police, who we have given the tools to do this job in the form of $20 million last year.
But that's not what this motion is about. This motion is about waiting until the federal government does this. How do we know the federal government is going to do this?
Well, they claimed in their campaign that that was a priority to them, and I'm going to take them at their word that that's what they're going to be doing. I feel that Toronto is a very diverse city, right? Our motto is diversity is our strength. And I have said from the very beginning, this should not actually have been brought to council in the first place.
Can you answer my question about this motion? Because that's not what this motion is specifically about, deferring it until the federal government deals with it.
And I'm saying that Toronto Police has the tools to do the job now. I think they've done it well. And we as a council should continue to support them. That's
I don't think that answers the question, but
well,
anyways.
that's my answer. Thank you.
Okay, thank you. Councillor Pasternak, 2 minutes clarification of the motion, please.
Yes, thank you, Madam Speaker, and thank you, Councillor Moyes. So the political situation in Ottawa is fairly unstable. Would you agree that it's a minority government? It's unlikely to fall tomorrow morning, but they predict it could fall within 12 to 18 months. Many of the proposals or plans that they have would die on the order paper. Wouldn't you agree that it might be a high-risk venture to, if we really want to get this done, to wait on the federal government?
I actually think that there's just two MPs short to a majority government. And I am sure that with the other parties, mainly the NDP and the Green Party, and perhaps even the Parti Québécois, Bloc Québécois, thank you. I think they could actually have the right numbers to make that happen. And again, Prime Minister Carney has stated this is a priority for him, and I believe him when he said that.
We have an opportunity here to create a Made in Toronto bylaw for our unique situation. Do we really want faraway Ottawa, out-of-touch Ottawa, to be doing it for us?
I think we've done it. Like I've stated, I actually don't support this coming to council. It's been divisive in this chamber. It's been divisive out in the community. I believe one of the responsibilities of council is to bring people together. And we haven't been doing that. I believe that if anything, we've done
Okay,
the
thank you,
opposite.
thank you, thank you. 2 minutes. Councillor Burnside, 2 minutes.
Yeah, thank you, Madam Speaker. You mentioned the federal government said it was a priority to do something. What's their definition of priority?
Well, I can't speak on.
Nobody knows the answer.
I can't speak on what is a priority for the government in regards to timeline, but they actually took the time to say that this is important for them.
Was that similar to the rank balloting importance?
This particular Prime Minister didn't mention a rank ballot.
Sorry, I guess my point is, what assurance do we have that they will do something? Will this, if, you know, for those councillors who think this is very important, and I think that's a large number of councillors here, what assurance do we have that this won't get lost in the ether? My concern, you know, like, would it not be wise to have a time frame for the government to do something?
Well, it's a priority for council, it's a priority for other municipalities, and we do have mechanisms to engage our MPs and this government. For example, next week, I will be in Ottawa for the Federation of Canadian Municipalities conference, and many of my colleagues will be there, and I will be meeting with some ministers who are out there as well. So I would take that opportunity to speak to them about this issue.
So just in case you're not successful, and I don't want to judge your level of persuasion, but would it be wise to maybe put a timeline in terms of the referral? Like if the government doesn't do something within 6 months,
Last question.
Well, Councillor Burnside, this could take 6 months, it could take 12 months. I don't want to come back here in 6 months, have another
Thank you,
in-depth,
Councillor Moyes. Thank you, Councillor Holyday. 2 minutes. Please make your answer short, Councillor Moyes. Councillor Holyday.
Would Councillor Moyes let us know if, when he's meeting with the ministers in Ottawa, if he'll take a copy of our bylaw to show them?
Councillor Holyday, all our documentation is public.
Okay.
So I don't need to actually bring a hard copy to them.
To clarify the motion, do you think that this motion will create more conflict or less conflict in the city going forward? Human conflict.
I think this motion will actually do nothing. And it will not create...
Well, it's doing nothing, I agree, but will that lead to more or less human conflict?
This motion that we have today, it's not going to stop protests in the city of Toronto, to be quite frank. People will protest, and they will continue to protest peacefully as they have been.
But
Is their charter right to actually do so? Okay. And they'll continue to do that, regardless of what's in the books here. We don't have the resources. MLS doesn't have the resources. We cannot police 3,000 plus institutions across the city,
right?
Because we have this here.
Again,
this is why I said initially that
Councillor Moyes, please allow the councillor to ask you a question.
Will it end up costing more or less not to take action?
Well, I like, you know, the city manager mentioned, I don't have what if answers here. What I'm saying that with the federal government, once they put this in place, hopefully will accompany funds to actually help the city of Toronto. As of right now, we don't have the resources to do this.
Thank you. Thank you. Okay. Councillor Bravo, 2 minutes, just clarification of the motion, just 1 sec. I'm having problems with the screen here. Okay, Councillor Bravo, go ahead.
Thank you, Speaker. Councillor Moyes, through you, Speaker. Your motion indicates that we know that the federal government is planning to examine such a move or such legislation because it's in the city manager's report. Is that not correct?
I'm going to turn my mic on, Madam Speaker. That is correct. I actually read it in here, and yes, it's correct.
And isn't the core question here and the most significant question that the charter, the Constitution, is a federal area, and secondly, that the criminal code, which qualifies and substantiates and creates all the parameters around hate speech, around intimidation, around obstruction, which are the things that we're talking about here, that's also a federal responsibility?
That is absolutely correct. And as I've mentioned also too, the police actually have the tools they currently need to do their jobs when it comes to mischief or trespass, and even hate crime. It's all in the criminal code.
And the question of, are we creating, as Councillor Pasternak said, a Made in Toronto solution? Are we creating a Made in Toronto solution, or are we sort of creating a bylaw on the floor of council without a lot of study? Do you believe that the federal government doing a thorough study of what's needed here would be more beneficial?
Well, I think we're creating a Made in Toronto problem. And again, I don't think, dealing with this in a piecemeal manner is the right way to do this. It's such an important issue that I think it's important that the federal government looks at this across the country and deal with it that way.
Thank you, Councillor Moyes. Thank you. All right, 2 minutes on the deferral. Councillor Bradford.
Thanks, Madam Speaker. I would just urge my colleagues to vote against this. The language of the motion here is poorly written. For starters, it states defer consideration of the item until such time as the Government of Canada completes the work as described in the report from the City Manager. I didn't hear Prime Minister Carney campaigning on completing the work of the report outlined by the City Manager, so I don't think that this is a realistic approach. And further on that, I would just say, and it comes from a bit of a place of frustration, we've been having this discussion about safe access for places of worship for a long time here. Last May, I moved a motion alongside Councillor Pasternak calling for the Attorney General at the Province of Ontario to implement bubble zones around places of worship here in the city. That is similar. In fact, we lifted the language from what they have done to protect abortion clinics. And that was literally just a request from the City of Toronto to another level of government to do something. We do that every single meeting. Every single council meeting, we go ask somebody else to do something. And yet, when it came to safety of those who want to practice their faith in this city, the mayor and the majority of council voted against that. They voted it down, just a simple ask. And so, forgive me, but I'm not terribly confident in another exercise of deferral, in another exercise of a dereliction of our duty here in this council, punting it to another level of government, that is going to be terribly successful. I think that the deferral would be very unhelpful. I think that 19 months into this mess of what we've seen happening here in the City of Toronto, further debate, further deferral, further delay is unhelpful, and it's not something I can support.
Thank you. Councillor Turnus-Lynn, 2 minutes on the deferral only. Thank you.
Thank you. I have to say that, like Councillor Moyes, I believe in bringing people together. And I think we shouldn't be saying that just because, you have questions about bubble zones, it doesn't mean that you don't believe in bringing people in the City of Toronto together. But I think this is a moment of moral clarity for this council and for our outlook for the safety and well-being of the people of Toronto. We have heard loud and clear, month after month after month after month, about the pain they are enduring on the streets of Toronto. They feel like they can't go downtown. I get regular emails from people who feel they are being victimized on a regular basis, who are afraid to go to the symphony, to an arts event, to go shopping, to go out for dinner. I know this doesn't solve all those problems, but it at least gives them the sense that they can enter their synagogues, their churches, their mosques safely. To defer this is putting us back on the hamster wheel, going around and around and around and around. And I can tell you that gets us nowhere. We don't know that the federal government will do anything. If they do something down the road, it will help, sure. But it is our responsibility. What's before us is our responsibility to answer what we asked this council to do and directed staff to do back in December. And I think to stray from that is doing a massive disservice and incredible harm to the people of Toronto. Thank you.
Thank you. Councillor Matlow, 2 minutes on the deferral.
I have a motion on the deferral, the wording of the deferral. To make it, if you could put it up. Councillor Bradford is correct. It's not about continuing the work of the city manager. I want to, it shouldn't be about introduction, it should be about past. I am getting feedback on the microphone, Madam Speaker. And I think that we need to understand what takes precedence and also, actually, would you pause my time? I'm just getting too much feedback. I don't know if you can hear me. Distracting me too.
Okay, Councillor Matlow, you're amending the deferral motion?
Correct.
Oh, okay. Just so members of council understand what we're doing here.
That's correct.
Okay.
May I have another go of it without the feedback?
Yeah, you should start us again.
Thank you, Madam Speaker. I was just saying that I'm still getting feedback, Madam Speaker. I don't know why.
There's something wrong with your mic. It's not me.
Should I go to another mic? Here.
Turn yours off.
No, she doesn't. I'm not touching. Okay, let's see if Councillor Mantis's mic works any better. Madam Speaker, I am making some amendments to Councillor Moise's motion. Councillor Bradford is correct that the federal government is not continuing the work of the city manager. Let's clarify that. It should be approved, not introduced, and or passed rather. And I also think we would benefit from understanding from our debate what takes precedent and what could withstand a charter challenge. I think that's critically important, both for those who want legislation to actually be effective and can be effectively enforced, and for those who want to ensure that peace.
Thank you, Councillor Matlow. Sorry, your time is up. 2 minutes. No, I gave him extra time. Yes? Councillor Fletcher, I gave him an extra 20 seconds. Yes. Okay. Okay, please, Councillor Fletcher, stop disrupting. Councillor Matlow, I'll give you a few more seconds, but please continue. Councillor Fletcher, please allow Councillor Matlow to finish. Councillor Matlow, a few more seconds. Yes, I heard you, Councillor Fletcher. Okay, Councillor, thank you. Thank you, Councillor Fletcher. You made your point, and I'm allowing Councillor Matlow a few more seconds. I'll take it back, Councillor Fletcher. Please, I'm allowing Councillor Matlow to continue. Councillor Matlow, go ahead.
Thank you, Madam Speaker. I think the analysis is important, both for those who want anything that's done to be effectively enforced and actually work to protect people, but ultimately, we also want to make sure that people's charter right to peaceful expression and peaceful assembly is protected. Ultimately, I think all of us want to make sure that regardless of both the emotional pressures and the political pressures here, that whatever we do actually makes sense and is most effective. And I think that it is important, I agree with Councillor Moyes, that we want to understand what the federal government is going to do, and then ultimately,
Councillor Matlow,
just to conclude that one line,
okay.
And then ultimately, if we end up doing something, I want to make sure that it's the right package that actually addresses both of those concerns.
Thank you. And I just want to clarify, so Councillor Fletcher and other members, when we stopped because Councillor Matlow's mic wasn't working, I stopped his time at 1:12. So I did not continue his time. So just to make that clear, and the clerk even verified, at 1:12 I stopped this time. Councillor Holyday, point of order.
I do want to raise a point of order. I'd like you to rule on whether or not Councillor Matlow's amendment is in order, because the procedure bylaw only allows us to change the time or the circumstances of a deferral. And this particular last clause here talks about the city manager reporting to council with analysis of whether or not the legislation would take precedence and address the charter challenge. And I don't know that there's direction in place to have that to occur. And so that clause may not be in order.
Okay, I need to get a copy of that motion, please, to the clerk. It's in. So, Councillor Holyday, what Councillor Matlow's motion is changing the time and the circumstance of when it will come back, so that amendment will be in order. Okay, Councillor Holyday? Thank you. Yes, Councillor Fletcher.
I certainly realize that, yes, you did stop his time at 1:12, 1 minute and 12 seconds. But my point was that because his microphone was malfunctioning, we couldn't hear properly the first 1 minute and 12 seconds. So I just wanted everybody to understand that. Thank you.
Yes, thank you. I urge you not to defer this. I mean, it's a minor bylaw change we're trying to introduce here, where the bylaw officers issue tickets for people to impede entrances to childcare centers, places of worship. I mean, if we can't do that as a city council, what the hell are we doing here? We can't even pass a bylaw, and we want the federal government to do something before we pass a bylaw? Give me a break. And to wait for the federal government to do this and pass it? How many years will that take? We've already asked the provincial government to pay attention to this. They've totally ignored us. They don't even think it's a problem. We've asked. And then to characterize what's been happening here as peaceful protest, give your head a shake. We've had the firebombing of a Jewish grocery store. We've had front doors broken into. We've had shootings at the Jewish day school, repeated shootings at a school. And you say it's peaceful protest? Sure, there are many of the protests have been peaceful, and thank God they have been. But there's been a frightening level of violence that I've never seen. They even occupied, some of these aggressive protesters, even occupied a neighborhood of mine in the Upper Avenue for 6 months because they said it was a Jewish neighborhood. 6 months they occupied a neighborhood. So, sure, again, thank God, many of the protests were peaceful, but a significant number were not peaceful. Thank you.
Pasternak, 2 minutes on the deferral.
Yeah, thank you. I'll use my first few seconds to thank staff. I forgot to thank staff in my other speech for the work they did on the bylaws. Even though there were parts I didn't agree with, I know a lot of effort was done, so I thank you for that. This is the 4th time this item has come to council. And although it's not in the decision history in the report before you, the first time it came as the phrasing of community safety zones in October of 2023. And this is the 4th time it has come here. And it is important to realize what's going on in the streets of Toronto. Councillor Cole made reference to it. What is going on in many quarters of Toronto is a disgrace. The 3-time shooting of a Jewish girls' school, the firebombing of a Jewish-owned grocery store, the swarming of Jewish-owned businesses downtown, the blocking of roads, the blocking of critical federal infrastructure, hate crimes are doubled. This is not the city we know. This council has to show some leadership. This council has to give direction to city staff and police services to make sure there is a rule of law in this city. I'm amazed that some of the people in this council who support the protesters are arguing of criminal code, criminal provisions for the enforcement of these various laws. Well, my gosh, you're asking for more draconian measures against the protesters than what we're advocating here, which is simply bylaw. I mean, I don't know what you're thinking. But the bottom line is there's an urgency here. It has already taken us over 18 months to get to this point. We have to be a council of leadership and decisions, and we have to do everything we can, reach into that toolbox and do everything we can to keep our city safe. Do not vote for deferral. Vote against deferral.
Councillor Sachs, 2 minutes on the deferral. Just 1 sec, please. Just have to set it up. Okay, Councillor Sachs, go ahead.
Yes, thank you. I am asking my colleagues not to defer this again. We are in a situation, we've all talked about vulnerable institutions, but we might as well be honest. It's the Jewish community that's being terrorized. You'd never know that from the equity analysis because we're not mentioned. But what we've seen is a pattern of harassing and intimidating the Jewish community, Jewish school children, Jewish seniors, because of a foreign war that we didn't start and don't control. It is not legitimate to intimidate Toronto Jews because of a foreign war, no matter how horrible that war is. We need a decision today. Waiting for the federal government is just a mug's game. They may never do something. We have no idea what they would do, if they would do it, when they would do it. If they ultimately do something, there's certainly no guarantee they're going to give us any resources. But there is no problem with duplication. We have many, many examples in Canadian constitutional law where different levels of government legislate in the same area. That is perfectly fine. If they both do the same thing, there's no harm. If one does things that the other doesn't do, they each apply within their area of jurisdiction. And what the authority of the federal government is the criminal law. So all they can do is regulate criminal behavior. What we're trying to do, and what the courts have shown is consistent with the Canadian Charter of Rights and Freedoms, is to give a small area that is free from all kinds of aggressive protests, whether or not they breach the criminal code. There is a big gap between what breaches the criminal code and what makes a child safe going to school. And we should be taking our position to make it a little bit safer for children to go to school, for people like me to go to synagogue.
Thank you, Councillor Sachs. Sorry, it's just 2 minutes. And that's for everybody, and I try to go by the rules. Councillor Morley.
Thank you, Madam Speaker. I want to thank Councillor Matlow for the amendments. I'm inclined to support them. And I just want to underscore why I feel that way. I completely agree with my colleagues and certainly Councillor Sachs talking about the lack of legitimacy to attack or target Toronto's Jewish community. That is unacceptable, and I can't agree more with that. But I think it's important that we do not forget what has spurred the protests to begin with. This is an international conflict. Councillor Sachs mentioned that criminal law is a federal responsibility. So is international relations. And I think many people would agree that there's a lot more that Canada could and should be doing as it relates to the atrocities that are currently taking place and that people continue to stand up and point out. So, I'll leave it there. I don't want to get too much. I'll speak a little bit more at remarks. But this is a highly emotional, highly charged issue for many people. I know, having been firsthand at the table with Toronto Police Services, for example, the amount of energy, effort, and resources that have consistently gone towards ensuring that Toronto's Jewish community feels safe and is safe and protected through these very challenging times. But we need to be very mindful about our role as a municipal government as it relates to an international conflict and the important work and leadership of the federal government in this regard. So I'll leave it there. Thanks, Madam Speaker.
Thank you. Please, no applause. Councillor Holiday, 2 minutes on the deferral.
Thank you, Speaker. I don't support the deferral, but I want to make sure everyone's clear about what the deferral is. It effectively takes this body of work, puts it into a folder, puts it onto a shelf, and there it will sit until a certain time or a condition are met. The original deferral said when a bill is introduced to Parliament. I think we can understand that would be a point in time. But I want to specifically articulate the changes proposed by Councillor Matlow. First, it introduced the idea that a bill must be passed. At least we could figure out what that meant. And that becomes further obscure. That may or may not happen. We don't know. And the second part is even more concerning because it talks about a future report from the city manager, of which the city manager has no direction to do, and with an analysis of federal legislation that we haven't seen or heard of, and whether or not it takes place, would take precedent over a charter challenge that I don't think we have. So it really places this into obscurity. It might as well say indefinitely. I mean, that's sort of one step below it. So members should be aware that adopting Councillor Matlow's amendments really sends this far off into a place of uncertainty. And, the whole motion to defer means City Council takes no action, no further work is done on this. It's very similar to just voting against it. So I don't support any of these, but I want to make sure people understand what's before us. And why some of these small word changes really make a big difference. Thank you, Speaker.
Thank you. Councillor Fletcher, 2 minutes on the deferral.
Oh, thank you, Speaker. I will be supporting this deferral and thank Councillor Moyes for doing that, Councillor Matlow for bringing some clarity to it, because if we pass this, it's 3,000 locations. I'm sorry, that was the answer that I had from staff, that the total number of locations that could apply and be bubble zones in the city, 3,000. We're unclear what the cost of that would be for the policing side, what the cost of policing would be, or for MLS. I'm going to assume that that's something that, I'm sorry, wasn't in that report. I'm sure we can continue to do that work. In supporting this deferral, I want to be perfectly clear. I do not support attacks on any Jewish institution in this city. The attack on the Jewish girls' school is unconscionable. When police were here last time, they did not suggest that they would like to pull out certain places and have a special rule for them. I do not remember that. We were here for hours with the police. They indicated there had been many, many complaints, 400 and some complaints, and only 2 charges laid. If we had something in front of us that said at these particular locations where there have been violent acts that are clearly unsafe, not just where people feel unsafe, then that might be a different story. But This is why I think this will give us some chance. I think 3,000 locations is a slippery slope. We need to be very careful, and finding our way through this is not easy because it's a very emotional issue for everybody. We pride ourselves in the City of Toronto to thinking through things, and I think this deferral gives us a chance. Thank you.
Councillor Bravo, 2 minutes on the
Thank you, Speaker. I also want to support the deferral, and I want to thank Councillor Moyse and Councillor Matlow for their work on this. This is a very emotional moment. There are a lot of people that come at this from very different perspectives, and I think that what we have before us now is a bylaw that's sort of cut the baby in half, and then we have already suggestions that there are going to be amendments to the bylaw. This isn't the level of government where we should be considering these questions. These are federal questions of constitutionality and respecting charter rights, of the criminal code and expanding anything that needs to be done in that regard. And I do want to say, though, that speech is crucial. Speech matters. Speech is the way that we find our common humanity. When we stop listening to each other, we polarize, we dehumanize. That's how we're going to get through this, is to listen to each other. I have nothing but empathy and compassion for those people that are feeling very afraid in the city right now in the Jewish community. And I think that the tools that are made available that are in the answer to the administrative inquiry clearly indicate that we have the criminal code, we have trespass notices, we have bylaw enforcement. And to say that these, all of these public servants aren't enforcing this would be incorrect. That's why we have charges. But what we put at stake is the ability of people to freely speak in a society, which is a fundamental and foundational freedom. It is the way that we understand each other, and it's the way that we're going to get through this. It's what people said in the consultation process, however flawed that was.
Sorry, could we just have some order in the chamber? Councillor Matlow. Thank you.
Thank you. I don't need much more time, but to say this, that I have lived in a society
Councillor
where there's been a breakdown.
Sorry, I'm just going to hold your time now, because there's a lot going on here.
I lost about 30
Councillor
seconds.
Moyse and Councillor Pasternak, could you let the speaker finish and then perhaps pick up after? Thank you.
Thank you. I lost about 30 seconds. I have lived in a society where there was a breakdown of freedoms, military coup, dictatorship. And I can tell you that we don't make peace with people that we agree with. We make peace with people that disagree with us, and that's what we need to do.
Thank you, Speaker. Thank you, Councillor. Now we have Councillor Nunziata. Just 1 second, please, while I get you set up.
Okay, I'm urging members of council not to vote for the deferral. People that are voting for the deferral, and Councillor Moyse is moving the deferral because they don't support the bylaw. So if you don't support the bylaw, just vote against it, and don't do the delay tactic, because you don't support the bylaw. So say no rather than defer it. You know, it's crazy when you move a deferral. You know that that's why you're moving the deferral, because you don't want to vote against this bylaw today. So I urge members of council to not vote for the deferral. If you do, then you don't support the bylaw, and don't make up excuses why you're moving the deferral for more information.
Thank you, Speaker. I'll give this chair back to you. Anybody else wishes to go on the list? Oh, Councillor Chang. 1 minute, please. Thank you. You're up.
Thank you. This is a very difficult moment for so many people, and it's not just the people in this room, it's people across the city. And this morning, my colleague, Councillor Sachs, shed tears right here on this chamber floor because her grandchildren don't feel safe in our city, and they have encountered intimidating situations going to daycare. And if we send this into purgatory, which is really what it is, if we defer this, we are saying to the Jewish community, your pain, your struggles don't matter. And this is not a discussion about whether or not the Palestinian community has rights or the Palestinians in Gaza are suffering. This is not a discussion about what is happening in Gaza. This is a discussion about
Councillor
whether
Moyes, please stop disrupting.
regular folks who have spent decades in Canada, maybe a whole lifetime, who want to wear a Star of David and go to their place of worship and send their children to school, whether they can feel safe doing it. Is it complicated? 100% it is complicated. Will we get it right? Probably not. There will probably be things we have to learn along the way. But we have to listen to each other. We have to sit at a table and figure out how we can share a city and a country together, because we are not in the Middle East. We cannot solve the problems there. But we can live and build a respectful society with civil discourse here in Toronto. That is what we must do. We should not silence each other.
Thank you,
but
Councillor
we
Chang.
should create safety for everyone.
Sorry, everyone's 2 minutes. Councillor Myers, 2 minutes, please.
Thank you, Speaker. So I just want to add my comments to the deferral. So to be clear, I do not support the legislation. However, I don't support the deferral either, because I think I agree with Councillor Pasternak. We've dealt with this issue now. This will be the 4th time, and potentially there will be a 5th time. And I think we owe it to ourselves to just make a decision one way or the other. Whether we agree with the decision or not, I think we have to just own it and vote on it. The staff have done a lot of work on this. People are expecting a decision one way or another as leaders of the city, and it's not going to be a comfortable decision. I suspect the bylaw will be passed. However, I would like to say that we dealt with it. So far, the debate has been largely respectful, and I think we're showing an example to Torontonians that you can disagree with one another, but you can do it civilly, and I think deferring it at this moment would send the wrong message. So I will be voting against the deferral, but I will also not be supporting the legislation. Thank you.
Thank you. Okay, so let's put the motion on the screen. 2 motions. One's the amendment by Councillor Matlow, recorded vote.
Councillor Myers, are you able to vote using the system, or will you state your vote?
I'm not able to vote. My vote is... Thank you.
How did you vote? Oh, thank you. We've received it now. Councillor Perruzza, how do you vote, please? The motion to amend the deferral motion does not carry. The vote is 9-15.
On the motion by Councillor Moyes, recorded vote.
Councillor Matlow, please. The motion to defer the item does not carry. The vote is 8-16.
Okay, we got through that one. Okay. Next speaker is Councillor Holiday. Councillor Holiday. Okay, so I start your time.
Spell your application. Thank you, Speaker, for allowing me to do that. I wanted to unroll the tape measure because I wanted to make sure that Council was really clear on what 20 meters represents. I could see Councillor Bradford's facial expression, certainly could hear him. I could, if he was making a gesture, I could understand that gesture. He couldn't physically touch me, but he was very close. And 20 meters is literally within the intimacy of the council floor. It's not a big distance. At the heart of this bylaw, the words are here, it's in the report, and that is to ensure that people don't face barriers while attending specific social infrastructure. And those are physical barriers, those are psychological, and those are emotional barriers. What we're talking about, if you look at the places, they are schools, daycares, and places of worship. Those are places that children go. Those are places that families go to. Those are places that seniors go to. Why do they go there? They go there to learn. They go there to be taken care of as daycare, but they're also learning, and they're practicing their faith. And these things are the bedrocks of our society. We fall into dysfunction if people aren't able to self-actualize. And if you look at the science, something like Maslow's hierarchy of needs, you realize that being spiritual is right at the top of the pyramid. It literally forms people's identities. It allows them to be the people that they want to be. And if you attend services, you know that, and no matter what the religion is, people talk about those that may be out adrift in society. I can't believe for one moment that this council would allow barriers to exist where people could not participate, the most vulnerable people in our society. The ask is for 20 meters. There's a suggestion for more, which probably isn't a bad idea, just considering how close that is. There are small limitations, but let's think about this practically. We know as a council there's conflict that's happening out there. And if any of you are parents, or at least everyone should be able to relate to this, if someone interrupts a child, or causes harm to a child, or intimidates a child, what do you think the parent's reaction is? We have to be alive to the risk of human-to-human conflict in this city. And if something happens to someone, it's on our hands if we don't intervene and do something about it. So this is a very, very basic set of rules that creates access to these institutions. It doesn't say people can't protest. It doesn't say people can't hold beliefs. It allows people to get into those buildings. And that 20 meters is literally, the width of this room, places where we dialogue back and forth. And we can probably have that debate as to whether it needs to be farther. But if we're not protecting the bedrock of our society, then what are we doing here? Think about that. All the people want to do is go and practice their faith. I'm not even talking about a single faith, because this bylaw applies. Some members of council said, well, it's going to cost more. There's more schools. There's more places. There's 3,000. There's an old saying, good fences make good neighbors. When you establish the line, or you establish the limit, everyone understands and agrees to what that is. That actually reduces sources of conflict. Where you don't have a limit, you don't have an understanding, you don't have clarity, those are times when people mix it up, especially with people that are conducting law enforcement. And I don't want to make it about cost, but one could draw inference from that. That if we have clear rules in place that allows everyone to coexist and do what it is that they want to do in this, then maybe the complaints to police and bylaw go down and everyone can carry on without the conflict. But members of council, please protect the bedrock of our society, which is allowing kids to go to school,
Councillor
and
Holiday?
allowing people to practice their faith.
Thank you. Councillor Myers.
Hi, can you hear me, Speaker?
We can.
Okay, thank you. So I want to begin my remarks by acknowledging the sincere motivations behind the proposed bylaw. I understand that for many, particularly our friends, neighbors, and colleagues in the Jewish community, the intent of the bylaw is to create safer spaces around religious institutions and schools, places that are central to community, faith, and family. I also like to thank the city manager, city solicitor, and city staff for their hard and sincere efforts on crafting a bylaw that attempts to strike the right balance between safety and constitutional rights. Finally, I'd like to thank the more than 620 residents of Ward 23 who called, emailed, and spoke to me directly to share their thoughts on their proposed bylaw. All residents expressed their support for the rights of religious minorities to be safe in Toronto. However, they are also overwhelmingly clear. We do not support the erosion of our constitutional rights and freedoms in the name of safety. As the most diverse ward in Toronto and probably in all of Canada, with 90% of residents being racialized and 70% being immigrants, Scarborough North is unique in the diversity of our residents, institutions, and beliefs. A quick journey through our neighborhoods will show mosques, churches, temples, and a gurdwara peacefully coexisting and children of all races and faiths playing together. And due to our hyperdiversity, there is probably no ward more than ours that depends on the rights and protections granted by the Charter, including equality under the law, freedom of religion and association, and the right to fair treatment in the workplace. Regarding the bylaw itself, I keep coming back to the same question. What is the problem it is trying to solve? A recent article in the Star detailed the horrifying and sustained incidents of anti-Semitism that have been plaguing Toronto since last October 7th, which included shootings of synagogues, schools, and childcare centers. At the TTC, and as TTC chair, we've been dealing with less violent incidents, though no less disturbing incidents of spikes in anti-Semitic graffiti. However, none of this would be solved or even addressed by the proposed bylaw, as all of this is already covered under the Criminal Code of Canada. Regarding the bylaw itself, rather than asking owners of social infrastructure to provide evidence such as videos, calls to police, or evidence of property damage in order to show the need for a bubble zone, as was done in BC prior to the enactment of bubble zones around abortion clinics, it instead asks that the owners of social infrastructure to make just an attestation without the need for any evidence. Moreover, the individual responsible for determining the attestation is true is the general manager of transportation who, to my knowledge, has no legal background or experience in making decisions that affect constitutional rights. On top of that, the bylaw provides no avenue for any attestation to be reviewed for accuracy and no means for a group to appeal a decision. I fear the bylaw will be putting our staff in an impossible situation, will not have the desired effect of dealing with the safety of religious minorities, and is unlikely to survive a judicial review. I also think that the bylaw may have unintended consequences. In my conversations with community members, I was told about a mosque in Scarborough that was serving women different meals than men when they were breaking for fast during Ramadan. In response, the women protested at their mosque and indeed engaged in techniques such as speaking to congregants as they entered and exited the mosque on the discrimination they suffered, which no doubt made some congregants uncomfortable and would therefore likely run afoul of the proposed bylaw. In the end, the women won and they were given the same meals as men. There have also been more serious incidents in the mosque in my ward, particularly after 9/11, including protesters, and the mosque leadership and congregants worked with police and they used the available laws to keep the mosque and the congregants safe. I, along with my colleagues, stand against hatred, bigotry, and discrimination. In a ward with numerous houses of worship, religious schools, and daycares, I strongly support taking any and all meaningful steps to keep our schools and houses of worship safe. But I do not believe this bylaw, as written, will do that. While well-intentioned, the bylaw is likely unconstitutional and impossible to administer in a fair and consistent way. For all of these reasons, I will not be supporting the proposed bylaw. Thank you, Madam Speaker.
Thank you. Please, no applause. We have time for one more speaker, Councillor Bradford, to speak.
Thanks, Madam Speaker. Through you, job number one of local government is to keep our residents safe. That's our job. That's what people expect, and that's what Torontonians deserve. So today's debate is really about a simple question. In the most diverse city in the entire world, does everybody deserve to feel safe while attending their places of worship, their daycares, their schools, or do they not? For me, it's pretty straightforward. And no matter how much misinformation or spin is propagated by others, I believe that everybody has the right to protection and safety, freedom from harassment, hate, or worse, when accessing their places of worship, regardless of their faith. And yet here we are with a proposal that, as drafted, is set up for failure. Nearly 19 months after we started to see a historic spike in hate, harassment, and intimidation in our own city. Chief Demkew in March came forward with a report that indicated the City of Toronto has seen a 93% increase in hate crimes since October 7, 2023. Not just incidents of hate crimes. And while there's been a rise in reported hate crimes across the board, none of which are acceptable, a shocking 56% of those incidents have been anti-Semitic in nature and targeting Toronto's Jewish community. It seems almost weekly that we have a story about a Jewish-owned school, a business, a community center, a synagogue, a school that is targeted by vandalism and hateful protests. Let me be clear, it's not just a Jewish problem. It is a Toronto problem. It's a problem in this country. It's a problem around the world. But these are not our values as Torontonians. And people across this city and beyond are looking at us in this chamber today to see where we choose to stand. Who is going to stand by and who is going to stand up? The safe access zone or bubble zone concept, it's nothing new. We have it for hospitals. We have it around abortion clinics. We understand and agree broadly about the principle of ensuring safe access without fear or harassment. And I would venture to guess, Madam Speaker, that the same people who are spinning misinformation, half-truths, full lies about bubble zones would run through a friggin' wall to protect them around abortion clinics. And you know what? We should. But it's hypocritical and it's disingenuous to advocate for the safety of some vulnerable people, but not the safety and protection of everybody. This bylaw, as proposed, places the onus on the victims targeted by acts of hate and requires community members to be victimized before being eligible to apply for protection. And that requirement doesn't exist anywhere else at the municipal level in this country. Now, I understand that we have a very thoughtful motion coming forward from our colleague, Councillor Chernos Lynn, who has worked very hard with many of us here in this chamber to advance something that is more effective than what was in front of us, but something that broadly can have support in this council. And I will be supporting her in that motion because it's completely unacceptable to think that as an institution, a community, that they would need to be victimized first before this council would take action. I also will be supporting Councillor Pasternak's motion to increase the size of the bubble zones because, as we heard from our General Manager of Transportation Services, there are a lot of roads and streets here in the city in excess of 20 meters. I believe that the bare minimum we owe the residents here in Toronto is to show that we take their safety seriously. And for 19 months, this chamber has debated, deferred, and delayed. And it's a fundamental failure of the leadership in this room. It is a dereliction of our duty as elected officials to stand up for people who are vulnerable and have been subjected to hate and intimidation. We saw that again right now from everybody who voted for the deferral. More of that. And it's honestly, it's so disappointing. But it's never too late to do the right thing. So I urge this council to pass the amendments coming forward from Councillor Chernos Lynn to make this bylaw less bad and to ensure that it actually stands a chance of being effective to protect the people who need it. Thank you, Madam Speaker.
Thank you. Okay, members, we'll recess to 2 o'clock for lunch. 12.
Count you for quorum. Thank you.
Council, please take your seats because we do need quorum. Councillor Crescenti, can you come back to your seat? This meeting is now resumed. Members, I have reviewed a number of urgent motions without notice to be added to the agenda, but only if we have 18 members. Okay, so it looks like we don't have 18 members, so we can introduce these motions. Oh, here's one more. How many more do we need? One more. We need one more councillor. We'll have to do the members' motion later then, because we don't have members of council at their seats.
Caruso's here. Yeah. Are you counting me?
Okay. Okay. Okay, so I believe we have 18 to add, and then we'll go to the members' motions run through. Councillor Cheng? All right. Councillor Crescenti.
Oh, yes, Speaker. So thank you. I have a motion without notice that's urgent for a request for a city solicitor to attend the Toronto local appeal body to appeal a committee of adjustment decision. Can that be dealt with right now, Speaker, or just add it?
When we go, we're just adding it right now. On
Okay.
favor?
All right.
Carried. Okay. Councillor Chernis Lynn, you have a motion that you want to introduce? 11 Oswald Crescent.
Yes, Speaker. This is an urgent request for the city solicitor to attend at the at TLAB, and the city solicitor, thank you, sorry, requires instructions to obtain party status in the appeal and subsequently attend this hearing.
Okay, thank you. On favor? Carried. Okay. Yes, just wait till I get to it, Councillor Fletcher. Okay, so that's it for the adding on to the motions. And before we start the member motion run through, I would take the release of holds. The clerk will open the speakers list in CMP and you can place your name on the list. Councillor Fletcher.
Thank you, Chair. I'm just going to release GG 21.19 overview of security practices for employee access card photos. Had my questions answered.
Okay, Councillor Fletcher's releasing GG 21.19. On favor? Carried.
I have CC 30.7. Report on options available when incorrect facts or legal advice is presented to council by an accountability officer. I'm deferring that until our Chief People Officer has a chance to pair her report up. And I believe that clerks have that motion to Q4 2025.
Councillor Blair, I didn't hear that. Are you releasing that?
No, I'm deferring it. I have a motion for that, Chair.
Screen.
Yes, thank you.
There it is on the screen.
It's defer consideration till the time as the Chief People Officer has completed the review on human rights, which is expected in Q4 2025. So though both of those items would come together at that time.
Okay, on favor, carried. Thank
And then
you.
one more, which is IE 21.8. And I think you tried to release that, Councillor Perks, it's your shuttle. But I just have a 21.8. The Unwin Avenue Bridge. Sorry, I don't have the shuttle one ready yet.
Which?
IE 21.8, Unwin Avenue Bailey Bridge Replacement Study.
Okay, so you're releasing?
No, I have a motion for that.
Okay. There it is on the screen by Councillor Fletcher.
General Manager, in consultation with the local councillor, the impact of ongoing challenges with the Bailey Bridge and the Bascule Bridge for all those permit holders in Parks and Rec.
Okay, on the amendment, on favor, carried. Item is amended, on favor, carried.
And I'll have another shortly. Thank you.
Councillor Pasternak, quick release.
Yes, I'd just like to defer NY 23.28, Menizer Road parking restrictions to the next scheduled council meeting.
I'm sorry, what number was that again?
That was NY 23.26. And just defer that to the next scheduled council meeting. Menizer Road, yes. Oh, I'm sorry, 23.28. Menizer Road, yeah.
On favor, carried. Thank you. Councillor Morley.
Thanks, Madam Speaker. I hope colleagues have had a chance to take a look at IE 21.2, recommended strategies to address prematurely failing water meter transmission units. There is a confidential motion that I've worked closely with staff on and would happily release that pending moving that motion, unless councillors have questions or concerns.
Okay, so we'll put the motion on the screen. There it is on the screen. That's on IE 21.2 by Councillor Morley. On favor? Carried.
Thank you. That's all.
Okay, Councillor Fletcher.
And I believe the staff do have the motion for GG 21.9. I'm sorry.
On the last item is amended. On favor, carried. Okay, go ahead, Councillor Fletcher.
Thank you. GG 21.9, the Hyde Park Shuttle, and this is about the Tommy Thompson Park Shuttle, which is, pardon?
Yeah.
Oh, okay. Happy to have that. Sure, great.
Okay, thank you. All right. Now, members, the city clerk has advised that the financial impact summary sheet for member motions MM 30.1 and MM 30.29 from the chief financial officer and treasurer has been posted with the agenda item RM 30.7 review of the order paper. Okay, so we'll go through members' motion at this time. We'll wait till the motion gets on the screen, which is MM 30.1. Notice if this motion has been given. This motion is subject to referral to the executive committee. A 2/3 vote is required to waive referral. On favor of waiving referral? Carried. On the item, on favor? Carried. MM 30.2. Notice if this motion has been given. This motion is subject to referral to the executive committee. A 2/3 vote is required to waive referral. On favor of waiving referral? Carried. On the item, on favor? Carried. MM 30.3. Notice if this motion has been given. This motion is subject to referral to the executive committee. A 2/3 vote is required to waive referral. On favor of waiving referral? Carried. On the item, on favor? Carried. 30.4. Notice if this motion has been given, this motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.5. Notice if this motion has been given, this motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.6. Notice of this motion has been given. This motion is subject to referral to the Economic and Community Development Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, hold. Item has been held down by Councillor Perk. 30.7. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.8. Notice of this motion has been given. This motion is subject to referral to the Infrastructure and Environment Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.9. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.10. Notice of this motion has been given. This motion is subject to referral to the Infrastructure and Environment Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.11. Notice of this motion has been given. This motion is subject to referral to the Economic and Community Development Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.12. Notice of this motion has been given. This motion is subject to referral to the Infrastructure and Environment Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.13. Notice of this motion has been given. This motion is subject to a reopening of item 2024, i.e. 14.4. A 2/3 vote is required to reopen the item. If reopened, the previous council decision remains in force unless the council decides otherwise. All in favor of reopening the item? Carried. On the item, all in favor? Carried. 30.14. Notice of this motion has been given. This motion is subject to referral to the Infrastructure and Environment Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. 30.15. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. Recorded vote.
Councillor Perruzza, are you present in the meeting? I received a vote for you, but I don't see you on camera. Thank you. The motion to waive referral does not carry. The vote is 7 to 17.
MM 30.16. Notice of this motion has been given. This motion is subject to referral to the North York Community Council. 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, all in favor? Carried. MM 30.17. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item. Well, I don't know. Does the staff have your technical amendment? Okay. If you want to present your technical amendment.
Just moving it.
Just stand by, Speaker, while we bring that amendment up.
The amendment's on the screen. All in favor of the amendment? Carried. On the item as amended? On favor? Carried.
Definitely.
MM 30.18. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. On the item, on favor? Carried. MM 30.19. Notice of this motion has been given. This motion is subject to referral to the Economic and Community Development Committee. A 2/3 vote is required to waive referral. All in favor of waiving referral? Carried. Recorded vote. Okay, recorded vote. A recorded vote on waiving referral.
Councillor Bradford, please. The motion to waive referral carries. The vote is 22 to 2.
Pardon? You want to hold? Okay. MM 30.20. Notice of this motion has been given. This motion is subject to referral to the Etobicoke York Community Council. A 2/3 vote is required to waive referral. All in favor of waiving referral? But is it not incorrect? It's not Etobicoke York Community Council, is it? Oh, on mine it says Etobicoke. On mine it just says Etobicoke. Yeah, I'm looking at 20. It just says Etobicoke. Okay. 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 Yeah, but I'm just reading what's here. Okay. All right. I was wondering why. Okay. Okay, recorded vote on waiving referral. No, on the item. Is it on the item or? Oh.
Okay, stand by, members, while we cancel the previous vote. The voting panel is now open, Speaker.
So this is a recorded vote on the item, correct? Yes, okay.
Councillor Chernislin, please. The item is adopted. The vote is 21 to 1. Speaker, I'm sorry, we missed Councillor Matlow's vote. The item is adopted. The vote is 22 to 1, including Councillor Matlow in the affirmative.
Okay, thank you. MM 30.21. Notice of this motion has been given. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. On favor of waiving referral? Carried. On the item, on favor? Carried. MM 30.22. Notice of this motion has not been given. A 2/3 vote is required to waive notice. This motion is subject to referral to the North York Community Council. A 2/3 vote is required to waive referral. This motion has been deemed urgent by the chair. On favor of waiving notice? Carried. On favor of waiving referral? I only see two hands. On favor of carried. On the item, on favor? Carried. MM 30.23. Notice of this motion has not been given. A 2/3 vote is required to waive notice. This motion is subject to referral to the Executive Committee. A 2/3 vote is required to waive referral. This motion has been deemed urgent by the chair. On favor of waiving notice? Carried. On favor of waiving referral? Carried. On the item, on favor? Carried. MM 30.25. Oh, 24. Thank you. So you caught me this time. But I'm going to show you on the other one that I was right. Okay. MM 30.24. Notice if this motion has not been given, a 2/3 vote is required to waive notice. This motion is subject to referral to the Economic and Community Development Committee. A 2/3 vote is required to waive referral. This motion has been deemed urgent by the chair. On favor of waiving notice? But if you want to hold it, hold on. If you want to hold it, we have to introduce it first. Okay. On favor of waiving notice? Carried. No, I have to do the referral. On favor of waiving referral? Carried. Okay, Council. Well, I think that Councillor Perks was the loudest. Well, you can both speak on it. Doesn't matter who holds it. MM 30.25. Pardon? But we haven't introduced it yet. Okay, this motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agendas before council for debate. So, Councillor Candeval, you're holding it, right? All right, I'll put your name down. MM 30.26. This motion has been deemed urgent by the chair. This motion is not subject to vote to waive referral. This motion has been added to the agendas before council for debate. On the item, on favor? Carried. MM 30.27. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda before council for debate. On the item, all in favor? Carried. MM 30.28. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion is subject to reopening of item 2024 CC 23.8. A two-thirds vote is required to reopen the item. If reopened, the previous council decision remains in force unless council decides otherwise. On favor of reopening? Carried. On the item, on favor? Carried. MM 30.29. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda before council for debate. On the item, on favor? Carried. MM 30.30. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion is subject to reopening of item 2024 GG 18.23. A two-thirds vote is required to reopen that item. If reopened, the previous council decision remains in force unless council decides otherwise. On favor of reopening? Carried. On the item, on favor? Carried. MM 30.31. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda before council for debate. I'm hearing people talk. Who's talking? On favor of the item? Carried. MM 30.32. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda and is before council for debate. On the item, on favor? Carried. MM 30.33. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda before council for debate. To the agenda and before council for debate. Recorded vote.
Councillor Cherneslin, please. The Councillor Myers, are you present in the meeting?
No, I don't see him.
I'm here. Yes, I voted. Sorry, just have my camera off.
Councillor Myers is in the meeting. Okay, thank you. The item is adopted. The vote is 24-1.
MM 30.34. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agenda before council for debate. On the item, on favor? Oh, I'm sorry. They didn't put the, I apologize. Okay. I thought it was on the screen. Sorry. Okay, it's on the screen. Is everybody okay? On the item, on favor? Carried. MM 30.35. This motion has been deemed urgent by the chair. This motion is not subject to vote to waive referral. This motion has been added to the agendas before council for debate. On the item, all in favor? Carried. MM 30.36. This motion has been deemed urgent by the chair. This motion is not subject to vote to waive referral. This motion has been added to the agendas before council for debate. On the item, all in favor? Carried. Councillor Candeval, you need to be at your desk when we're voting. MM 30.37. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agendas before council for debate. On the item, all in favor? Carried. MM 30.38. This motion has been deemed urgent by the chair. This motion is not subject to a vote to waive referral. This motion has been added to the agendas before council for debate. On the item, all in favor? Carried. So the other motions that we did add on, we'll deal with them later because it's not. Or can we deal with it now? Oh, that's what I'm saying. We'll deal with it later. Yeah. All right. So we'll now go back to the item we were dealing with before lunch. If we can put the speakers list. Okay. Our next speaker is Councillor Chernislin.
Thank you. As has been mentioned, I am moving a motion to amend recommendations 3 and 4 and add a new recommendation that does a number of different things. It recommends requesting emergency services to work with property owners to establish safe access plans as needed. It also moves various changes to improve the bylaw, most importantly to streamline the overly bureaucratic access area request process, to remove the requirement to be victimized within 90 days to reduce the burden on victims, as well as clarify language around co-located facilities, permitted behaviors, and enforcement. I want to underscore that this motion is the product of a collaborative effort among so many councillors, and I would like to thank everyone who helped us pull together these reasonable improvements to provide needed clarity and refine the proposal that came to us from staff. It was encouraging to have so many people, all with different perspectives, come together to try to make this bylaw better. I'd also like to thank staff for bringing this report forward. I know that an immense amount of work has gone into this report, and it has not been without its stresses. Yesterday, a broad coalition of faith leaders shared their full support for the implementation of a bylaw, but they highlighted a few key points of concern with the proposal before us. Some of them mentioned the 20-meter distance, which is far below other cities, and that still remains the same in the motion that I'm putting before us today. I know there are other motions that deal with that. But importantly, and I think this is most important, the requirement to have been victimized within 90 days before requesting an access area, this we are addressing in this amendment, and I think that's very important. I also think we've streamlined things, and one of the things that struck me when we first read this bylaw was that it was so bureaucratic and complex in order to figure out how to opt in. It felt like just more layers of bureaucracy, and I think that's something that I know I hear a lot from my communities about challenges they have with the city. So I think this is an important piece that we've done today in this bylaw if it's adopted. This bylaw is a step towards a safer city where all Torontonians can access critical social infrastructure. Kids can go to school, we can drop off our kids at daycare, and people can practice religion at places of worship of all faiths. This bylaw protects all of us. Right before City Council resumed this afternoon, I received an email from a Toronto Catholic District School Board trustee who said that this bylaw would be truly helpful to help ensure that students can safely access schools when there are disruptive anti-Pride protests. This has happened not just at the Catholic School Board, but in other schools as well. As it stands, school boards cannot do anything when anti-Pride protesters block sidewalks in front of school entrances. And just to clarify, in the motion that we're presenting here, this doesn't change that. Schools would have to opt in order to access that. So it doesn't automatically protect them, but they could opt in if they wanted to. At the end of the day, all we really are doing is creating a buffer to ensure that people can freely access schools, places of worship, and daycares if those institutions opt in. I hope that we can all take this important step together to send a clear message that we will not allow any group to be targeted or intimidated in our city. Thank you.
Thank you. We do have a question for you by Councillor Myers. 3 minutes clarification of the motion.
Thank you, Speaker. Through you, I did have a question on motion.
It's very hard to
F.
hear. Is it possible to speak up?
Is this better? Is this better?
A little bit.
Councillor Perks to speak.
Thank you, Speaker. Councillor Candevel wants to ask Councillor Chernos-Lynn a question.
It's there on mine. Okay. Thank you for the accommodation, Madam Speaker, and through you.
Okay, go ahead.
To the mover, I wanted to get clarity on the language around in which the owner attests that they reasonably believe an activity listed. What is the context for reasonably?
So, they no longer have to attest that they've been victimized in this, but they do have to opt in, essentially. That's the difference, is that it doesn't apply across every single daycare unless that daycare fills out this form, like a form.
Is the spirit of this language essentially that it's
that there's no burden of proof. It's, they apply and they get it.
Well, the thing is, Councillor Candeval, is that even in the original attestation, staff were never going to be able to vet each application. It was merely an attestation. So the idea is that really this is just less paperwork, less bureaucratic in that sense, less work of staff on that end to vet all these applications. So it's really, if you qualify, like you're a school, you're a daycare, you're a faith-based institution, if you're one of those listed things and you wish to opt in, you would fill out a form, I suppose. That would be how it would be operationalized.
And they would then...
But there was never a burden of proof.
Okay. And this is just, your intent is to...
Just simplify.
Simplify, and the applicant would receive the permit, or whatever the term is.
Correct.
Okay.
And the thing is that the thinking behind that, Councillor Candeval, is that when we think about some of our leaders in, like our community leaders in faith-based institutions and childcares, it's complicated and bureaucratic to have to start filling out all those kind of things and figure out all those pieces. So we really just wanted to make it as simple as possible and without people having to be victimized first.
Thank you. Speaker, am I allowed to ask staff a question on, no? Okay. Okay, thank you.
Councillor Perks.
No, there's another question, isn't there? Oh,
Councillor Perks to speak.
Moise wants to speak or ask questions.
His name wasn't there.
It's on mine.
It is now, but they put it on after we go to the next speaker. I don't know. I mean, councillors know what the rules are. Okay, just a sec. Councillor Moy, just a sec. Now it's all frozen now. Okay. Councillor Moyes.
So this is my first time seeing this motion. I'm just wondering, at a quick glance at it, it indicates here that it talks about MLS, it talks about Toronto Police. I'm just wondering, is there a dollar value that should be added to all of this? Okay, it seems that we're adding resources to our city budget. Should there be a dollar value attached to this? Yes, I'm talking.
Yeah, the question was to you. He put his name on last minute. Okay.
Thank you, Councillor Moyes. My understanding is the way we've done this has actually streamlined things in terms of costs, because we've minimized the process involved in applying for this. And so you'll notice that one of the other changes we made was that City Council direct the city manager to manage the in-year costs for staffing and resourcing, as opposed to directing the general manager of transportation services. And so we do think that this will actually cost less than what was initially proposed. So this is a net gain in that sense.
But in here it mentions support by Toronto Police. I mean,
Toronto Police is already supporting every time there's a protest or an event like this. Toronto Police is already there. They're supporting this anyways. So the real change here is that it would not likely cost more. It would probably cost less, and possibly considerably less.
Okay, thank you.
Bravo. 3 minutes.
Thank you, and through you, Chair, to the councillor. So motion 4J removes false, inaccurate, misleading request. No owner shall provide inaccurate, misleading, or otherwise incorrect information. Is that because there won't be an attestation anymore? Okay.
Yeah, it was really a housekeeping note, Councillor Bravo, because once we removed the requirement to be victimized, there was no need to supply an attestation that you'd been victimized. So that really was just a housekeeping piece.
Okay. So the presumption here is that if a person is protesting, that we're assuming that there could be an infringement.
No, not necessarily. The organization has to be one of them elucidated in this, like in the bylaw. So it has to be a church, a school, a faith-based institution. They would have to fill out the paperwork to be an opt-in, and then the bylaw would go into effect. But there are still provisions that allow for peaceful protest, allow for labor negotiations. This is not just a blanket, you can't protest.
I need to ask other questions, and we haven't seen this before, so it's very difficult to understand what's being amended in a very short amount of time. This is a substantive rewriting of the bylaw, correct?
I think the key pieces are simply that we've removed the victimization piece.
But
we've streamlined that process.
No, you said that before, but we are, to be clear, rewriting the bylaw that staff proposed on the council floor at this time.
I don't think it's a rewrite. I think it has been streamlined and it has been amended. I would say amended slightly, but it's not a motion of substitution or anything like that.
Okay. Is there still, I'm finding it really difficult to understand here. So what would be, is there any particular activity that would be not allowable in terms of holding a sign or saying something?
So, I mean, I think the clause that you would be looking to is the one which has stayed the same. Which outlines all the different things that you're allowed to do and not allowed to do. That hasn't changed.
So a protest would be, for example, if a person is holding a residential school survivor says, in this church, this is a Catholic church, I'm sitting outside holding a sign about how harm has been done to me, that wouldn't be allowed in this.
My understanding is it would be, and we did ask about that.
I don't understand how that's possible.
Well,
okay, that
you
was
can
your
discuss
last
with
question.
legal.
Okay, thank you. Councillor Carroll, sorry, at 3 minutes, clarification of the motion.
No, sorry, Madam Speaker. My question was asked. I'm good. Thank you.
Okay, thank you. Councillor Bradford, 3 minutes, clarification of the motion.
Thanks, Madam Speaker. Just a couple questions to follow up on Councillor Bravo's questions there, hoping to help clarify. It was sort of suggested that you're just doing this on the fly here on the floor of council. Have you had an opportunity to work with the mayor's office on these amendments?
So I haven't worked directly with the mayor, but I have worked with staff from the mayor's office, but I've worked with a whole bunch of different staff throughout the chamber.
Right, no, I just want to clarify.
But it hasn't, but yes, this has been a true, what I believe is a collaborative effort of going back and forth on a number of different things.
We worked together on this, Councillor Pasternak, Councillor Matlow, Councillor Cole, Councillor Nunziata, and others.
Yeah,
so
I didn't get everything I wanted.
Yeah.
You didn't.
Right.
Lots of councillors didn't, but most people got, I think everybody got something to see themselves.
But
people who were interested in working on passing a bylaw were
and I just wanted to clarify,
approached.
like, we had various drafts and there was a collaborative process, and as you said, not everybody got everything
Councillor
they wanted.
Bradford, clarification of the motion, please.
So clarification of the motion, though, as we went through the iterative drafts and the draft that is in front of us here today, like the mayor's office has seen this, they've gone over it and they were okay with it. That's your impression?
So, you know what? I can't speak for other, it's hard for me
That's
to.
for your impression.
I think everybody's been really working in good faith to try to get to a place that fulfills the spirit of what we can do from a legal perspective to ensure that charter rights are protected for everybody.
Okay.
And that is what we've come to here. And we've also really tried to make sure that we are doing it in a way that doesn't bog the system down with bureaucracy.
Hope that clarifies this wasn't just thrown together here on the floor.
Thank you. Councillor Sachs, 3 minutes clarification of the motion.
Yes, thank you. First of all, Councillor Cherneslin, thank you for this. You've mentioned a couple of times protection for faith-based institutions. I just want to be clear that this bylaw will not protect faith-based institutions unless they're a house of worship, right? It only protects houses of worship, childcare centers, and schools, nothing else. Right, that's what it says.
Yes, that's my understanding. It has to have something like one of the outlined areas in the bylaw. Only what's in the bylaw can be protected.
Right, which is just houses of worship, childcare centers, and schools.
Correct.
Okay.
It's limited.
All
It's
right.
limited. This is not a wide encompassing, and for people who think that they will not encounter protests in Toronto, in the city, they're wrong. That's not what this covers. It's narrow.
Right, and the acts that are prohibited have not changed.
Correct.
Thank you.
Thank you. Are we ready now to go to Councillor Perks? Councillor Perks. Just one moment, please. Councillor Perks to speak.
Thank you, Speaker. I have a motion. Speaker, essentially what my motion does is authorize the release of the City Solicitor's advice to Council on this at the conclusion of this Council meeting. You'll recall I asked the City Solicitor if she would be okay with that, and she said yes, it wouldn't be prejudicial to our case. This isn't, all of the arguments for how a bylaw was crafted will have to be presented if there's a challenge in any event. Okay, now, on to this issue of the bylaw. The discussion we've had here today has mostly got the history and nature of Canada and the rights Canadians hold upside down and backwards. Canada is not a nice place that had a Charter of Rights and then guaranteed us all the freedoms that we enjoy. That is not how freedoms work. When Canada was founded, the only people who were allowed to vote were males over the age of 21 who owned property. And by the way, if you owned property, you were almost certainly white. So only rich white men were allowed to vote when Canada was founded. The way we got from there to here wasn't by nice, polite discussion. It was by people taking risks, breaking the law, and standing up. Where would Canada be if Viola Davis hadn't illegally sat in the white section of a theater in 1949? Where would women's rights be if Nellie McClung hadn't taken a piece of political theater around Manitoba, earning women the right to vote in this country? What rights would people have to things like a weekend and overtime pay if it hadn't been for the Winnipeg General Strike and countless other illegal protests by labor organizers? It's worth noting that not one but two former presidents of Unifor have been arrested doing illegal occupations of work sites. Where would the rights of Indigenous and Métis people be if it hadn't been for Louis Riel, if it hadn't been for the tragedy of Ipperwash, if it hadn't been for Kanesatake? Every single right anyone in this chamber enjoys was won not by the charter, it was won by protest. Protest is not the enemy of any right that you have. Protest is the means by which that right was won and will be protected in the future. So I don't frankly much care whether this bylaw is charter compliant. I don't much care whether or not the specific niceties of the distance will live through a charter challenge. What I care about is that the foundational principles that give us our rights are won by protest, assembly, and free speech. Every single one of them. No government, no monarch, nobody has ever voluntarily stood up and said, you know what? We should just give people more rights. They're always won by protest. There's been a suggestion that we are somehow taking away the rights of one group to protect the rights of another if we allow protests to happen. And there's been conversation about faith-based institutions. Here's what your bylaw will do. There have been protests in front of churches multiple times by survivors of the residential school system. They have gone and sat on the steps of churches and encouraged people not to go in. If you pass that bylaw, you are saying they are wrong. Now, here's the thing that is so hard about allowing for protest, supporting protest. If you support protest, you have to support it for people you disagree with too. I once, as a member of the library board, got into very big trouble for standing up for the right for someone to talk about something and say some things at a library that I utterly despised. I despised everything that person wanted to say. But I knew
5 seconds.
that if you didn't protect them, the consequences would be what we're seeing in the United States, where librarians are being fired for putting books on shelves and allowing LGBTQ performers to perform in libraries.
Thank you, Councillor Perks. Your time is up. Please, no applause. If it continues, I'll have to ask you to leave. Thank you. Councillor Matlow to speak. Yeah. Councillor Sachs to speak.
Thank you, Madam Speaker. Dear colleagues, with all due respect, a lot of what you're hearing today is irrelevant to this motion. Nothing in this bylaw stops people from protesting. And contrary, you've been told this is about Gaza. Nothing in this bylaw is about Gaza. It is clear from the decision of the British Columbia Court of Appeal that the Supreme Court backed by not hearing an appeal, that it is consistent with the Canadian Charter of Rights and Freedoms to have small areas where certain kinds of harassment are not allowed. People can still protest in 99.9% of the city, and they do. We have a policy of tolerating large groups of masked people marching through Jewish areas just because it's a Jewish area. And that's not legitimate. It is perfectly legitimate to protest the conduct of a foreign government, and there are many despicable foreign leaders. And I would certainly put Putin and Trump and Netanyahu on that list. And it is perfectly appropriate to stand in front of their consulates and stand in front of their official institutions and protest the conduct of that government. What is not legitimate is to use the excuse of a foreign war that Toronto Jews did not start, do not control, cannot stop, to intimidate toddlers, school children, people going into a synagogue. And that is what has been happening in this city for the last 18 months. My community has never been less safe in Toronto since 1933. when the Mayor Stewart stood up to say we would not tolerate the swastika in Toronto, which was being used to intimidate Jews. And here we are today with more swastikas throughout my ward than has ever occurred since 1933. That's the world we live in right now. We also have to take into account that there is a real distinction in the impact on different communities. I don't know of any community in the city other than Jews who have to have 4 large armed security officers to have a school concert. I don't know any religious community in Toronto that has to have guards, multiple guards, to have a prayer service or a daycare. This is a specific problem directed at the Jewish community by organized groups over and over again since the war began with an invasion in a foreign country. So we have this bylaw won't resolve the widespread intimidation of the Jewish community. It won't stop the mobs chasing people off skating rinks like happened in front of City Hall. It won't stop the vandalism of synagogues. It won't stop the shooting at schools. But at least it is a tiny step, a very tiny step, to say that there is a small piece of this city at the very door to a daycare, at the very door to a school, at the very door to a synagogue, where somebody like me with a kippah can walk in and walk out and have the screaming people a little distance away. They're still wearing their masks. They still have their placards. They still have their loudspeakers. But I'm not a captive to them in very close quarters, which is exactly what the British Columbia Court of Appeal said is consistent with the Charter. People can still protest. There is nothing here that stops people protesting. It just stops them intimidating minority communities in the city. It's a tiny step that matters. It's the first tangible action by this council since October of 2023 to show that the Jewish people are welcome in Toronto and deserve some protection. And that's all we do. Now, we've heard a lot about cost. Yes, there's 3,000 schools and daycares and childcare centers in this city, but very few of them are threatened. Very few of them are needing to pay for private security. This is a very narrow issue. I'm delighted to hear that it can also be helpful to the Catholic schools. I'm delighted to hear that it can also be helpful for other religious minorities when they're having difficult times, as the Muslim community did. But in this case, we need to deal with a pressing and substantial problem. And I will say it's easier and cheaper to enforce when there's a clear boundary. So please support Councillor Chernes-Lynn's motion.
Thank you. Able to speak.
This is a very distressing day for many reasons. First of all, because we've received a rewritten bylaw that we're making a Franken bylaw now. It hasn't had the benefit of study by staff. In fact, what you heard before is that the staff were never ordered to look at or directed to say, do we need this? In the answer to my administrative inquiry about necessity, how did we assess that trespass notices, the criminal code enforcement by police, the bylaw enforcement by municipal licensing and standards is insufficient? That question was never asked or answered. How do we know that we need this bubble zone bylaw? It is because people feel afraid, and I am not going to discount that fear. I'm not here to judge how people feel. But I am going to say that it comes at such a substantive cost to all of us. Because I think what we need to recognize is that the Charter of Rights and Freedoms is not just for one group, it's for everyone. And while already the case has been made for the social good that is protest, and it is a social good, and the courts have recognized that it has social purpose many times, I'm going to say that it's actually protest that has put a lot of care into our society, because without it, we wouldn't have had attention to injustices. for minorities, for particular communities. I think about my own experience and about how victimization, as my colleague Councillor Sachs has talked about the Jewish community, is a great concern to me, enormous concern. For many, many years, from 1989 until 2005, the Heritage Front operated in Toronto. Do you know who went out there to stop neo-Nazis from recruiting in high schools? Who went out there to confront them and said, not in our city, not in our territory? It was people like me. It was people like other people in this room. Some of you I recognize. You were out there with us. We put our bodies on the line, and I know people that were beaten, stabbed, broken in that process. It was protest, and it was criticized at the time. Who was out there saying Ernst Zundel, the largest publisher of Holocaust denied materials in the world, who lived in Toronto, who operated out of a house on Carlton Street? It was people like me. It was people like many of us who went out there. And sometimes there was 300 police officers to protect that particular house because that was the prevailing notion of the day. But we wanted to have hate laws enforced. We wanted to make sure that when we talk about hate crimes, that it included specifically incitement to genocide and anti-Semitism, because anti-Semitism is a real cancer in society that we have to fight, and we have to acknowledge that it's present. What I fear we're losing in this process is that we're devaluing what that means, what that social discourse means. People being able to stand up and say, you know what, there are other injustices in the world, and I want to give speech to that. Why does even disruptive, peaceful protest matter? Because there are other people suffering in this city right now who have seen injustices, whether here or anywhere in the world, and want to hold their governments accountable. Protests are destined to see government action, to change course around particular things, to have Canada, for example, uphold its obligations under covenants that it's signed, international human rights covenants. That is a valid form of speech. It's a useful and important form of speech. What is the alternative? If we shut down the spaces where we see each other as human beings, where we fight polarization by saying, I see your pain and this is my pain, let's talk, let's find a way through this. What are we saying? We're creating more atomization. We don't know each other. We don't see each other. You don't make peace with people that agree with you. You don't build bridges with people that are already on your side. I'm afraid of where we're going. I'm afraid of the dehumanization and polarization is going to grow. And the worst part is that, yes, we've been requested to send a message to the Jewish community, but as many people have said, not that much is going to change. What happens when this is contested and taken to the Supreme Court for a charter violation? What message will that send? I find that solidarity and standing up for each other and standing true for the things that are constitutional in this country are the best line of defense that we have for each other.
Thank you, Councillor. Please use your jazz hands today, please, people. Thank you. Councillor Cheng.
Thank you, Madam Speaker. Hate is deeply corrosive, but the reality is that hatred is not in itself illegal. And that makes it really hard to confront using the legal tools that we have. We live in a time when our society is growing more polarized and the fabric of civil discourse is fraying. I don't believe that any child going to a school or daycare or any individual going to their place of worship should have to endure hateful words, whether or not these words meet a criminal legal threshold. That's why a bubble zone can be a practical tool. They create a necessary boundary not to silence opinion, but to protect people, especially vulnerable people, at their most sacred and personal moments. In recent months, many members of the Jewish community have shared that they feel like the city is sitting on our hands while they meet with escalating hostility in their daily lives. Jewish people represent 4% of our population, yet they were the target of 40% of hate crimes in 2024. This is not a statistic that we can ignore. The surge in hate crime has left many in the Jewish community feeling exposed, anxious, and unsafe. This policy is about more than enforcement. It is a statement. It says to our Jewish neighbors, we see you, we hear you, and we care about your safety. We will not sit on our hands. No cultural or religious community in this city should be held responsible for the actions of governments far away. I, too, am devastated by the images of suffering, by the deaths and starvation of Palestinian women and children. These are not abstract tragedies, they are human ones. And every person, regardless of where they live, deserves to live in security and in peace. We must find a way to express our grief and our anger, as well as our hope for justice, in ways that do not descend into hate, harassment, and vandalism. That is not who we are, and it cannot define our city. This moment calls for courage, not just to condemn what is wrong, but to build what is right. We need more dialogue, more understanding, and more space for empathy. We must commit to humanizing one another, especially in the areas where we disagree, because that is the only way that we can move forward in a city as diverse and extraordinary as ours. We can take a stand against hate and still stand for justice. We can protect one another without losing our voice, and we can make this city safer, stronger, and more united if we choose to do it together, and it is a choice. I agree very much with my fellow councillor, Alejandra Bravo. We really need to talk to each other. We need to listen to each other. There is so much pain in this room, and I imagine the many who are watching today's meeting. For many, they feel like their identity and their safety is on the line, while others fear that their voices are going to be silenced. These are big issues, and we are not going to be able to solve that if we stand at different sides of a room. So no matter where this goes today, I hope that we can find a table where we can sit together, acknowledge the pain and grief of different viewpoints, and find a way to be the excellent, diverse, good city that Toronto is known to be. Toronto the good. Let us call out the good in each other and be united against hate, be united against violence, be united against suffering. We can find that way, and I believe in us as a city. So I hope that we can find a path forward today, regardless of how we move this motion. But I do think that we should support our Jewish community to feel safe in the areas where they are most vulnerable. Thank you.
Thank you, Councillor Cheng. Councillor Burnside, you are next. Please give me a second.
Yeah, thank
You're
you, Madam
online.
Speaker. Can you hear me?
Correct? Yes, I think we can.
Okay, thank you. Madam Speaker, we've heard the social good of protests, and I don't think anyone's going to deny that. But no one has been able to articulate the social good of harassment. And there's a clear distinction between protesting what any particular government is doing and targeting people because of their faith. And that's what it's the conflation of those two things what has me very concerned regarding this debate. Like somehow Jewish people are responsible for the current government in Israel. That's stereotyping at its worst. And in many cases, I think it's just an excuse to be anti-Semitic. Back to my point, there's a big difference between the social good of protest and any good that could come out of harassment. Thank you.
Thank you.
Okay, well, are there any speakers? You put your name on the list because we just have one more for Councillor Matlow. If anybody else wants to speak, please put their name on the list. Okay, Councillor Fletcher to speak. And just give me a minute because the screen gets frozen, so just one sec. Okay, go ahead.
I'll just be very brief, and I've listened to a number of speeches today, and this is a very difficult debate for everybody. I want to be clear that if I don't support the bubble zones for potentially 3,000 locations in the city of Toronto, that somehow I'm for hate. I've never been for hate. I have fought against hate in the city of Toronto as long as I've lived here, basically for my life. And I don't want to indicate, to have it said that if I don't support that, I don't stand against hate. I think that's a very important thing to say, because a number of councillors have intimated that if you don't support this, we have to take a stand against hate with these bubble zones. I don't support hate. Nobody here supports hate. We have a difference of opinion as to how effective this will be, as to whether it's overstretching, as to whether or not the police already are there and very capable of managing the most extreme moments that we're experiencing because of a foreign war that is finding its way and seeping into this society, that there are a small number of people that are engaged in this activity, that each one of us, when there's anti-Semitism, anti-Semitic symbols anywhere in our ward, anything, we are on that. I think everybody needs to know that. At least I am, and I'm assuming everybody else is as well. So that's all I want to say, Speaker, here today. Please don't confuse my position on civil liberties, on 3,000 locations, with somehow that I don't support, that I am somehow part of those who hate. I'm not. I do always take a stand against hate. I take a stand against discrimination. I take a stand against racism. I take a stand against anti-Semitism. I take a stand against Islamophobia. And that's who I am and what I've always done. I may have a different way to do it, so please don't paint me with that brush if I don't support this bubble zone today. Thank you.
Thank you. Councillor Crisanti to speak.
Yes, Speaker, thank you. This certainly is a very important topic. We've been discussing it for many hours today and, of course, for many months prior to today. We've got a couple of good motions on the table. One is Councillor Pasternak, who's moved a motion to extend the perimeter to 100 meters, failing that 50 meters. I think that's a critical motion. You know, we need to, if we're going to have a bylaw, it's got to be a bylaw that actually truly makes an attempt to create access, but still allow the protesters, anybody that has a point or a voice they want heard, the ability to do that, because that also is very important. But I also will support Councillor Turnus Lynn's motion, who she's done a good job with, how can I put it, cleaning up the motion in terms of ensuring that you eliminate some of the red tape and you make it more universal and equal. The attestation is something that is important, that is dealt with in the way that Councillor Turnus Lynn presented it in her motion. Protests by their nature are intimidating. People don't realize that. Not that they could be peaceful, but when you have a group of a large number of people, it doesn't have to be a large number of people, it could be a smaller group of people, by standing by a place of worship or school. There's my own constituents that tell me they feel intimidated. They tell me all the time that, you know, they're concerned about taking their family downtown because of the number of protests that constantly happen in the downtown area. We just heard earlier, there's close to 700 protests just in 2024. So now we're in 2025. We don't know where that number is going to land. So freedom of movement without restriction and without intimidation is important. I ask my colleagues to support the two motions, and let's get on with this vote. Thank you.
Thank you. Councillor Cole to speak.
Yes, thank you. I think it was Councillor Sachs mentioned the 1933 Christie Pitts riots and saying this was the worst situation of anti-Semitism we've had since then. At least the Christie Pitts riot per se was pretty truncated and very short-lived. Luckily, the immigrant communities of Toronto rose up and defended their Jewish friends and neighbors, and it was a very short-lived rise of ugly pro-Nazi sentimentism that was in the streets of Toronto. But what has happened again since October a couple of years ago is that there is really escalated form of systemic attacks of all degrees on people in Toronto who happen to be Jewish. And not to say there haven't been other acts of hate against other communities, Asian community, the Muslim community, those are abhorrent. And yes, the constant attacks on people that happen to be Black in Toronto, which still goes on too frequently. The critical thing here is that there has been this unprecedented escalation. And this escalation has really frightened people, has intimidated people, has made members of the Jewish community lose faith in government, lose faith in Canada, lose faith in Toronto, Ontario. So we have come to a point here where we as city councillors have been forced to try to reassure the Jewish community, especially of Toronto, that we are trying to do something to stem this wave of hate and anti-Semitic violence. I certainly have been calling for the Missing in Action provincial government, who has done zero to help Toronto, to help the Jewish community. They've done zero. The so-called Attorney General, Downey there, he's totally missing in action. Nobody calls him, or there's been no debate in Queen's Park about this systemic hate. Zero debate at Queen's Park. Yet we have had to fill the gap. We have to step up and do something. And it is bylaw. Unfortunately, that's all we have at our disposal. It was bylaws. Asking our bylaw department to deal with the, please, could you stop this conversation here?
Go ahead, Councillor Cole. Councillor Cole. Councillor Cole.
How about the councillors who are disrupting the
Oh,
proceedings?
I'm sorry. I put your time on hold. Councillor Sachs, please. Okay, go ahead, Councillor Cole. I did put your time on hold. Yes.
But anyways, so in light of the fact is we have a missing in action provincial government and an Attorney General who does zero, we have had to basically go through these machinations of grappling with this incredibly challenging problem. As a city councillor trying to deal with bylaws where people would get fined for undertaking these abhorrent acts. So it would be great if the federal government did something, as Councillor Moy said. It would be great if the province isn't going to do anything. We know that. So we have this very awkward tool called bylaw. But it's really all we have to show our Jewish friends and neighbors and constituents that we are trying to protect them, so at least they can go to their synagogues, their shuls, their schools, their daycare centers, and not be afraid to go, and not to have all these security guards, etc. That's the least we can do here today. And I just say one thing, just do not support Councillor Perks' motion, because I think what that motion does, because we've changed the bylaw, it could jeopardize our case if we have to defend this at a higher level, because it might not be essentially the original bylaw. So do not vote for that, because it does jeopardize future challenges we may face as a city council if this proceeds. Thank you.
Thank you. Okay, so does anybody else want to speak? Are you ready, Councillor Matlow? Councillor Matlow, are you ready? Okay, just one sec. Just give us a minute, please. And if anybody else wants to speak, please put their name. I'm going to close the speakers list. Okay, there was one more name, so Councillor Morley, then we'll get you, Councillor. Councillor Morley, go ahead.
Thanks, Madam Speaker. And yes, happy to add my voice to this conversation. And it's been a difficult one, as was mentioned by many of my colleagues. I appreciated the words and sentiments from Councillor Fletcher on the challenges. I know many of us have met with and heard from folks within the Jewish community, specifically in Toronto, who are feeling targeted. We've also met with folks from the Muslim community and other communities, wider communities, who have a lot of different interests in what we do here today. I am someone who has previously taken a strong position and gotten myself in a bit of trouble for supporting the right of Torontonians to protest. And it's something that I continue to stand by. We heard from Councillor Perks about the value and importance to the society for us to be able to have the abilities to have our voices. And I know about the incredible hard work of our members of the Toronto Police Services, who have been engaged and active and dedicating resources and doing everything that they can, holding space with members of all communities to make sure that we as public servants are doing the best that we can for folks to feel supported and safe through really difficult times. That being said, I think when we hear comments like what's happening in this conflict is not connected, of course it is. It's the reason for the protests, right? And it's the reason people are showing up and showing solidarity one way or the other. And so we can't separate ourselves from, we are interconnected beings. We're all connected to this planet. We're connected to each other, whether we share the same skin color, religion, or otherwise. We have a responsibility to one another to ensure that we are holding space for justice and for speaking truth to power. And what I want to really say specifically here is there has been a conflation. My colleague, Councillor Burnside, talked about how we're conflating harassment and different pieces like this. There are laws on the books to protect us. They are good, they are strong, and they are being enforced. And I want to encourage people who don't feel empowered to complain or to bring forward their concerns to participate, because that's the data that drives our decision making. But to say that, and what has been a consistent message, that any protest, peaceful protest in support of Palestine is anti-Semitic is not true. And again, I do not condone targeting, harassment, or any of that as it relates to calling out members of our brothers and sisters in the Jewish community in Toronto. That is not acceptable. But it is not true to say that every protest that is standing for the rights and freedoms of Palestinians who are being subjected to atrocities is anti-Semitic and anti-Jewish. And I think we have to very carefully walk this line. And I'll leave it there. Thanks, Madam Speaker.
Thank you very much, Speaker. I wasn't going to speak on the issue only because so many of my colleagues have already spoken, and they have spoken in a variety of different ways and so on. But I thought I would lend my voice to this issue. I asked a series of questions of the solicitor and also the city manager earlier because I do believe in the right to protest, but I also believe in the fundamental right for people to feel safe and to be safe in our city. We have an obligation as a body to ensure that everyone is safe in the city. And while there are certain international situations that are taking place that are basically not in our own doing, in our own responsibility and so on, they have nonetheless visited our shores. And it's certainly appropriate for people to feel a particular way and to allow their voices to be heard. But what is actually important to this discussion is that there needs to ensure that those who are impacted by actions by others are being at least respected, and we are, as a body, responding to the challenges. Speaker, I've had several members of the Jewish community who have spoken to me. Most recently, I had a doctor who told me that after 7 o'clock, he and his family does not go anywhere downtown. They try to ensure that they avoid large groups of people because they feel unsafe. I've had many others who have informed me of that fact. And when I wake up on numerous mornings and I've heard about shootings at a particular establishment that happens to be a Jewish business and or an institution, it is actually a great problem, a concern for me. I would feel the same way if a shooting occurred in any other groups or to any other groups or any other culture. But I know that it's really important for us to take a stand today. I don't want to wait for the federal government to actually take a position on this. I think that we have an obligation. I certainly want to commend Councillor Bradford and others and from the community, Councillor Sachs, Councillor Chernus-Lynn and others and so on for the work that they've actually done. I also want to commend our staff. They have been able to, take a fine line with respect to their approaches in terms of balancing the ability for peaceful protests and the right to assemble. But when those protests has an effect of creating an endangerment to a community or neighborhoods in terms of where you try to create a siege for the neighborhood, it happens to be Jewish neighborhoods, I think we have to stand up to respond because it's undeserving. It shouldn't happen in our city. There's nothing wrong with someone coming forward and saying, I'm concerned about things that are taking place that are not within our control. But what is within our control here in this particular chamber is to ensure that community is safeguarded, that community is protected with resources as any other community, Italian community, Black community, Muslim community, or any other community that are under siege by others and so on. We have the ability to do something about it. The actions that we're taking here today demonstrate that. And so I don't think we walk away and step away and say, do nothing. We know that what's being proposed does not restrict the ability for people to assemble and to voice their concerns and so on. However, it will not be done in fear. It will not be done with violence. It will not be done with the nature of how some of the activities have taken place in our city, where we talk about diversity being our strength. We don't want to see a situation where people seem to think that a group of people could be vilified because of certain things that are taking place elsewhere that they have no control over. And we're talking about religion, we're talking about culture. And so what we have to then talk about is ensuring that members of our community who feel that their safety is at risk, that their community is under siege within our community, that we take the responsibility to take actions to do something to help them. We don't want a young Jewish child being affected by gun violence or anything. We don't want a young Muslim child to be affected by any of those. We don't want any of our young people to be, or anybody to be affected that way. And it is happening. It has to stop. doesn't stop it, but it actually helps, in my view. Thank you.
Thank you. Okay. Councillor Matlow.
Thank you, Madam Speaker, and thank you to the clerks for working on this. I have a motion, which I'll outline to you. I came in here wanting to support something because we have a Jewish community that is collectively traumatized by decades and decades of pogroms, a Holocaust, and the massacre of October 7th, who is looking to their leaders to provide protection and support, and don't feel like they have that yet. I want to support something, but I can't just support something performatively. It's got to be something that I actually believe is real. It also has to be something that while we protect every community, we need to protect every community's charter rights. So this motion gets rid of the bureaucratic nonsense. It doesn't have transportation services provide some sort of opt-in. It doesn't pretend that they are detectives, nor does it suggest, with all due respect, that our municipal licensing and standards officers, who can't break up a house party without calling the police, should be the ones to deal with protesters. That is a police matter, and we have criminal codes that they already are meant to use and effectively enforce. That's where it properly belongs. Now, I moved a motion when we asked the city manager to come back with a bylaw for safe access zones to ensure that the words protect charter rights would be in our request. And that was passed 18-4. And what the city manager provided us doesn't comply with the Charter of Rights and Freedom. Now, there's an argument that can be made in some circumstances that yes, the Charter is not absolute, that there are some times where there is a need to keep peace and order, that an infringement is acceptable. But you can't have your cake and eat it too on this one. What I mean by that is that I agree with Councillor Chonos-Lynn, who's done a remarkable job trying to bring people together around an omnibus motion. But the reason that I don't believe in that approach, when I actually had to get real with myself about this, and I believe in what I'm moving now, is because ultimately, if we keep that bizarre, contortionist, bureaucratic mess that was brought to us in the city manager's recommendations, then it is more compliant with the Charter. If we remove that nonsense, then it's not at all. In other words, this is a mess. And it's a mess because it is properly an issue that Parliament needs to address. It is something properly in front of the police to effectively enforce. That's how our system should be working, and we can have an argument about whether it's working well enough or not. But I know we're all feeling pressure, I more than many, to show that we are doing something, to show that we care, that we want to protect our friends and our families and our neighbors. But in good conscience, it has to be real. You know, everyone in the Jewish community who is worried about the shootings at the Jewish girls' school, this bubble wouldn't do anything about it. Everyone who's horrified about what happened in D.C. last night, this bubble wouldn't do anything about it. Everyone who's horrified about hostage posters that have been desecrated in our parks, that bubble would do nothing about it. And everyone who wants to speak, whether it be because they care about the state of Israel, or, yes, even within the Jewish community, stand up and say that what Netanyahu is doing is deplorable. Everyone should have a right to say that. In fact, when a preacher in the Westboro Baptist Church stands up and says homophobic and anti-Semitic remarks, everyone should be able to stand up and say that's wrong. Everyone. And the Jewish community has a very long and proud history of doing that, including fighting segregation and many other deplorable, deplorable things that have been part of our history. So I hope you'll support my motion that I believe both removes the bureaucratic nonsense, the contortionist mess that we received, with all due respect, that's how I see it, but also puts it where it properly belongs, which is the police not only supporting whatever we call the bubble, but also ensuring that the laws of the land are effectively
5
enforced.
seconds.
I appreciate you hearing me out. Thank you.
Thank you. Okay, so Councillor Carroll, you have 3 minutes, clarification of the
Yes.
motion.
Yes, I hope we can go through this quickly. I'm having trouble trying to understand the deletions versus the add-ins. So help me understand the impact of this on the activities as described in the staff's original bylaw draft.
I appreciate that, Councillor Carroll. So to say it really simply, what I'm removing is the whole process of everything. Rachel and I completely agree on this. Like, we shouldn't have the whole 90-day thing, the proof that something happened. We shouldn't even have the opt-in. We shouldn't have transportation staff be administering any type of, even an opt-in application process. All that's removed. What I do add is a compliance with the Canadian Charter of Rights and Freedoms, as we asked the city manager to provide us, which was not in the original recommendations, and ultimately put this toward the Police Services Board, which you chair, to have what I would submit to you as the proper group enforcing laws, rather than, honestly, if my family were in trouble, I wouldn't be calling a bylaw officer, I'd be calling the cops.
Sorry, I only have 3 minutes here. So what I need to understand, though, if council should choose to adopt a bubble zone, we're adding in an except here. It does not prohibit lawful activities, and you've added some phrases, and I'm trying to understand if council should adopt a bubble zone of 20 meters or whatever, does your motion do away with that? Just so we know for sure what we're voting on.
My motion still supports the intention of having safe access zones. What it doesn't do is have an ad hoc opt-in or application process. It removes that. I fundamentally believe that that there are boundaries that we need to be setting at social infrastructure, but they also need to, and this is what this adds, that it complies with the Charter of Rights, and that there's a difference between peaceful assembly and expression and not. And when it crosses the line, it's the police's role to enforce.
So I just need to ask, what we have heard in some of the community comments, if we were to be universal and not have an opt-in clause, that there are some places where, schools, whatever, have worked out their own process and an agreement with their students for regular protest, and they're concerned now that universality here would erupt in a wave of parents saying they want this consideration for their school, when at the moment things are actually at a happy place.
And
that was your
mutual
last
agreement. Are you concerned about that?
Answer the very thoughtful question. And this wouldn't actually have an adverse effect on the universality, wouldn't have an adverse effect on the intention that you just described, because all of what you just described would be within peaceful assembly and peaceful expression.
Okay, thank you. Councillor Chang, 3 minutes, clarification of the motion.
Councillor Matlow, I appreciate your efforts to create a olive branch motion here. What I'm trying to understand, though, is we've heard from Toronto Police Service that even with enforcing hate crime, it's quite a cumbersome process. It goes through the Minister of Attorney General. And so in this scenario now, they're going to be enforcing a bylaw, and we heard that the first step would be education, but are you picturing then that the police would one day apply fines, or what would their role be in the enforcement?
So even in the city manager's recommendations, ultimately, bylaw enforcement would have to call the police in any circumstance that actually would be a situation that needed to be addressed, I would submit to you. So what this is putting it properly where the police's purview, but also the police have said repeatedly that they don't, while they welcome all tools, they don't actually need this bylaw, and most likely they'll never use this bylaw, any of this, frankly, any version, any rendition, because the criminal code, the legislation federally, ultimately is so much stronger and gives them so many tools that and I say this with humility because I'm a city councillor as you are, but city bylaws, frankly, are not what's going to actually protect our communities if a real incident is occurring that is threatening their well-being, their safety, or people are actually being harassed or intimidated.
But uttering hate is not illegal.
No.
So that is why we're going through this process, because there are non-criminal hate acts that become very difficult for police to enforce. And so this is just trying to create a safety barrier for children going to daycare. So I'm just trying to understand, you know, if police are really busy doing the intense enforcement necessary for the situations that you're describing, how are they going to then also expand their mandate then to address the non-illegal hate utterances or hate activities?
Because
that was your last question.
Yeah.
Because the reality is, if something were to occur, that we would need the police's support.
Councillor Mallow, speak in your mic. We can't hear you.
My apologies.
Sir.
If something were to occur that we would need the police's support, for example, at a synagogue, that's where they should be in the first place. The reality is that, well, you know, many fear about many fear that our synagogues are going to be subject to protests that will impede somebody's ability to go and, for example, worship on a Saturday morning. The reality is I can't cite an example of that actually happening in real life. So if that were to happen, then I would want the police there regardless. So why are we going through this nonsense of asking transportation to do an application process, have MSOs be on the scene, when really, if there's an incident that's happening that we're actually concerned about, and frankly that synagogue is concerned about, they're going to want to call the cops. Like, I think any of us would if we're actually concerned about the impact that it's having on our kids or the rest of our community.
Thank you. Okay, you can. Councillor Carroll to speak.
Well, Madam Speaker, I was simply going to speak with my vote, but I have to speak here because I'm disheartened and I have great admiration for my colleague.
Councillor Carroll, sorry, somehow, well, wasn't on my screen, sorry. Okay. No, but are you asking a question? Yeah, he wants to ask a question. So your name was not on the list. I'm sorry, Councillor Crisanti, it was not on the list.
Well, okay. Anyway.
It is now, but it
Councillor
wasn't before.
Yes. So am I okay to go?
Councillor Crisanti, go ahead,
So
yes.
Councillor Matlow,
Yes.
if you could, can you please explain a little more your intent for the part 4 of your motion, the one that reads, the city establish access areas around all social infrastructure as defined in the bylaw that's recommended. Now, are you removing any of the red tape, any application process? People can, if there's a problem, they can directly call who they need to call to get help.
Let's cut out the bureaucracy, cut out the nonsense. To Councillor Cheng's, I believe her point, uttering actual hate under the criminal code is illegal. Being violent is illegal. Shooting at a school is illegal. Any of these acts where harassment, intimidation, I don't believe that any school, childcare, synagogue, gurdwara, mosque, church, any social infrastructure should be subject to that kind of behavior, while I also, and quite equally, believe that we need to protect people's rights to peacefully assemble and peacefully express themselves. Anywhere. But peacefully.
I just needed that clarification. Thank you.
Thank you.
Yeah.
That's it. I don't see any of the names. Oh, Councillor Cherneslin.
Thank you, Speaker. Councillor Matlow, I'm having trouble understanding exactly how this would work. Because really it seems to me that what you're doing is you're narrowing the prohibited behaviors, but you're making it apply everywhere. And
Yes.
what if only parts of your motion pass? How is that, wouldn't that essentially just kill the bylaw?
So I'm moving this is my motion. I want it all to pass. And, you know, a concern that you may have, you'll speak for yourself, obviously, but if your motion passed and if the other motions passed that I expect to be part of any one package, because of what I described as a contortion and things kind of being removed and changed, because it won't be compliant with the charter, it will be thrown out. So in other words, those who will be reassured... We didn't
change any of the charter compliant pieces. None of that was changed.
It has been changed. If you read my motion, I reinforced the compliancy with the charter, just as Council 18-4 asked the city manager to provide us in the bylaw. So what I'm saying is that mine actually wouldn't be subject to a charter challenge and fail the way that I believe the other versions would. So in other words, people might feel better for a moment, but it won't actually do anything, and it won't be effective, and it won't last. What I'm saying is, let's just say we don't want the behaviors that are illegal to be happening at our schools, our churches, our synagogues, at our social infrastructure. When these things happen, the police have responsibility to enforce, and not try to contort and create something at the city level using merely city bylaws. That again, I mean, try calling 311 when you've got a noise complaint. They might come in 5 days a week. I don't know. I mean, that's the reality of it.
So my question then, you know better than what legal, because legal's suggestion was this only be applied where people opted in. And what you're suggesting, this is a blanket statement, so this is much broader than what legal. So I will just say that I am not clear that is, you're not creating a charter challenge with that. I think we should be trusting bylaw.
First of all,
trusting our legal.
Okay, thank you.
So if I may, legal, without speaking to what's in confidential, though I'm going to support, providing to the public, legal wrote to the recommendations provided by the city manager. Their missive did not speak to the changes that are being recommended today. So in other words, we're speaking in a vacuum. And I think both of us should,
Okay, thank you. Councillor Matlow, thank you. There's another question. Councillor Bradford, 3 minutes clarification of the motion, please.
Thanks. I want to focus on 3A here because I think this sounds good as you've described it, but I wonder if actually it might undermine the effort here. And so you're saying delete all the pieces about bylaw, and you're replacing it with city council request, because we don't direct police.
That's right.
Request the police board to recommend to the police service that they enforce the proposed bylaw.
It sounds awful, doesn't it?
It doesn't sound good, and it doesn't sound like it would have the teeth. What would happen if the police board doesn't make that request to recommend, or if the police say no? Then what happens to the enforcement of the bylaw?
So I completely agree with you about how it sounds. I wish I didn't have to write it that way, but as I think you understand, we don't direct the police operations, so I have to write it that way because council needs to make the request rather than order. That's just the way it is. So that's why it's written that way. To your point or your question, it's really no different than if an MSO makes a request of the police to do anything as well. Like, we're always, any of us, whether it be council or our staff, can merely request things of the police, and then they make their operational decisions. So in reality, like on the ground, it's the same.
I agree.
Yeah.
But the way you've written it here, and I appreciate the nuances, we don't direct, we request, etc. But by deleting the fact that we can direct bylaw our own staff to go and do it, which is how this was written, you're deleting that. So that is sort of the fail-safe that we have, because that's within our authority in this council chamber, is to direct our bylaw staff. And you're changing and replacing that with sort of a hope and a prayer, a request to the police board, hopefully to recommend to police, and hopefully they take carriage of this. My question to you on clarification of the motion is, what if they say no? Then what do we do?
So, first of all, to your last question, they can always, of course the police can say no, including to the other variation of the bylaw. In other words, if they don't want to show, if they don't want to participate in this, that's their prerogative, that's what they're going to do. I actually, I've had conversations with the police repeatedly. From what I hear from them, they actually see more assistance in actually using the criminal codes, the existing legislation, and there isn't a lot of purpose
I appreciate
in this,
that.
right?
I get that. I'm just
Okay,
watching
that-
the clock. My last question,
last question.
I actually am just trying to understand.
Oh, the MSO question,
If
though.
they said,
Councillor Matlow, please.
it's just, this is actually important,
Yeah, no,
because
I agree.
I'm concerned that by supporting this, if the police board doesn't make that request, or if they do and it comes back in the negative, you have actually entirely removed our ability to enforce it
Okay.
at all.
I get what you're
because
saying.
You've deleted that.
No, I appreciate, that's a
Okay,
really good
thank
question.
you. That was your last
So
question.
to answer, great, fair
Councillor
question.
Matlow, that was the last
May I
question.
answer it?
We
It's a
have
good question.
Councillor
No,
Holiday.
we both want the answer. Yeah.
Well,
So just very quickly, fair question. No, you'll see, we can't actually tell enforcement not to do it. In other words, if it's a bylaw, they still can. I'm just saying I want to ask the police to do it. So this doesn't say they can't do it.
okay, thank you, Councillor Matlow. We do have other questions. Councillor Holiday? Question.
But it's a bylaw, so I'll come back to you.
Thank you, Speaker. 3D moves directly to apply the access areas around all social infrastructure immediately. What happens if something is happening at one of these 3,000 locations and the people that are there don't have issue with it?
Then nothing will happen.
But then the people that are doing the activity outside could find themselves not in compliance with the bylaw.
But if nobody's actually breaking the law, then it won't be a problem.
No, but this moves to establish the zones.
Yes.
Prescriptively, it just happens.
That's right.
And if the people inside and the owner of the building has no issue with the activity in front, the people that are doing the activity in front could find themselves offside with the bylaw.
If the people doing any activity out front are compliant with the law, then that shouldn't be a problem. And any activity that either is illegal or isn't covered by our Charter of Rights and
Not in
Freedoms,
scope.
that's a different story.
Not in scope. So do you still see this as proportionate and measured with respect to the requirements of the issue that is trying to be solved?
Yes, I don't believe that any place of worship, school, childcare, any social infrastructure should be subject to hate, violence, harassment, intimidation, bar none. Just that is my view, and I would hope you share that. That being said, I equally and fully believe that the Canadians' rights, the Charter of Rights and Freedoms, need to be complied with, and need to be respected and need to be protected. And that's what my motion does.
So your motion is going to establish these zones regardless of the sentiments of the owners of those institutions.
I don't, how about this? I can't think of a single place of worship, school or childcare, that would say that they are comfortable with any illegal activity, including hate, harassment, intimidation, or people trying to impede people's access to enter inside. So if you can find me one that wants some of that behavior, I will correct myself. But I don't believe there's a single one in the world that would
Okay,
ever wish for that.
thank you, thank you. Councillor Pasternak, 3 minutes, please.
I assure you I will keep it to 3 minutes. So, Councillor Matlow, I mean, are you aware that over the last 18 months we've been trying to get municipal licensing to lay bylaw violations against many of the activities that have taken place in the city, from protesters, from smoke bombs, to amplified sound, to blocking roads, to illegal affixing of signs. And they have said we have turned that over to police. And then when you march over to police headquarters and say, well, I understand you're going to be enforcing our bylaws, they say, oh no, that is not correct at all. We will not be
Okay, hold on. Councillor Perks, please. It's hard to hear. Okay, go ahead.
Oh no, we won't be taking that on at all. But what we will do is we'll create a safe corridor for municipal licensing to lay charges. They didn't know that, but it sounds very similar to what Ottawa is doing. You seem to be relying on police services on something they have said repeatedly they won't do. I'm just wondering if you could explain how you're going to change their mind.
There are many, many instances already where the police, to their credit, have done a very effective job to keep peace and order, to ensure that there are corridors, that there are perimeters, that there are essentially zones where people cannot clash because they want to protect the peace, they want to ensure the safety of everyone, including their own members. And they do that routinely at a number of events, including many I'm sure that you've been to. With respect to MSOs, your frustration actually supports my point. We just had a debate yesterday about how we want them to be more effective at protecting renters through RentSafe and other, there's so many things that we're asking MSOs to do. And I fundamentally agree with you, frankly, that the MSOs are not the most effective group to send out toward a protest and see that resolved. And especially if a protest is going into taking on a nature where there are real concerns, like genuine concerns. That is the proper place for the police.
Thank you.
Anybody else?
Councillor Carroll to speak.
Thank you, Madam Speaker. Madam Speaker, I have great respect for my colleague, Councillor Matlow, but I want to ask us to cast our mind back even to the morning, to the beginning of this debate. We had excellent answers from both municipal licensing and standards and from the Toronto Police Service. And we know one thing, we've always known it. Crimes are what police enforce. Public order, criminal code, statutes, in both provincial and federal. Bylaws created by the city are what our bylaw enforcement officers enforce. The reason I asked the question I asked the Toronto Police Service, I was very specific. Should the bylaw officers proceed to enforce this bylaw? Are they like any other Torontonian? When you are on the scene of these zones, however they are configured when council decides, will you be protecting their safety as well as everyone else's? And the answer was absolutely yes. And I know that that's a fact. I've had that conversation offline with the Toronto Police Service. They will be there to do what they've been doing all along, to enforce public order, and there are laws about that, and to look for criminal code violations under the Mischief and Hate Crimes Act. And so the police have a role to play here, but you are going down a very slippery slope and leading to a lot of over-policing if we are now going to ask them to be bylaw enforcement officers as well. There's a reason why we separate those out. The council can do the things they do. The Police Act can ask the things they ask of police services. And lastly, but not least, there has to be a collaboration between the two to do some of the things we do. Our safety and well-being plan, which we all looked at in update earlier this year, is an idea of that collaboration. But it doesn't mess with the difference between a bylaw and a law enforceable by police. And so that's why I have problems with most of Councillor Matlow's motion. I also have a problem with the fact that it came very last, with no ability to deeply understand it, with no ability to run across the room and ask staff, or those of us having to participate virtually so that we don't spread our contagion, to be able to text anyone and ask them about it. Whereas Councillor Chernos Lynn's motion was a deeply collaborative, consensus-building exercise that all of you had seen so much by the time you were listening to Councillor Chernos Lynn that it was delivered quite calmly in her 5-minute speech. Whereas right now, we're all very much at odds with the motion coming by surprise at the last minute. And so I asked you to go back to the results of the consensus building exercise. That is really your best bet, because that is where you put all of your thought and time over the last few days. That is an attempt to do some very careful amendments to staff's proposal. Going to universal application of those zones is actually not advisable. I can tell you that when this gets to police service, they will say, gosh, I hope this works out all right, because what Project Resolute has been able to do over the last 19, 20 months is to be able to evaluate and know where the hotspots are, where they haven't arrived at some sort of peaceful coexistence, where they need to be when they need to be there. If we go universal and suddenly people are thinking that they can expect that someone is going to be on tap to enforce the zone universally in 3,000 different locations the minute we pass this bylaw, and that will be the expectation. That's just plain dangerous, and it's disingenuous in the main. And so I ask us to vote for the motion that you have spent much more time considering and spending some time and thought and consensus building on. That is our best way forward. Thank you, Madam Speaker. Those are my thoughts.
Thank you. Okay, so if we can ring the bells for the votes, but before we start, I'd like to ask our legal staff on the motion by Councillor Perks. Now that we've heard all the motions and amending the bylaw, I would like the legal staff to please comment. Yes. I'm asking legal staff to comment. So if I can have you comment, please. Okay, you can do a point of order, Councillor Perks, but
yeah, the
I'm going to ask the
bylaws,
question to legal staff.
Yeah, and the procedural bylaw is very clear on this point. Your opportunity to ask for advice from city staff is during the questions of staff time.
I understand,
and
but
and you didn't ask that question then. The rules say you cannot call them back. You can ask the clerk for advice about ordering motions and things like that, but you can't have a second round of questions of staff. Otherwise, too.
Councillor Perks,
I'd like to hear the legal staff opinion on Councillor Matlow's motion or Councillor Chernos Lynn's motion.
We've done that previously. Yes.
Okay, then I want...
Thank you. Councillor Perks, please. Okay. Okay. With that, okay. All right. No, it hasn't been challenged.
Yes, there was a challenge.
But yeah, thank you.
Madam Speaker, point of personal privilege.
Councillor Bradford.
You had suggested that we were going to hear from City Legal on something because new information had been presented that has ramifications for the City of Toronto's position on a go-forward basis. Councillor Perks stood up and challenged you because he doesn't want council to have that information from our city solicitor. And I would just ask that there was a challenge of the chair. If you would like and you think it's in the best interest...
Councillor Perks, please.
Madam Speaker, if you think it's in the best interest of this council and the city to hear from our chief solicitor, then I would suggest you continue with that. Happy to have a challenge of the chair, and we will support you because I think it's important for the city. Thank you.
Councillor Perks.
Yes, Speaker. Councillor Bradford said that I don't want council to know something. That is in fact not the case. What I am trying to do is to make sure that we have an orderly debate and that the rules of procedure are followed. So I would ask you to tell Councillor Bradford to withdraw that remark.
Councillor Perks, please. Let's just move on. Let's put the motions on the screen. And we just know when it's up to members of council to decide how they're going to vote on the motions. Councillor Holyday.
I would like to raise a point of order under the procedure bylaw. The chair is allowed to ask, I'll just read it here, permitting statements by city officials when integrity questioned. Councillor Cole, in his remarks, questioned the legal advice that was brought forward. And a statement was issued prior and it has cast doubt on the information. And so this section here implies that that official can be called upon.
It's not how it's read it.
We'll have the clerk comment.
Speaker, in my view, the rule that the member is stating is about the personal reputation of individuals. So that's the rule is designed so that if the if the personal reputation of a city official is called into question, the chair is permitted to have the city official address council to correct the record. So the issue here is whether that applies. In my view, that's what you have to decide.
Okay. So I think it applies. Okay. So if anybody wants to challenge me, if I can ask legal staff to comment. If I can ask legal staff to comment. On the okay, Councillor Perks, if you want to challenge me, challenge me. I'm asking the question for legal staff to comment on the confidential information and the motions that we have before us if it changes the bylaw. Yes. Okay. And then, okay, can I ask legal staff please to comment on the motion to release the confidential information? No. No, I'm ruling that the motion, Councillor Perks, that you moved on releasing the confidential information, I want the legal staff to comment. Okay. Okay, for clarification. Because we did not go in camera. Okay. Okay. Okay, so Councillor Perks is challenging me, Councillor Fletcher. So there's been a challenge by Councillor Perks. is the ruling of the chair upheld? Recorded vote.
Madam Speaker, it's Councillor Carroll. For clarification, we're just voting on the motion you just last stated to receive a legal opinion on that one motion.
Yes.
Councillor Perks's motion.
That's right.
Only.
Only.
Okay, thank you. Thanks for the clarification.
Yeah, this is the challenge for the chair.
Councillor Thompson, please. Councillor Perks. And Councillor Fletcher. Councillor Sachs, please. Thank you. Can you turn off the bells for me? Sorry, Councillor Thompson, your vote, please. Okay, thank you. And Councillor Fletcher, your vote, please. No. Thank you.
The ruling of the chair is upheld. The vote is 15-10.
So if I can just ask the city. No, we're at the end of the debate, Councillor Fletcher. We're not. We finished the item. I'm just asking the city solicitor. Councillor Fletcher, please listen, please. I'm just asking the city solicitor on the motion that Councillor Perks made to release the confidential information if there's any liability. That's all I'm asking. No, you don't need to have that in camera. Okay, can I ask the solicitor please to comment? Yeah. Yeah. I just want the comments on as far as the motion to release the that's all I'm asking. Yeah.
So,
okay.
So, Madam Speaker, what I will say in public is that this morning I was asked if I was comfortable with my legal advice being made public. It is currently a confidential attachment to a supplementary report, and it is not public. My response was that if the bylaw was adopted in the form that has been proposed by the city manager, I did not see significant risk in having my advice made public. I was comfortable with that. There are a number of motions before you now, and I actually have not answered that question about the motions. If council would like my advice on all the motions, then I would have to, I think we're past that point, but I'm not prepared in public right now to answer that question about all of the motions.
Okay.
So my advice was about the bylaw that we had at that time.
Yeah,
the
so
bylaw might look different. My advice might have been different if I'd had a different bylaw in front of me.
Thank you. So let's put the motions on the screen then. Let's vote. No. We're just voting on the motions. Yeah. Yeah. Yes, we're just voting on the motions, Councillor Fletcher. Yes, you're right. No, we're just voting on the motions now. We're putting the motions on the screen. Yes. No, let's just vote on the motions, Councillor Fletcher. No. No, we're not going in camera, no. Can we put the motions on the screen, please? Okay. No, I don't have the voting order. First motion is motion 1A by Councillor Pasternak, and it's on the screen. Recorded vote.
Councillor Myers, please, and Councillor Perruzza. Motion 1A does not carry. The vote is 8 to 17.
Okay, next motion is motion 1B by Councillor Pasternak. Recorded.
Councillor Candeval, please. And Councillor Thompson. Motion 1B carries. The vote is 13 to 12.
Next motion is motion 6A by Councillor Matlow. Recorded vote.
Just stand by, Speaker.
Okay, there it is on the screen. Recorded vote.
Councillor Crisanti and Councillor Morley, please. Councillor Crisanti, please.
Councillor Perruzza, how do you vote, please?
Councillor Crisanti, your vote.
I'm sorry, my vote is on this one is no.
No. In the negative, thank you. Motion 6A does not carry. The vote is 4 to 21.
Motion 4A by Councillor Rachel Cherneslin. Recorded.
Councillor Candeval, please.
Motion 4A carries. The vote is 18 to 7.
Motion 4C by Councillor Cherneslin. Recorded.
Burnside and Councillor Crissanti, please.
Motion 4C carries. The vote is 19-6.
Motion 6B by Councillor Matlow.
Councillor Perruzza, please. Motion 6B does not carry. The vote is 7-18.
Motion 4D by Councillor Chernis Lynn. Recorded vote.
Councillor Perruzza, please.
Councillor Matlow, please.
Motion 4D carries. The vote is 17-8.
Motion 6C by Councillor Matlow. Recorded.
Councillor Mantis and Councillor Crissanti, please.
Councillor Perruzza, please. Motion 6C does not carry. The vote is 6-19.
Motion 4E by Councillor Chernis Lynn. Recorded vote.
Councillor Candeval, please. Thank you.
Motion 4E carries. The vote is 19-6.
Motion 6D by Councillor Matlow. Recorded vote.
Councillor Perruzza, please. Motion 6D does not carry. The vote is 4-21.
Motion 4F by Councillor Chernis Lynn. Recorded vote.
Motion 4F, as amended, carries. The vote is 16-9.
Motion 4G by Councillor Chernes Lynn, recorded vote.
Councillor Perruzza, please. Motion 4G carries. The vote is 13 to 12.
Motion 4H by Councillor Chernes Lynn, recorded vote.
Councillor Fletcher, please. Motion 4H carries. The vote is 20 to 5.
Motion 4I by Councillor Chernes Lynn, recorded vote.
Motion 4I carries. The vote is 17 to 8.
Motion 4J by Councillor Chernes Lynn, recorded vote.
Councillor Perruzza, please. Motion 4J carries. The vote is 14 to 11.
Motion 4B by Councillor Chernes Lynn, recorded vote.
Councillor Perruzza, please. Motion 4B carries. The vote is 17 to 8.
Motion 5 by Councillor Perks, recorded vote.
Councillor Perruzza, please. Motion 5 does not carry. The vote is 12 to 13.
Councillor Ainsley, can you move that the confidential report stay confidential? Because you haven't spoken. Okay, Councillor Ainsley will move that. Recorded vote.
Councillor Perruzza, please. The motion carries. The vote is 15 to 10.
Okay.
Yes.
Item is amended. Recorded vote.
Councillor Perruzza, please. Speaker, the item is amended as adopted. The vote is 16 to 9.
Okay, we've dealt with that item. Thank you.
Top of the
Okay, we'll just a few minutes, just recess so everyone can leave the council chambers.
member motion piloting a red tape hotline for businesses. After discussions with Councillor Carroll and the city solicitor, I have an amendment.
Have your amendment?
Yeah,
Okay, we'll put it on the screen.
I'll explain.
Okay, there it is, the
Okay,
amendment.
I'm just going to take 1 second and say what the effect of this is. The way the motion was originally written, it would have said that the general manager of economic development had the authority to tell the city manager what to do. And that wasn't the intention. So the language here cleans it up so that the correct delegations happen, so that actions to cut red tape that businesses identify can go for. Pardon me? Oh, okay. Councillor Fletcher wants to hold it, so we're not there yet. Okay.
Okay. Thank you.
And that's all I have for now.
Thank you. Councillor Fletcher, you have a quick release?
I do. I have a quick release for GG 21.18, and it is the where'd it go? Payments Modernization Framework, and understand from our Deputy City Manager, David Jollymore, that there will be a second report coming in Q4, and I think I can wait to make sure that it's going to not stray off into a pay it situation then. So I'll release this, Speaker.
Okay. On GG 21.18, Councillor Fletcher's releasing. On favor, carried.
Sorry, my CC 30.2, Office of the Integrity Commissioner 2024 Annual Report, and I will move that with thanks to our new Integrity Commissioner. Thank you.
Okay, Councillor Fletcher is releasing CC 30.2, Office of the Integrity Commissioner. On favor, carried. Okay. So
16
now,
items.
pardon?
Only 16.
Yeah, Mayor, Olivia, did you want to move the vacancy? Yeah, we're going to do it now. Okay. So, Councillor Crisanti, your member's motion for MM 30.39. Want to just move it? Okay, let's just put it on the screen. MM 30.39. Okay, there it is on the screen. Recorded vote? Recorded vote.
Deputy Mayor Malik, please. Councillor Matlow, are you present in the meeting? Councillor Matlow? Councillor Pasternak, please.
Councillor Chernislin, please. And Councillor Pasternak, please.
The motion carries. The vote is 18-1.
Thank you. Councillor Chernislin, your member's motion that we added to the agenda for the Toronto Local Appeal Body, would you like to release that? We'll put the motion on the screen. MM 30.40. There it is there on the screen. Would you just like to move it?
Sure, I'd be happy to move that. Thank you.
Recorded vote. Is this on 3040?
Speaker, could the member read into the microphone, please, the nature of the interest for the minutes, please?
Yeah, could you,
Just
sorry,
the
sorry, let
microphone
me
was
put
not
his,
on and did not
let
pick
me
that
put
up.
his mic on. Go ahead.
I'm declaring an interest in this item, given that I live very close to this property, and I will submit the relevant paperwork.
Okay, so can you fill out the form and give it
Yeah,
to
I
the
will.
clerk, please?
Yeah.
Thank you. So recorded vote.
Councillor Perks, are you voting?
I gotta fix my computer. Yes.
Deputy Mayor Malik, please. Deputy Mayor Malik, and thank you. Councillor Fletcher, how do you vote, please? In the affirmative, thank you. The item or the motion is adopted. The vote is 19-1.
Okay, so we'll now go back to the item we were dealing with yesterday, which is DX 23.2, Ontario Toronto New Deal. If we can put the speakers list on the screen, please, because we did start the item yesterday. Okay, Councillor Cole, you're up to speak. Is it?
Speaker. Madam Speaker, where we left off on this item was we had a short debate on a motion by Councillor Holyday to refer the matter, but Council did not vote on that motion. So my advice to you is that you proceed to take the vote on the referral motion, and if that fails, then we'll resume the speakers list, the main speakers list.
That everyone spoke on the referral motion. All right, so let's ring the bells, and we're going to vote on the refer. Oh, Mayor Chow, sorry. Go ahead on the referral.
I urge Councillor to vote against the deferral because this is part of the New Deal, Part 1, which was finalized in December of 2023. And And this conversation as to what we, by uploading the Gardner and the DVP, that the province of Ontario wanted to have access to some of the lands that where they're building the LRT, which we thought makes a lot of sense. We are eager to start on New Deal Part 2, but until we've finished all the outstanding items in Part 1, we cannot start on putting the New Deal Part 2 together. And I'm anxious to do so because it would have impact in our upcoming budget. So I urge you not to defer this item. Thank you.
Thanks, Madam Speaker. Just rising in support of the referral. Last night, some colleagues were getting very fired up about Councillor Holiday's motion to refer for additional consultation with the community out in Etobicoke. I think it was suggested, as we just heard from the mayor, that this would effectively blow up the term sheet for the new deal. I think it was implied that it was outrageous that a member of council would threaten to send this back for more consultation with the community. It was, well, first-time consultation, and it was immediately after the section on the Eglinton Crosstown West extension. It talks about East Harbour, and what does it say? Well, the quote is, "City to prioritize approvals and finalization of agreements to meet conditions precedent on commercial agreement with the development proponent," which is interesting because the employment area conversion request for East Harbour, necessary to enable the development of the TOC there, has been referred by the local councillor not once, not twice, not 3 times, but 4 times. It came before us in September of 23. That was before the new deal was signed, but then it was deferred twice last year, most recently in December of 2024, with a request for a report back in June of 2025. So that's 21 months of putting on this file that was part of the new deal, where the city committed to, quote, prioritize approval and the finalization of agreements. So I would just say for all my colleagues that are open to this, you got a member here who's saying my community has never heard about this. We would like to go out and speak to them. We would like to do some consultation. There is a precedent in East Harbour of it being deferred and referred 4 times over the course of 21 months, still part of the New Deal agreement. And so this is something that Councillor Holiday is making a request for. He was admonished, mocked even last night, and yet for other people in the chamber, it's just fine, and we're all happy to go along and get along. I would say, you know what, support the folks out in Etobicoke, support Councillor Holiday's request here. I don't think it's that big of a deal. Thanks, Madam Speaker.
Thank you. Just to let everyone know, there's been many consultations about the East Harbour development. The conversion is from employment from Great Gulf, but the transit hub has always proceeded. The transit hub is GO, the transit hub is TTC, and the transit hub is the Ontario line. And it is now going to be constructed. So that is not referred anywhere. That's proceeding. I would have to say that in all of my many months of the Metrolinx and the Ontario, the TOCs, I've had many consultations, many, because I hold those consultations. I'm not expecting the city to hold them for me. I'm not expecting Metrolinx to hold them for me. I don't think there's anything stopping any councillor from having that consultation about what's going to happen in the community. In my community, I have to let them know Metrolinx is doing this, Metrolinx has changed this, Metrolinx is doing that. Here's your TOC. It's IO that does the TOC, not Metrolinx. It's quite complicated, but I would just urge councillors that are in this situation, and that would be you too, Councillor Chernos-Lynn, as a new councillor with that Ontario line, just grab hold of that. Let people know what's happening, because the consultation that's undertaken by Metrolinx and IO just isn't the kind that we would do. But I'm not expecting city planning to do that. I think it's important that we talk to our communities and bring everybody on to that meeting to let them know what's happening along this line. And this is great for you to do that, but I don't think City Council has to instruct anybody to have a consultation about something happening in our ward. Thank you.
Thank you.
But I won't be supporting you already. I have many times when I have...
Okay, Councillor Cole. Councillor Cole.
Yeah. Okay, I have a lot of sympathy for Councillor Holliday, and he's trying to deal with forces that are really beyond his control or our control, and that is the provincial government's authoritarian approach to development and planning. They basically control it now. We are just place setters now, and we have to come to that realization. And I think you're talking about two different things. The East Harbour, as Councillor Fletcher said, they've been consulted to death on that thing, even before the New Deal. So here, in this case here, I really wonder whether the local MPP there, I think it's the minister, isn't it, Kinga Sharma? She had a meeting, I wonder. God forbid. I know when I asked my MPP, I said, why don't you have a meeting about the 10 pieces of legislation you passed about development and like the TOCs, whatever you want to call them, the transit-oriented communities, they're basically the sisters of the MTSAs and the PMTSAs, where we have no control because the province says if it's an MTSA or PMTSA or a TO, it's their God-given right to build whatever they want because there's a transit station. But the province is very shrewd. They never told the people that they represent that this is what they did to them. So then by having City Council say we're going to have a meeting authorized by the planning department, then the public are going to think, oh, it's the city, the damn city again, rubber stamping development. Meanwhile, Kinga Sharma is hiding somewhere. Oh no, planning, that's nothing to do with us. MZOs, that's not me. Maybe that's what they should call them, not me's. But so that's what we're asking for. So I think I have a heck of a lot of sympathy to what's happening along Eglinton there. And I would really like to say, I think there should be a joint public meeting between the...
Oh, thank you, Councillor Cole. You're way over 2 minutes.
Oh,
Sorry.
okay. Anyways, I just want to say
Yeah.
I'm not supporting the referral because it's just putting the blame on us, and it should be on Kinga. She should do her job. Thank you.
Okay, so... Yeah, we have to take a vote. I'm so sorry, Councillor Holliday. On the referral. Huh? Yeah, I think we need a recorded vote.
Councillor Sachs, please. Councillor Fletcher. Councillor Deputy Mayor Malik, please.
Councillor Pasternak, your vote, please.
Councillor Myers, if you're present in the meeting, can you turn on your camera so I know you're here? Thank you. The motion to refer the item does not carry. The vote is 6-16.
Okay, we'll go back to speakers. Councillor Holiday, we can work out some conditions. What's happened to my screen? No, but it's...
Oh, I'll have her come. Just call on Councillor Cole.
Okay, Councillor Cole to speak. Councillor Cole.
I was just going to tell Councillor Perks, what's his name, that we're talking about our grandchildren, and I was just saying my grandson goes to the same childcare center at St. Matthew's Co-op there that his father went to. So that's pretty rare in Toronto nowadays, yeah. Anyways, other than that, I just want to say that what Councillor Holiday was bringing up here is of critical importance to what's happening to our city. We're going through this in my ward, and I'm sure some of the other wards. I know Councillor Chernis Lynn is certainly going through it. There's unbridled, hyper, extreme condo warehousing taking place in the city. And it's all in the guise of a transit-oriented community. So what they say is, because you've got a transit station, subway station, LRT station, the province has basically said, you can build what you want. So I know Councillor Holiday's talking about Eglinton. I know on Marley Avenue, and Marley Avenue is not Eglinton, it's, marginal arterial road. They're proposing 20 condo warehouses up to 43 stories. They got 20 condo warehouses up and down Marley. And why? The rationale is, well, there's a transit station there, the Glen Cairns transit station. So because the station is there, the developers have bought up every house and are proceeding with the condo warehousing of the street. So, and because there's a transit station, they say, we don't care whether there's parks, we don't care whether there's sewers, there's no sewer capacity, we don't care about hydro capacity, never mind schools or parks. That doesn't matter because the transit station trumps everything. At least. So that is what is happening with the new intense development that's taking place wherever there's transit. And that's what's happening here on Eglinton with the transit-oriented community. So the question is, how do we bring some sanity to this development when they can't sell the condo warehouses anymore? People cannot afford to buy a 500 square foot condo warehouse for $1 million. Yet, the application is still coming in for more warehousing. 30, 40, 50, 60 stories of condo warehouses being applied all over the city. In Willowdale, God help the people of Willowdale. Luckily, they've got Councillor Cheng there trying to do her best, but they're overwhelming her with a tsunami of condo warehouses in Willowdale. You will never see the sun in Willowdale in 10 years. It'll be a rare sighting when you can see sunlight in Willowdale. They'll say, what happened to the sun? And that's because of these policies of the province, which in this case of the transit communities, they're coupled with ministerial zoning orders. So you don't have a choice. And as you know, if the city planning department says this doesn't fit the city's plan, within 90 days, they jump to the private tribunal, Premier Ford's private tribunal, meets in the basement of some condo somewhere that rubber stamps everything. Every application, 96% of all condo warehouses get rubber stamped by the tribunal. So it doesn't matter what the public says, Doesn't matter what the residents say. It doesn't matter what our planning staff says. The tribunal in the basement there somewhere in Toronto rubber stamps all these warehouses. And what do we do as council members? Like Councillor Holladay here is saying, please help, do something. But it's too late because it's all been done. We are now just basically becoming a city of condo warehouses. So God help our future generation who can't afford to live in these 500 square foot boxes. Thank you.
Thank you, Councillor Cole. Is that it for the speakers on this item? Yes? Okay. So let's just vote on the, there's two other motions that Councillor Holladay put forward. If we can put it on the screen and vote on it. So it's 1B by Councillor Holladay. Recorded vote.
Councillor Cole, Councillor Matlow, please.
Councillor Pasternak,
Councillor
please.
Councillor Thompson.
This one.
Councillor Thompson, please.
Councillor Sachs, when you're seated, please. Councillor Sachs. Councillor Matlow, how do you vote, please? Okay. Yeah. Motion 1B does not carry. The vote is 6-16.
And 1C by Councillor Holladay. Recorded vote. Point of order, Councillor Holladay?
Yeah, there's an updated wording. It changes Ministry of Infrastructure to Government of Ontario. The clerk should have that.
Yeah, that's fine. Take it as read.
None. People have known about this for a week.
Okay, so Councillor Holladay,
It's fine. We all know what he means.
are you amending that motion?
Yeah, I'd sent that in a long time ago. It should just say Government of Ontario, not the Ministry of Infrastructure.
Yep.
Okay.
Speaker, we'll make that change in the motion. Councillor Sachs, please. Councillor Cole, how do you vote, please? In the negative, thank you. Motion 1C carries. The vote is 18-5.
Okay, item is amended on favor. Pardon? Recorded vote on item is amended? Okay, recorded vote on item is amended.
Yeah, I'm going to see her. It keeps tuning out. Good job on the
Councillor Cheng, please. Councillor Deputy Mayor Malik, please.
things under control.
Councillor Matlow, please.
The item is amended, carries. The vote is 15-6.
Okay, so our next item is EX 23.7 status update of funding for the federal and provincial government for FIFA. Mayor Chow, you held it down, it's here without recommendation. Do we have any questions? Does anybody have any questions on it? It's here without a recommendation. Okay, Mayor Chow, would you like to ask a question or speak?
I have some recommendations in front of folks. Has it been advance circulated?
Okay, so are you going to speak now? So we put the motions on the screen? Okay, Mayor Chow, they do have your motions. So did you want to speak on it now?
I'll speak after Councillor Malik. It's in her ward.
Oh.
Technically.
Okay.
Councillor Chang.
Your computer doesn't work?
She's on the list.
No, the only person. Oh, there you are, Councillor Cheng. Okay, just one sec. Okay, go ahead.
Thank you. Through the chair, how much does the provincial government stand to make through the hosting of FIFA in our city?
Through the chair, as noted in the report, the economic benefits for both Canada and Ontario are noted, and it's expected that there'll be a positive economic impact for Ontario of $1.3 billion.
So in the negotiation of the original terms, was there an understanding that there would be some in-kind value as part of the province's contribution, or is this a new request that's being made?
Through the speaker, it was in the original letter we received around funding that provincial services would be deducted from the $97 million.
And in our valuation of our contribution, does it also include in-kind?
Through the speaker, yes, there are portions of our budget that are in kind.
And were we expecting this amount to be declared as in-kind, because this has a significant impact on our city?
Through the speaker, we were definitely expecting some costs related to provincial services, but I think as noted in the report, these were higher than expected and on some of sort of areas that we weren't necessarily expecting.
And so can you just remind me, what is the total amount that they are saying is going to be in-kind?
We're at around $39 million.
So that's about 1% of property tax, I think. And I'm just wondering, in terms of the budgeting for FIFA, how much now is going to support local activations beyond the Fan Fest and the area surrounding the game? So are there still budget allocations that will be allocated to activations outside of the downtown core to spread the love and the joy of FIFA?
Yeah, through the speaker, we definitely have elements in our budget that are conducive to supporting communities and engaging in different ways in the tournament, including community celebrations, including legacy, dressing, signage, engaging community, and having a very much a World Cup feel throughout the city.
And is that amount at risk with this current news of larger than expected in-kind contribution declaration?
Through the speaker, I think it's difficult to pinpoint that exactly at this point. To be really clear, we are still in negotiations with the province. We're very confident that we will get this number lower, and then we will have to, make some choices about elements in the budget.
And is there an opportunity through advertising and partnerships that I think MLSE is negotiating to recoup the loss of the impact from this in-kind contribution amount?
Through the speaker, our revenue strategy has been set, including the dollars in terms of our targets on the revenue side of our budget. We're hoping that those will be higher. We certainly have some stretch targets as well. So I think there'll be a number of factors at play. Our continued negotiation with the province, as we do every single day, continuing to look for cost savings within the budget and looking for opportunities to increase revenue.
Great, thank you. Those are my questions.
Thank you.
Thank you. And I just want to let members of the council know that the mayor has motions that we are going to circulate, advanced circulation, so you can check the motions on CMP, so you have an advance notice of the mayor's motions, okay? Now, Mayor Chow, would you like at this point to move your motion and extending, Councillor Perks?
Yes. I would like to move that we extend to complete the agenda with a break from 6 to 6:30.
Yes, that's what the mayor was just going to do.
Well, they told me to do it.
Okay.
And I do whatever Erica says. It's like the law.
So Councillor Perks, you're moving that we recess from 6 to 6:30 and complete the agenda.
That's exactly what I'm moving.
Okay, on favor?
Pizza, though.
Carried.
Amendment. The mayor's got to order pizza.
Okay, so the mayor is suggesting, Councillor Cole wants pizza. So Councillor Cole wants pizza, the mayor suggests, okay, enough, please stop screaming. So what the mayor is suggesting is that we recess at 6:30, so this way we give enough time for pizza to deliver. So we'll recess at 6:30 to 7, okay? Thank you. Okay, now we have to take a vote on that. On favor? Carried. I apologize for that, but it's Mike that said he wanted pizza. Anyway. Councillor Candaval, questions?
Thank you, Madam Speaker, and I can assure you they're not about pizza. To follow up on Councillor Cheng's question on investments outside of the core, celebrations was used. Can you provide some examples if they've been established of what we can see in the suburbs?
Through the speaker, we are developing a program that is going to be announced fairly soon around supporting communities, BIAs, and other community organizations for community events and celebrations related to the FIFA World Cup. We'll also be sharing some information about public viewing events and how communities and organizations and businesses can tap into that opportunity as well.
When can we expect that in? Couple months or before
we're looking
summer?
we're looking at launching some more information on that by mid-June.
Okay, thank you. And
Yeah.
as part of that, we've got a very active soccer community in Scarborough. Would elite leagues be examples of community groups that would be engaged?
Yes, in fact, we have an outreach program to the soccer community that we're going to be engaging for our 1 year to kickoff celebration that's coming up. So a lot of activations related to the soccer community will launch with our 1 year to kickoff.
Thank you. How is the city ensuring that legacy projects and community investments are not overly dependent on private donations through the Champions Table?
Through the speaker, so as you've alluded to, we have our one main opportunity for legacy with the 12 mini pitches, which is primarily related to donations coming in through the Champions Table. Outside of that, we do have money in the budget for other legacy projects and have been, over the last few months, engaging various community leaders and groups in our program advisory bodies.
Gotcha. The 12 proposed mini pitches, what is the criteria for selection? Will neighborhoods be able to nominate?
Councillor Candeval, we have to ask questions on what's before us. We're not here to talk about community benefits.
Well, it's to do with the funding that's coming out of it.
No, it's not part of this, I'm sorry.
Okay.
Okay.
All right, if I could, I'll pivot. With the planned satellite versions of the Fan Festival, are there consideration for other opportunities that provide accessibility for families who can't attend the core?
Through the speaker, yes, that will be part of our community activation program.
Great.
Okay, so I think what we're discussing is the update on funding from the federal and provincial government for the World Cup. There's
the
nothing
relating
in
budget.
Yeah, but there's nothing in here that's talking about community benefits.
It speaks to the
No,
how
I'm
the
sorry.
budget's
I'm
being
sorry,
applied.
Councillor
Okay,
Candeval.
I'll respect
Okay.
your decision. Okay, thank you.
Thank you. Deputy Mayor Malik.
Thank you very much. Appreciate the report that's come to us. And we also know that the approach that we've been taking to FIFA is an all-team approach where us at the city are hosts, and we've been working collaboratively with the provincial and federal governments. And this is a tremendous undertaking, and it's going to require all of us to put in our fair share for the success of the games and also for the substantial benefit. And can you speak a little bit to the economic benefit that is being projected from the games, not just for the City of Toronto, but across the province?
How is that related? Just questioning your logic.
No, I understand. Please don't get angry, please. Okay, Deputy Mayor, can you just ask questions on what's before us on the provincial and federal funding of FIFA?
Yes, this is related to that because there's economic benefit that is going to be shared across the province, the federal government, and the City of Toronto. I'm just not sure how that's out of order.
No, because I just called Councillor Candeval out of order when he asked those questions.
Sorry, I missed that.
So I have to be fair here.
No, I just don't know what Councillor Candeval's questions were that were different.
Yeah.
You were asking about Section 37 funding. I'm talking about the economic benefits.
Please, let's move on. Otherwise, we're going to definitely be back tomorrow.
Raising a point of personal privilege. So.
Okay.
Through the speaker, I can answer your question about economic benefit. And as was noted in the report, the economic benefit for the province of Ontario is expected to be about $1.3 billion, around $700 million to the GDP, along with, probably over 8,000 job opportunities, et cetera. So it's significant economic impact for the province and for Canada as a whole with our colleagues hosting in Vancouver.
And speaking of Vancouver and the relationship between the host cities, their provincial governments and the federal government, and you're in communication with them, and it's been important to kind of exchange those best practices. And what are you hearing from them in terms of, being at the table with their provincial counterparts and the federal government?
Yeah, through the speaker, I can share that our, governance models and hosting models between Toronto and Vancouver are quite different. The province of BC has been actively at the table working sort of side by side with the city of Vancouver on hosting the event. And so they're much more engaged than the province of Ontario has been thus far.
And the progress of the work that you outlined for us and what's in front of us, can you share your impressions of that?
Yeah, through the speaker, I can confidently say we're in constant communication with the province. The conversations have been collaborative. I think we have lots of questions back to clarify some of the items that were in the service cost list. And we're going back and forth on what those details are and sort of looking at areas where we feel perhaps the service costs that they've put in don't necessarily meet requirements or beyond requirements for us as a host. We're also looking for areas where there might be redundancy so that we make sure we haven't accounted for something that they're also accounting for. So there's lots of negotiations going back and forth, and I'm really confident that we will get to a very reasonable place.
Okay, thank you.
Thank you.
Councillor Cole, questions on the item, please.
I know we've already got our private sector partners out there trying to raise money from a sponsorship program, the championship table. How much money are we already trying to add to defray some of the costs that we're going to incur in hosting these games?
Our target for all commercial sales, including host city supporters, our hospitality program, and the Champions Table, is approximately $34 million. And so we're well on our way to that. We have several partners that we have one signed partner and several others that are in contract phase and agreement phase.
Okay, so we're already asking Toronto residents, basically, above and beyond the taxpayer commitment, to also raise money to offset the cost of the game.
That's correct. Through the Champions Table, we have a group of leaders who are out seeking donations for our Soccer for All program, in addition to speaking with Corporate Toronto as part of our host city supporter program.
Now, in terms of the provincial, you might say, statements of the last week, what are they really trying to say about the conditions to their original commitment? How much was their original commitment to us?
Through the speaker, the original commitment was $97 million.
Okay, now they're saying that's really not $97 million flowing to the FIFA tournament, but it is basically got some pay downs, or what do you call them, whereby they're saying it's $96.7 million, but we have some things that are not going to be passed on to you because we are essentially bearing some costs. What are some of these costs they say that they want us to basically get more money for?
Yeah, through the speaker. So to clarify, the original funding commitment was for 97 million, but it was always made clear by the province that any service costs they have to support the event would be subtracted or deducted from that 97 million. And so some of the areas that they've identified are things around the Ministry of Health, OPP, some items related to the Ministry of Sport, Intergovernmental Affairs. So those are kind of the categories all listed in the report that they've noted as provincial service costs for them to support the hosting of the event.
So what does the Ministry of Health costs got to do with hosting the FIFA tournament?
So that's provincial costs related to having the hospitals prepared, EMS, paramedics. It has included some surge capacity. So should there be any type of mass casualty event. So there's some items in there that this is definitely one of the areas we're still negotiating to learn more about how they've itemized and come to the dollar figure that they've put in the list.
Now, the other thing I noticed, something about cleaning, the cost of cleaning the Metrolinx stations, that we're supposed to basically pay for the cost of cleaning their unbuilt stations?
Yeah, through the speaker, I can clarify. I think the term used in the report and that we received from the province was the term beautification. And to clarify, that's not cleaning. It's really what we would call sort of look and pageantry. So it might be signage, it might be hoarding around some construction areas. So it's really creating sort of a brand look and pageantry for the event.
So it's not cleaning the washrooms for their Metrolinx stations?
It is not cleaning the washrooms.
Don't they clean them usually? No?
Yeah, it doesn't include that. It doesn't, that's not what that means.
Okay, thank you.
Yeah.
Thank you. Okay, well, we have to finish the agenda. Councillor Thompson.
Thank you very much. For you, Madam Speaker, to Sharon and Joe, we've heard around what the provincial benefits will be. I think it was $1.3 billion. What is the benefits to the federal government?
Through the speaker, and as noted in the report, based on the Deloitte study that was done in 2024, federal contributions or positive economic output, for Canada as a whole will be $3.8 billion.
Yeah, thank you. And I've read the report. I'm familiar with it, and I know that I'm asking you some of these questions, quite frankly, so that members of my community can have that to hear from you firsthand, quite frankly. So that's part of the reason I'm asking you. Now, the focus here is on the province in terms of their contribution and the fact that the process and the budgetary process, there's a need for more resources because a number of changes have occurred. What changes have occurred that requires additional funding? And given the fact that the province had made certain commitment, and I recall them saying that what they were giving was their final amount, which was the $97 million. And so our ask to them now is based on what principle?
Through the speaker, the original funding letter received from the province indicated that their contribution would be $97 million less service costs for them to support hosting the event. So we always were aware that there was going to be service costs attached to their funding agreement. What we weren't clear about was the amounts or the categories of which they would have service costs that they would be applying to hosting the event.
Right. And would it be safe, or could we assume that the province at the time didn't know what those costs were as well? I mean, one would presume that as we move ahead, they're planning and preparing as we are for the FIFA Games, so that at the time when they made the commitment, they would not have known what those costs would have been. Would that be correct for me to assume?
Yeah, through the speaker, I would say that's very safe to say. I think as any big event, things evolve, and as planning evolves, you learn more and things change as you go. So yes, I think that would be safe to say.
So our current position with respect to the need for additional funding, is it just simply that we're focusing on the need to raise provincial funds? Are we also seeking more funds from the federal government as well?
Through the speaker, our contribution from the federal government has been signed. So we do have a contribution agreement with them. Our funds with them are locked in at $104 million. And so right now we are locked in with our federal funding. So it's the provincial funding that we're still negotiating.
Right, and that's part of the issue why we're focusing in the province, because we didn't lock that in. It had not been signed. It was just simply a commitment.
That is correct.
Right.
Yep.
And can you help me to understand, with respect to overall security, security is a big cost of the budget. Would that be correct to say?
That is correct.
And where is most of that money coming from? Is it from the city, the feds, given the fact that FIFA, as part of its process, dictates a lot of what's required as far as security, and the people who are actually going to be coming to the event, not only that we providing security for the general populace, the general public, but also for the heads of states and others who are coming. Would that be correct in terms of making that assessment? And where is the bulk of that funding coming from?
Yeah, I think across the board, to be honest, I think that all three levels of government funds have been allocated to safety and security. You are right, there is certainly an element to safety and security that is around visitors and folks crossing borders, et cetera. But all three levels of government will be contributing funds toward our entire safety and security plan and delivery.
And so my final question, if you don't get the additional funding from the province, what's the plan B?
So through the speaker, as mentioned, we are still in negotiations, very hopeful that we'll be able to reduce this figure. If we can't, obviously we'll be exploring, as we are every day on this budget, we'll be exploring ways for cost savings as well as opportunities for increased revenue.
Thank you. I have like one fast question, but could you just one fast question? It's always done up there. Yeah, the mayor turned it on. As far as security, is the province, do you know if the province is giving the police services funding to provide the security?
So through the speaker, as was noted in the report, one of the items that is still being negotiated with the province is related to the OPP. So the province has submitted service costs specific to OPP involvement in supporting our safety and security. It's an area that, as I say, is still under negotiation. We're wanting to make sure that what they've submitted in that budget amount isn't a duplication of what TPS is providing, and making sure that what they've put in is actually a service and a provision that we need as a requirement for the event.
Has TPS, have they submitted in their budget on what their costs would be to provide security?
Yes, our security budget has been set for the event, and some of that includes some support that we have requested from the OPP.
Okay, but TPS though?
Correct, yes.
That's part of it? That budget is part of OPP and TPS?
TPS, in our safety and security budget for the event, there has been an amount allocated for some support that we have requested from the OPP for additional personnel and other matters that, because of the increased requirement around personnel, we had made a request to the OPP to support.
Okay, thank you. Now go to speakers. Mayor Chow, you would like to speak now. I know that the mayor has circulated her motions. So Mayor Chow, you can put your name up. Oh, you put it on? Okay. Okay, okay, there you go. There you go. Okay.
The recommendation in front of you basically is to say we'll continue to negotiate, but at the meantime, let us just live within our means and spend the 340 million that we have, and let us put all our effort in the next couple of months, I guess. I don't know how long it would take, but hopefully sooner than later, that we would reduce some of their costs, whether it's OPP and some of the health costs, because the list that is in there, I don't believe is all completely necessary. And I have not seen a work plan as to precisely why we need to request on the OPP or any of the health plan. But so all of that needs to be worked out. And I don't know what kind of negotiation is occurring, but I will now get a bit more involved. So this letter came with a bit of surprise, and which is why I immediately make sure that there was a staff report in front of everyone, so that you can see what kind of impact it will have. You will notice also there are other things such as trying to find means on trafficking. And last I saw, the City of Toronto has the police has a unit, dedicated unit to deal with trafficking. So there might be some duplication as to what they think they need and why they have to pay for it, while we are, the Toronto Police, for example, are the ones that actually are the ones that are responsible for doing 98% of the work. So there's a lot of negotiation that needs to take place, and the recommendation in front of you is to continue the negotiation, but in the meantime, make sure we don't spend money that we may not be able to get.
Thank you. Councillor Morley to speak.
Thanks, Madam Speaker. I just wanted to rise to say a moment of acknowledgement to the staff team and to the members of council, including members of the mayor's office, who've been working really hard on the FIFA file. This has been something that council has been seized with for many months at this point. And we know our organizing situation is a bit unique across different jurisdictions. It's a high pressure environment with tight timelines and a lot to manage and to balance. So we heard at our last subcommittee meeting what a good job staff are doing in terms of making the necessary adjustments to keep us on track and keep us on time. And I really just want to take the time to acknowledge that work, while also wishing staff and our mayor the best of luck with ongoing negotiations. We know and learned very clearly through our budgeting process the way that things are set up in terms of our own structural deficit and the ways that a lot of taxes and monies when we have special events do flow specifically into the coffers of our provincial and federal governments, and at great cost and great effort from us here at the municipal level. So we do hope that those conversations will be fruitful, and again, wanting to thank the staff for what is going to be an incredible event. And I also want to challenge my colleagues, because I've got an invite slip to a 5-on-5 soccer game for the 100 Day Out that's supposed to be a mayor's match. So I'm curious who else has signed up and who else is going to be getting on the so-called field here in front of, I believe, Nathan Phillips Square in another couple of weeks to celebrate the milestone that we've been working towards. And I would challenge my colleagues to sign up and let's see what we got. Thank you. Oh, and the information is not with me anymore because I passed off those details, but I'll send an email around to colleagues, and I'm sure the team will send a reminder for us all as well. Thank you. Those are my comments.
Thank you.
0.
Councillor Cole, maybe we can finish this item before we break. Councillor Cole.
Yes, I want to thank Deputy Mayor Morley for appreciating the incredible work that's been done for the last year behind the scenes by the FIFA Secretariat here.
Do you have a motion?
Oh, yes. No pineapple was my motion.
I want pineapple and anchovies.
Okay. Anyways, there's my motion. Anchovies, God help us. You're a real Neapolitan. That's why you come from Naples. That's why you like. Anyways, City Council Director General Manager FIFA World Cup to report June 10th. Economic development. An update on community activation plan. This is inspired by Deputy Mayor Malik. She wants to get this community activation plan going full steam. So that's the motion. Yeah, and getting back to Deputy Mayor Morley, I just want to thank her for acknowledging the incredible work. I mean, this is day in, day out work that's been going on quietly behind the scenes by our staff, city staff, the Secretariat staff, also our private sector partners that are working nonstop on this. And as we sit here, they're doing the construction of the additional seats at the BMO field. And also we're doing 10 very exciting micro soccer pitches across the city in designated areas where kids don't have soccer pitches. So those are underway with our Parks Department because we don't want to just make this a game that's focusing in on the incredible athletes that have come from all over the world to play in Toronto, but we want to get everybody involved in their own way is critically important because we want to get kids to be healthy, active, excited, and we want fans to be part of it. There's an incredible groundswell of interest in this. It's just marks on the diverse city that we have. We're going to get people. I can imagine the countries. We're going to get 6 games here, and I just imagine if we get the Serbians here, and oh boy, you haven't seen or the Argentinians. God, they travel the whole world for these games. We're going to get people coming from every corner of the world to Toronto, and they won't just stay for the one game. They may be here for the whole month. Anyways, but just getting to the dollars and cents of this, it's a bit disappointing that the province is basically getting into this game about, we said we were going to give you $97 million, but we're going to charge you for cleaning the Metrolinx washrooms, and we'll take that off the $97 million. And then we're going to charge you for health care, capacity surge, they call it. And then at one point they were going to charge us for the delays that FIFA was going to cause for the building of their spa. So they said, if the spa is delayed, we're going to take this off their $97 million. At least they backed off that. So we just want to get along with our provincial friends and remind them that most of the money, 95% of the money that is generated by this incredible economic boost is going to go to the province and the federal government. We don't get any HST. We don't get any of the taxes and the prices of their alcohol, their restaurants, everything. That all goes to them. Income taxes. We don't collect income tax. We don't collect corporate taxes. So there's going to be revenues flowing to them in the billions. And here we are. We're doing all the work here. Our staff, day in, day out, preparing this incredible activity. They're doing nothing. They're basically not doing the legwork that we're doing. The grunt work is being done behind the scenes by the City of Toronto staff and the Secretariat. And so please, I just wish the people of the province would grow up and understand that this is of great benefit to the province of Ontario, to the federal government, and everybody should be looking upon this as an experience of a lifetime. A positive experience where we can show the world what a great city, what a great country we have, what a great province we have. And so we hope we will turn the corner on this bit of a match with the province about who owns what, who pays for what, whatever. Let's all pay it together.
Councillor Cole, thank you. Isn't it? Deputy Mayor Malik to speak.
Thank you very much. I'd like to echo the thanks that have been shared by my colleagues. We are very excited in the City of Toronto to welcome the world. That has been our incredible theme, and welcome the world to Toronto for the FIFA World Cup in 2026. And we know, and it has been shared again, that it will bring a big economic impact to all 3 levels of government, including the projected $1.3 billion to the province of Ontario alone. And we know from hosting big events in this city and as a city council that we have to work together across governments to make sure that we deliver an event that is great, that we can be proud of as Torontonians and Ontarians and Canadians, and that provides benefit for all of us before the games, during the games, and after it for years to come. That is how we demonstrate that true Team Canada approach that we are committed to. And we will keep working together to make this process a success. And we know that includes staying at the table. It means that we have to come in eyes open in terms of those negotiations. And that includes each level of government contributing their fair share in the way that allows us to execute these games in the best way possible. I look forward to continuing to hear about how these negotiations are moving forward. I appreciate the motivation of the mayor's motion as well that will continue to drive things ahead as we put together the best possible games for all of us. And alongside that, to be able to see the important work that city staff have been doing with incredible partners to activate and engage communities in every single part of our city, again, before, during, and after the games, so that we can feel that world in a city as Torontonians as much as we are creating that for visitors. Thank you.
Thank you. All right, so let's put the mayor's motion on the screen and let's vote on it. There it is. All in favor? Carried. Thank you. Oh, yes, I forgot. I thought your motion was only let's get the pizza. Okay, Councillor Cole's motion. There it is on the screen. All in favor? Carried. Item is, well, no, this was here without a recommendation, right? Yeah. All right. So does anybody have a couple more fast items to release before we break at 6:30? Councillor Perks, the general government one, did you still want to hold up? Oh. What about Councillor Perks, a framework for building more affordable rental homes, PH 21.4? Who held that one down? No, you didn't do the by-election one. I was trying to get a quick. Did you want to do the by-election one? Oh, so we can't do that. Okay, Mayor, do you want to do? No, I know, I understand that, yeah. So, Mayor Chow, do you want to do the vacancy? It's CC 30.1, declaring the office. CC 30.1.
Thank you. I'm moving option B, the by-election, I want to first formally congratulate our former Deputy Mayor, Jennifer McAuliffe, who's now the MP for Ajax. Yes, yeah. And we know Jennifer McAuliffe had many years of service to Scarborough Rouge Park. And she stepped in and did enormous amount of work as the mayor earlier this term. And I know that all of you in council want to join me in wishing Jennifer the best in the House of Commons, even though we know that we will miss her very much. I'm recommending we decide to hold the by-election because I think it's important to respect local democracy and let the residents of Scarborough Rouge Park decide who represent them at City Hall. Had the federal election had it been a few months before our next municipal election, then I could see that we would do appointment. But given that this is not even end of May, it would be at least a year and a half almost. It would be difficult for us to say to the residents of Scarborough Rouge Park that we would just do an appointment rather than allowing them to democratically elect a city councillor from the area. So that's why I'm recommending option B. Oh, A? Oh, the by-election option. Sorry, whatever it is. B. Someone is confusing me. The by-election option. Do I hear C? C for child? Oh, okay. Right. Thank you.
We need to have a recorded vote because Councillor Candeval has a conflict. Recorded vote.
Councillor Moyes, please. Councillor Moyes, your vote, please. Councillor Sachs, how do you vote, please?
I vote for the by-election. Thank you.
The motion is adopted. The vote is 19-1.
Before we recess, Councillor Cheng has a motion she would like to introduce. Councillor Cheng, we'll put the motion on the screen. And then we're going to cut off all motions, no more new motion.
There you go.
Members of council may remember I brought a motion to save a beloved amenity, which is the stage at Willowdale Manor. And I've been informed there's a meeting to implement the removal without being consulted. So I just want to make sure that we've explored every other option because this is really well used by the seniors and They can't maintain good sight lines for their activities without that stage, and they can't stand for long hours because many of them use walkers. Yes.
On favor?
Festival del Manor.
I want a recorded vote.
What?
Okay, this is just to introduce. Recorded vote to introduce it.
Deputy Mayor Malik, please.
Councillor Cole, please.
Councillor Moyes and Mayor Chow, please. Lock it in. The motion to introduce a motion without notice does not carry. The vote is 17-3. The 18 vote threshold has not been achieved.
Deputy Mayor Malik, I have to warn you, like you just asked me earlier, doesn't look like we have 18 members. No, but 18 in favor because Deputy Mayor Malik wants to introduce a motion too. Huh? Okay. Anyway, okay, we'll recess to 7 o'clock.